everyone. I think we are getting ready to get started. I just want to give you everyone a minute just to get seated. Okay, well, if you found our last panel interesting, I do hope that you will join the Corp Fin Workshop later on this afternoon. You'll get a chance to hear from some of the additional members of the division staff. I will say that the workshop is generally one of my favorite panels of SEC Speak, so I'm just going to put a plug out there. I'm not being biased. It is actually a really great panel, so please think about joining some additional Corp Fin representatives this afternoon for the workshop. Okay, now I am extremely excited to introduce former acting chairman and current commissioner of the SEC, Mark Uyeda. Mark T. Uyeda was sworn into office as a commissioner on June 30th, 2022. He served as acting chairman of the agency from January through April 2025. Prior to becoming a commissioner, he served as an SEC detailee to both legislative and executive branches, most recently as Securities Counsel to Ranking Member Pat Toomey on the U.S. Senate Committee on Banking, Housing, and Urban Affairs. Commissioner Uyeda also served on detail as a policy advisor to senior leadership at the U.S. Department of the Treasury in 2017 to 2018, and at the U.S. Department of Labor in 2020. Commissioner Uyeda has been with the SEC since 2006, serving as senior advisor to Chairman Jay Clayton, counsel to Commissioners Michael Puervar and Paul S. Atkins, an assistant director and senior special counsel in the Division of Investment Management. Before joining the SEC, Commissioner Uyeda served as chief advisor to the California Corporations Commissioner, the state securities regulator, having been appointed by Governor Arnold Schwarzenegger in 2004. Please welcome Commissioner Uyeda.
Well, thank you, Cicely, for that introduction, and thank you as well for co-chairing this year's SEC Speaks conference with Sam Walden. For the last 4 months, both of you, like a number of others at the Commission, have been pulling double duty as both acting division directors in addition to your regular role as Deputy Director of the Disclosure Review Program for the Division of Corporation Finance and for Sam as Chief Counsel of the Division of Enforcement. The Commission, its staff, and the public have benefited from your leadership during this period, so thank you. My remarks today reflect my views as an individual commissioner and not necessarily the views of the full Commission or my fellow commissioners. But I think the acknowledgement of your efforts, I can safely say, it's on behalf of all my fellow commissioners. Well, what a difference a year makes. On January 20th, 2025, the Commission entered a new period in its 90-year history. And SEC Speaks comes at a perfect time to discuss some of those changes. Financial regulatory policy can be a bit like navigating over the oceans. You want a North Star to guide you to your desired direction. You need to be observant of the weather and the seas while avoiding rocky outcrops and other obstacles. And there may be other hazards as well. For the past 4 years, the SEC's enforcement bite has been lurking below the surface like a great white shark waiting for its next meal. Perhaps it's only fitting that this year marks the 50th anniversary of the movie Jaws. Staying on course is an important objective from which the Commission strayed mightily from its historical path. The SEC would use its power and authority to address climate change, diversity and inclusion, share repurchase policy, and financial products and services predicated on whether it favored or disfavored specific investments or practices. Since January, the Commission has undergone a major course correction. Instead of tackling various perceived social ills through financial regulatory tools, the SEC has returned to its core mission of regulating the capital markets. One specific instruction that has been made clear to our staff is that they have full authorization to meaningfully engage with market participants. The quality of regulation is vastly improved when the Commission engages with the public, especially when it comes to new technologies and services. Regulators should be constantly seeking out informational inputs, then reflexively rejecting them. Only by doing so can regulators identify areas of improvement, whether they relate to the strengthening of investment safeguards, constructing a practical crypto regulatory framework, improving access to private investments, or reducing barriers for companies pursuing IPOs. Some of the Commission's recent course corrections have included creating the Crypto Task Force, a cross-divisional effort led by Commissioner Hester Peirce to examine under what circumstances crypto should be considered securities, and in such situations, how the securities laws apply to such crypto. Dismissing enforcement actions in crypto cases, where generally the only alleged violation was the failure to register the offer and sale of a token with the Commission, particularly when the status of the token would be an open question being deliberated by the Crypto Task Force. Withdrawing Staff Accounting Bulletin number 121 with respect to accounting for crypto by public companies and replacing it with SAB 122. Organizing public roundtables to discuss what regulation of crypto should look like moving forward. Reiterating the application of long-standing statutory and regulatory provisions regarding eligibility to use Schedule 13G, and issuing Staff Legal Bulletin 14M on shareholder proposals, and rescinding the prior Staff Legal Bulletins 14L, which was a significant deviation from decades of administration of the Commission's shareholder proposal rule. Approximately 1 month ago, I took great pride in swearing in Paul Atkins as Chairman of the Commission, and am pleased to be working alongside him in refocusing our regulatory resources and tools on the SEC's mission. I look forward to Chairman Atkins' leadership over the next 4 years and moving away from a perceived politically motivated regulatory and policy drift that was outside of the Commission's jurisdiction and expertise. At times, the SEC appeared willing to use its government imprimatur to take on social issues far beyond the agency's scope. A critical and historically informed understanding of the SEC's mission is necessary to understand why the significant policy shifts of recent years have undercut and weakened the agency. These policy drifts were particularly destructive as they consumed significant staff resources. For example, the SEC's climate-related disclosure adopting release came in at 885 pages, longer than many major novels. Complex rules like climate disclosure require extensive economic research, and in this case, the Commission expended large amounts of time and staff resources on issues best left to other agencies, like the Environmental Protection Agency or the U.S. Department of Energy. The Commission adopted the final climate-related disclosure rule on March 6, 2024 by a 3-2 vote, from which Commissioner Peirce and I both dissented. The rule was challenged in litigation consolidated in the U.S. Court of Appeals for the Eighth Circuit. Full written briefs defending the rule were filed with the Eighth Circuit prior to the change in administrations, although oral argument has not yet occurred. On March 27, 2025, the Commission voted to end its defense of the rule and advised the Court of this decision. However, the final adopting release and the Commission's prior written briefs remain filed with the Court, and other interested parties are prepared to defend the rule in oral argument before the Court. Thus, in my view, though keep in mind, I am not a litigator by background, there is ample discussion and argument before the Court on whether the Commission had statutory authority to issue the rule, and if so, whether the Commission did so in compliance with the Administrative Procedure Act. Some have suggested that the Commission could simply move to rescind the climate-related disclosure rule, which I view as a diversionary tactic to avoid answering the key questions of statutory authority and compliance with the APA. As the Fifth Circuit observed in National Association of Manufacturers versus SEC with respect to the 2022 rescission of the committee's proxy voting advice rule issued under Chairman Jay Clayton, quote, an administrative agency may alter or rescind its policies, including when a new administration enters office, unquote. However, in quoting the U.S. Supreme Court's opinion in FCC versus Fox television stations, the Fifth Circuit stated that when, quote, a new policy rests upon factual findings that contradict those which underlay its prior policy, unquote, a more detailed explanation is required, and that a failure to explain its decision to disregard facts that underlay the prior policy is arbitrary and capricious. The Fifth Circuit then vacated the Commission's 2022 action, one of a number of rulemakings during the last 4 years that was struck down by the courts. And don't worry, we still have others remain outstanding. For the Commission to rescind the climate-related disclosure rule and address the countless factual findings discussed throughout that 885-page release would place a significant strain on the Commission's resources. This effort would be a difficult lift, and it would potentially take away staff resources needing to advance a regulatory regime with respect to crypto, or capital formation, or market structure, or any of these other topics. Further, any such rescission would further likely be challenged in the courts. If such rescission is struck down, then the question of whether the original climate-related disclosure rule was lawfully adopted would escape judicial review altogether. Despite the adopting release's claims to the contrary, I do not believe that the climate-related disclosure rule was ever about financial materiality. Because if it had, an impartial observer would have recognized that the concept of financial materiality, including climate change, is already well embedded in the SEC's disclosure obligation framework, whether in the description of the business, risk factor disclosure, management's discussion and analysis, financial statements, and notes to the financial statements. The Commission twisted itself into knots to conclude that a 1% climate risk effect was quantitatively material. In my view, the climate-related disclosure rule was more about politics and social change than financial regulation. At any time, Congress could have enacted legislation to address greenhouse gas emissions and climate change, but it chose not to do so. If Congress, which is politically accountable to the voters, failed to take action, then I see little reason for unelected financial regulators without expertise in climate policy to fill that gap. If the Commission had studied the historical past, it would have realized that social change through financial disclosure regulation does not usually work. One need only look at Section 1502 of the Dodd-Frank Act, which directed the Commission to issue rules requiring certain companies to disclose their use of conflict minerals that originate out of the Democratic Republic of the Congo or adjoining countries. The term conflict minerals includes gold, tantalum, tin, and tungsten. Granted, this obligation was a directive set forth in legislation, but the abject failure of this provision should give pause to further attempts to use the SEC's disclosure regime to achieve social or political goals. Now, you don't need to take my word with respect to the failure of the conflict minerals to achieve their intended objective. You can look to the U.S. Government Accountability Office. The GAO reported in 2024 that peace and security in the Democratic Republic of Congo had not improved with the SEC disclosure rule. The GAO concluded that the SEC rules, quote, had not reduced violence in the Democratic Republic of the Congo and likely had no effect in adjoining countries, unquote. And then further, the GAO, in fact, reported that, quote, the rule was associated with a spread of violence, unquote. The cost of this rule has also created significant regulatory compliance costs for U.S. public companies without clear corresponding benefits. By discouraging public companies from sourcing tin, tungsten, and tantalum from the DRC, the policy has acted as a de facto boycott on such mineral purchases. This result is unfortunate because tin, tungsten, and tantalum have been each classified by the U.S. Geological Survey on a list of mineral commodities critical to the U.S. economy and our national security. Tantalum is used in electronic components, mostly capacitors and in superalloys. Tin is used as a protective coating for steel and in alloys. Tungsten is primarily used to make wear-resistant metals. Not only does this rule take away the DRC as a potential source of these critical minerals, it limits the ability of American companies that seek to acquire such minerals from improving economic conditions in that region of Africa. In so doing, the SEC rules have had the unfortunate effect of ceding U.S. influence in that portion of the world to geostrategic powers that may have less respect for human rights and dignity. Importantly, this SEC rule hurts American companies from competing in a global market. It is far past time to reevaluate such obligations with a view to determining whether such disclosure regulations should remain in effect. Key provisions of the underlying statute, Dodd-Frank, provide that it terminates on the date on which the President makes certain determinations. Congress can also repeal this statutory provision. In any event, the SEC should cease using financial disclosure regulations to bring about human rights changes in Africa to the extent permitted by law. Now, one argument raised about the need for non-financial, environmental, social, and governance, or ESG disclosure is that shareholders, or persons acting on behalf of beneficial owners, such as asset managers, require such information for proxy voting purposes and for stewardship engagement activities. As the beneficial ownership levels held by asset managers has significantly increased in the past couple of decades, market participants should be aware of the long-standing rules regarding disclosure of beneficial ownership. Congress created this reporting regime in 1968 to provide information to the public and the subject company about accumulation of its equity securities in the hands of persons who would then have the potential to change or influence control of the issuer. Initially, all persons beneficially owning more than 5% of a public company were required to report their ownership on a Schedule 13D. In 1977, pursuant to its rulemaking authority, the SEC began permitting certain categories of institutional investors to report their ownership on a shorter form. This form, now called Schedule 13D, requires less disclosure about the beneficial owner, is less costly to prepare, does not need to be initially filed as quickly, and does not need to be updated as frequently when compared to Schedule 13D. Asset managers can report on Schedule 13D if they have acquired securities in the ordinary course of their business and they have not acquired and do not hold the securities with the, quote, purpose or effect of changing or influencing the control of the issuer, unquote, of the securities. With respect to whether an asset manager's engagement has the purpose of changing or influencing control of the company, Rule 12b-2 under the Securities Exchange Act provides a definition. And Rule 12b-2 defines control as the power to direct or cause the direction of the management and policies of a company. A company's board, particularly the members on a committee overseeing ESG matters, may have the power to direct or cause the direction of the company's ESG practices. Thus, can an asset manager's stewardship and engagement activities, with the implicit threat of voting against a director standing for re-election, be described as having the purpose or effect of changing or influencing control of the company? Earlier this year, the SEC staff addressed this question by issuing Compliance and Disclosure Interpretation 103.12, which stated that a shareholder who discusses with management its views on a particular topic and how its views may inform its voting decision without more would not be disqualified from reporting on Schedule 13G. A shareholder who goes beyond such a discussion, however, and exerts pressure on management to implement specific measures or changes to a policy, may be influencing control over the issuer. Thus, Schedule 13G may be unavailable to a shareholder who recommends that the issuer undertake specific actions on a social, environmental, or political policy, and as a means of pressuring the issuer to adopt the recommendation, explicitly or implicitly conditions its support on one or more of the issuer's director nominees at the next director election on the issuer's adoption of its recommendation. The wording of the CDI, in fact, broadens the scope, in my view, of permissible activities while still remaining eligible for Schedule 13G, which is premised on not influencing control of the company. Influencing is a term that is not defined under the Securities Exchange Act. But if you were to look at a common dictionary definition, one meaning is the act or power of producing an effect without apparent exertion of force or direct exercise of command. By requiring that a shareholder needs to exert pressure on management, the CDI indicates that there needs to be something more than the mere planting of an idea with management in order to lose Schedule 13G eligibility. This result reflects a common sense interpretation of long-standing rules. If you are pressuring the board to undertake certain actions relating to the management or policies of an issuer, whether ESG or otherwise, coupled with voting threats, such actions are covered by existing rules and should be treated as such. As with the unfounded concern that Regulation FD would cease all communications between companies and shareholders, I am confident that asset managers and other institutional investors will be able to navigate the parameters of the existing and applicable Exchange Act rules in order to have appropriate levels of engagement with boards and public companies without losing eligibility to file on Schedule 13G. And if an asset manager chooses to exert pressure, they can do so, but they must provide the disclosure and transparency surrounding such conversations as required by Schedule 13D. Finally, I'd like to discuss the future of administrative law judges at the SEC. For background, the Commission may institute administrative enforcement proceedings seeking civil penalties, cease and desist orders, and other remedies. The expanded use of administrative proceedings by the SEC after the enactment of the Dodd-Frank Act in 2010 led to increased criticisms of this choice in venue. Such criticisms in part laid the groundwork for litigation that resulted in the Supreme Court's opinion in SEC versus Jarchese. Earlier this year, a member of the staff, Jamie Marinero, who's an associate director in our Fort Worth regional office, and I published a law review article exploring potential new paths forward, whereby the Commission can use administrative proceedings in a manner that is consistent with the protections provided by the U.S. Constitution. One concern was that under the prior system of administrative proceedings, even when defendants so-called win before an ALJ, they can easily lose upon SEC Commission review. The perceived unfairness and the limited efforts of the Commission to address such failings contributed to setting the stage for a full-blown constitutional challenge on the Commission's administrative proceedings, culminating in the Jarchese decision. ALJs can provide an important and constructive role at the SEC, providing benefits to market participants and investors through a timely, efficient, and thoughtful process. Due to the repeated nature of the types of cases brought before ALJs, they can develop subject matter expertise to adjudications as compared to federal district court judges, who often review a very wide variety of cases. We envision a new direction for administrative adjudication. It should be codified in the SEC internal procedures that ALJs operate under the direction of the Commission as a whole. Because the Division of Enforcement, the largest SEC division, reports directly to the chairman, responsibility for the oversight of ALJs should be given to a non-chair commissioner. One approach would be to randomly assign one non-chair commissioner to oversee the ALJ in a specific administrative proceeding. Another key suggestion in the article is for the Commission to consider selecting the forum based on remedies. Some remedies are more appropriate for adjudication by the agency, whereas other remedies raise constitutional concerns on whether the defendant should have the right to an independent adjudicator. Action seeking non-monetary remedies, such as the issuance of a cease and desist order, orders requiring an accounting, and orders to prohibit a person associated with a registered entity from serving as an officer or director, are appropriately handled in administrative proceedings. While there are real-life effects from being subject to such actions, particularly with respect to professional reputation, they do not have the attribute of the executive branch deciding to seize property of persons without the oversight of an independent adjudicator. In each case, the defendant, if unsatisfied with the administrative proceeding, will have the ability to appeal to an Article III court. For similar reasons, the Commission should also use administrative proceedings to issue orders denying the registration of a person as a regulated entity, censuring, placing limitations on the activities, functions, or operations of a regulated entity, and temporary and permanent suspensions, as well as to suspend or revoke the registration of a security. Where civil penalties are permitted in administrative proceedings by Cherkasy, the SEC should limit the amount sought to avoid the appearance that the SEC is stacking the odds in its favor. The SEC should not seek claims for disgorgement in civil penalties in an amount that exceeds a single Tier 1 violation. While such a ceiling is a line drawing exercise, limiting monetary remedies would potentially ameliorate the concerns raised by critics of administrative proceedings. Finally, any administrative proceeding before the Commission should potentially be subject to de novo review in U.S. district courts, rather than the current practice of being reviewed directly by the U.S. Courts of Appeal, which utilize a substantial evidence standard that is highly deferential to agency findings. As I look forward to working alongside Chairman Atkins and my fellow commissioners, I am confident that the years ahead will bring regulatory improvements and proactive efforts to address new and emerging issues, all underpinned by leveraging the talent of the SEC staff. Specifically, I'm heartened by the move away from regulation by enforcement. This is especially true when market participants make efforts to engage with us, but such efforts are rebuffed. Returning to JAWS, market participants should not feel like defensive swimmers in the ocean with a foreboding sound track by John Williams playing in the background. The Commission should undertake efforts to provide assurances that regulation by enforcement will not be a tool used for future policymaking. As you may recall, 3 years later after JAWS came out, JAWS 2 went back to theaters with a tagline, "Just when you thought it was safe to go back into the water." The SEC's resources and policies should be deployed in coherent ways that minimize the risk of policy drift and overreach that has occurred in recent years. A steady and predictable policy-making course in accordance with the Commission's historical norms benefit all market participants and enhance the agency's reputation and credibility. Thank you to the co-chairs, the organizers, panelists, and all of you attending here in person and online. It is your thoughtful participation and engagement with these topics that makes this conference a success. So thank you again, and I hope you enjoy the rest of the conference.
Good morning. I think we are about to resume. I'll give everybody just a few seconds. Okay, so I am thrilled to be able to welcome another of our current commissioners to the stage today, Hester M. Peirce. Commissioner Peirce was appointed by President Trump and was sworn in on January 11th, 2018. She was designated as the leader of the SEC's Crypto Task Force on February 4th, 2025. Prior to joining the SEC, Commissioner Peirce conducted research on the regulation of financial markets at the Mercatus Center at George Mason University. She was a senior counsel on the U.S. Senate Committee on Banking, Housing, and Urban Affairs, where she advised Ranking Member Richard Shelby and other members of the Committee on Securities Issues. Commissioner Peirce served as a counsel to then Commissioner Paul S. Atkins. She also worked as a staff attorney in the SEC's Division of Investment Management. Thank you so much for joining us, Commissioner Peirce.
Thank you, Cicely. It's been wonderful working with you as acting, in your capacity as acting director of the Division of Corporation Finance. It's wonderful that people like you step up, and I think the years of experience that you bring to that position have already served us very well, so thank you very much. It's wonderful to be with all of you today, and welcome to SEC Speaks. I have to give you the disclaimer, of course, which is that my views are my own as a commissioner, not necessarily those of the SEC or my fellow commissioners. Exactly 1 month ago, April 19th, 2025, marked the 250th anniversary of the start of the American Revolution. Crouching behind a stone wall at the Battle of Lexington and Concord was Samuel Whittemore, an octogenarian farmer who killed 3 British soldiers before being, as recorded on a memorial to him, shot, bayoneted, beaten, and left for dead. He defied the odds by living almost 2 more decades. Among the heirlooms that stayed in the family until my great-uncle gave it to a historical society was a teacup with a broken handle that Mr. Whittemore had buried in the backyard when the detested Tea Act was in place. It was his protest against it. He pledged never to drink tea until that act was gone. That little act of rebellion, which foreshadowed his much bigger act of rebellion, helped to lay the groundwork for a nation that uniquely values human liberty, celebrates the independent spirit, and welcomes dissenting voices. Mine has been one of those voices over the past several years, many of my dissents related to the Commission's approach to regulating crypto assets, an entirely new class of digitally native assets, as well as on-chain versions of currencies, commodities, collectibles, and securities enabled by a shared database architecture for recording ownership of digital property. Having emerged from the crypto dissent years, I'm glad to be able to speak to you today as the head of the Commission's Crypto Task Force about a rational and coherent approach and a new paradigm at the SEC. My guess is that some of you in the audience are not very interested in crypto. The SEC's remit is broad, and it's clear from the many topics on the agenda at SEC Speaks that there are many other things for us to work on. Important work lies ahead of us in areas such as expanding access to capital, reinvigorating our public markets, regrounding disclosure and materiality, fostering participation by more Americans in the capital markets, carefully implementing rules such as Treasury clearing, streamlining and modernizing the Commission's hefty rulebook, rethinking the consolidated audit trail, and the GAG rule, fostering innovation and competition in asset management, permitting the use of modern communications methods, and ensuring continued market resilience. Crypto is not the most critical issue for the Commission, but it is important, even for those of you who see no value, or even worse, in anything bearing the crypto label. Why does it matter? First, the Commission's approach to crypto in recent years has evaded sound regulatory practice and must be corrected as a matter of institutional integrity. The Commission has relied on enforcement actions to tell people how it views the application of securities laws to crypto and as a substitute for notice and comment rulemaking. It has provided little useful guidance about how the securities laws apply under the facts and circumstances of crypto. Second, although much of crypto to date has stood outside the traditional financial markets, change is coming fast, both because traditional financial intermediaries are developing and engaging with crypto assets, and market participants are experimenting with tokenization of traditional securities. Finally, providing crypto clarity will allow the Commission to focus on the aforementioned agenda with the many other things that I just mentioned that are on our agenda. The task force, which then Acting Chairman Uyeda established at the start of his tenure and Chairman Atkins has continued, has been around now for about 4 months. In that time, we've hosted 4 roundtables and planned one more for next month. We've received more than 100 written submissions that respond to an extensive request for comment. And we've held over 100 meetings with industry participants and other members of the public with a diversity of views on a wide range of topics. Staff across the Commission has issued new crypto guidance, including on crypto mining and broker-dealer custody of customer crypto assets. I support the issuance of further guidance to identify activities that are not covered by the securities laws, including guidance, for example, on direct participation in proof of stake and delegated proof of stake systems, and the technical nature of services that assist people seeking to participate in these consensus mechanisms. Staff also has rescinded guidance that has inhibited regulated entities from engaging in crypto assets. In addition, the task force, along with staff across the Commission, has provided technical assistance in connection with congressional efforts to develop crypto legislation, and we've worked together with other agencies to fulfill the President's mandates with respect to crypto. The most popular topic of discussion by far in written input and in the meetings that we've had is securities status. And my short answer to the question, are crypto assets securities, is that most currently existing crypto assets in the market are not. My supplemental answer is that economic realities matter, and non-security crypto assets may be distributed as part of an investment contract, which is a type of security. The federal securities laws apply broadly to situations in which a person takes another person's money in exchange for a promise to generate value for the person who handed the money over. As defined in the statute, the term security includes a variety of enumerated instruments, such as stock, bonds, and notes, that all have a key feature in common. All are instruments that in our commercial world fall within the ordinary concept of a security. Securities ordinarily represent rights or an interest in a business entity or other promisor. For example, a share of a common stock represents certain voting and economic rights in the business entity that issued it, and a note represents the right to receive payments from a promisor. The intrinsic value of these instruments depends on the financial prospects of the associated business entity or promisor. The drafters of the federal securities laws did not intend the term security to include instruments that do not represent economic rights or an interest in that's typical of an ordinary security with respect to a promisor. So despite the broad application of the definition of security in the federal securities laws, some financial instruments fall outside of its reach, including some that are sold by fraudsters. Financial instruments outside the Commission's reach may be within the scope, however, for another regulator. The line demarcating transactions and instruments covered by the securities laws from those that are not is still hazy, even after the SEC and courts have engaged for decades in following the congressional directive to decide which of the myriad financial transactions in our society come within the coverage of the statutes. In assessing whether an instrument fits within the securities regime, the Supreme Court has opined that the substance of the instrument is more important than the form. An instrument that's called a stock but does not convey the rights typical of a security will not necessarily come within the scope of the federal securities laws. Similarly, an instrument that is marketed as a good but conveys rights typical of a security will be regulated as one. Considering the economic realities is not necessary for traditional stock, which sits plainly within the statutory definition, but is for unusual instruments that are not easily characterized as securities. The Supreme Court has recognized that this approach, which is founded on economic reality rather than a set of per se rules, may lead to confusion about whether the securities laws apply in some contexts. However, this approach permits the SEC and courts sufficient flexibility to ensure that those who market investments are not able to escape the coverage of the Securities Act by creating new instruments that would not be covered by a more determinate definition. The court suggested that Congress may have, and this is a quote from the court, at the expense of the goal of clarity, overvalued the goal of avoiding manipulation by the clever and dishonest. The Supreme Court's acknowledgement of ambiguity accords with the crypto industry's confusion on the subject and underscores why the Commission should have done its job of providing clarity on security status specifically for crypto asset offerings. So deep was the confusion that many crypto entrepreneurs left the United States or simply excluded the American public from participating in the projects they were building. Yes, the Commission did issue the Dow report in 2017 to confirm that issuers of distributed ledger or blockchain technology-based securities must register offers and sales of such securities unless a valid exemption applies. But facts in the Dow report were distinguishable from many other crypto asset offerings. Yes, the Commission staff did issue guidance, but that guidance was so complicated that nobody could follow it. I support staff's withdrawal of that guidance, lest anyone else should still consider incurring the fees of a lawyer to try to help her understand what it means. And yes, the Commission followed the Dow report with many enforcement actions against issues of crypto assets and against intermediaries dealing with crypto, but many of these actions were premised on violating registration provisions that simply were not workable for the types of activities at issue. The Commission has since settled or dropped many of these cases so that our policy divisions have the room they need to develop a sensible path forward. The Commission's approach to crypto did not work. It neither stopped many of the bad actors, nor did it provide clarity for the ones trying to do the right thing. The fault lies with the Commission, not the hardworking staff who sought to do the best they could under the direction the Commission gave them. The Commission, consistent with its investor protection mission, will continue to vigorously pursue securities fraud, including cases that involve crypto. But the Commission's statutory authority does not cover every kind of fraud that's out there. Although much later than it should have, the Commission now has begun the work of providing clarity. Guiding this work is a recognition that whether something resides on-chain does not change the substance of what it is for purposes of analyzing its security status. Staff already has started to provide guidance, and as Chairman Atkins mentioned at the tokenization roundtable, we're moving expeditiously to codify through our thinking through notice and comment rulemaking. Tokenization of real-world assets is in its infancy, so most crypto assets in existence today are not instruments enumerated in the definition of security. Common crypto assets are methods of payment, stores of value, access to computing power, artwork, rewards points, video game items, tickets, memberships, and memes. The Commission staff recently clarified that in its view, certain meme coins and stable coins are not securities because, among other things, they do not convey economic rights in a business entity or other promisor. There are blockchain-based versions of things that exist in the off-chain world. A meme coin is a digitally native type of collectible that derives its value from an associated meme or popular cultural reference. A stable coin is a digitally native payment instrument that is designed to maintain a stable value similar to an open-loop gift card. A permanent exclusion from the term security for crypto assets that meet certain enumerated criteria, such as collectibles or stable coins, could be helpful. In addition, crypto assets that don't have indicia of external control or dependency could also be excluded through a Commission action. Other non-security crypto assets convey to their holder technical powers with respect to a functioning, decentralized, public, and permissionless blockchain network or application. Users must own the protocol's native crypto asset to interact with it, and users freely choose to participate in these protocols and their features and functionalities and abide by their rules, often in return for crypto asset rewards that are programmatically generated by or derived from the use of the network or application. Developers whose compensation comes in the form of crypto assets want to build for networks that are popular, that people are actually using, because the high demand for the crypto assets is then reflected in the crypto asset price on secondary markets. An economic mechanism rewards voluntary cooperation and coordination among a distributed set of participants. This powerful new flywheel effect emerges whereby users are encouraged to participate in a protocol based on the design of its economic mechanism, and developers are encouraged to build for networks and applications that successfully attract users. No central party oversees participation or distributes rewards to participants. As a result, the value of these crypto assets is intrinsically linked to the programmatic functioning of an associated network or application rather than to any business entity or promisor. Many non-fungible tokens also are not securities, including NFTs designed to compensate their creators over time. The NFTs are powered by smart contracts, which can be programmed to transmit automatically a portion of the sale price of an NFT to the creator of the artwork as a royalty each time that NFT is resold. Just as a streaming platform has figured out ways to pay royalties to creators of songs or videos, so NFTs can enable artists who once just sold their work and that was it. Now it enables them to be able to continue to benefit from the appreciation of its value after the initial sale. This creator royalty feature of certain NFTs does not provide to the NFT owner rights or an interest in any business enterprise or the kinds of profits that are traditionally associated with securities. Crypto assets that do not represent economic rights or an interest in a business entity or other promisor, including an ownership or debt interest, revenue share, or entitlement to any interest or dividend payment, and are solely for use or consumption, should not be subject to the federal securities laws. This analysis does not change even if purchasers are speculating on an increase in the future value of the crypto asset. The more difficult security status questions arise when distributions of non-security crypto assets occur early in the development of an associated network or application, before the assets are functional and while the network or application is centralized. It's common practice today for a software development company, foundation, or related entity, I'm going to call these an issuer for purposes of what we're discussing. It's common for them to distribute a crypto asset along with a promise of future functionality and decentralization before the crypto asset is functional. So they're making these promises before the functionality happens or before and while the network or application is still under the control of a central party. The issuer makes these promises either directly to purchasers or more broadly to the public. The purchasers are often venture capital funds or other institutional investors. The relevant promised efforts are the undeniably significant ones, those essential managerial efforts which affect the failure or success of the enterprise. These promises shape the purchaser's expectations. Rather than buying a functional crypto asset, the purchaser is buying the crypto asset along with the issuer's promise to make it functional. This promise arguably runs through these purchases as the thread on which everyone's beads are strung. If the issuer were to disappear and cease performing those essential managerial efforts, everybody's beads would fall to the floor because the crypto asset's value is intrinsically linked to the promisor's efforts. These transactions start to look a lot like other transactions courts have held to be covered by the securities laws. Because the crypto assets are sold with promises to develop the network or application and deliver functionality, the crypto assets may be subject to a contract transaction or scheme that qualifies as an investment contract, a type of security under the federal securities laws. As everyone knows, the Supreme Court defined this term in the Howey case as a contract transaction or scheme whereby a person invests his money in a common enterprise and is led to expect profits solely from the efforts of the promoter or a third party. The Supreme Court intended to capture uncommon and irregular instruments that have essential attributes that run through all of the court's decisions defining a security. As the court explained in Foreman, the touchstone is the presence of an investment in a common venture premised on a reasonable expectation of profits to be derived from the entrepreneurial or managerial efforts of others. Subsequent courts have elaborated on the definition, and the wide diversity of judicial interpretations has resulted in significant uncertainty for crypto market participants as well as participants in other markets. Additional clarity from Congress on the scope of the term investment contract could be helpful in crypto markets and more broadly. The biggest challenge for crypto market participants, including issuers, crypto trading venues, and early stage purchasers, is determining when a non-security crypto asset subject to an investment contract separates from that investment contract. Some commentators have suggested that it separates immediately, and subsequent sales of the crypto asset are not subject to any of the investor protections of the federal securities laws. Others opine that the investment contract travels with the crypto asset for some time until the associated network or application is sufficiently decentralized or no longer controlled by a central party, or the issuer has otherwise fulfilled his promise to the purchasers of the investment contract. Distinguishing the crypto asset from the investment contract allows the asset to trade freely outside of the securities law. This delinking fosters the flywheel effect that I discussed earlier. A wide range of purchasers can buy the crypto asset easily and thus can use it in a network or application, and developers getting paid in the crypto asset can sell it easily. At the same time, treating all secondary sales of crypto assets as being free of the investment contract runs the risk of facilitating bad behavior, the dumping of crypto assets bought as part of an investment contract on retail investors while the crypto asset lacks any functionality and is associated with a centralized network or application, and thus subject to information asymmetry concerns. If the initial holders are out of the picture, because they've sold their crypto assets, the investment contract is unenforceable and the issuer can dump its crypto assets to and walk away, wealthy and unaccountable for completing the project. Companies looking at capital raising options might even be tempted to use such crypto asset sales instead of other capital raising methods. Promise to build a network or functional product, do a crypto asset pre-sale to venture capitalists, stop developing the network or product once they've sold out to retail, and plow the money into the building the actual business. Market participants could solve this problem. They could, for example, and they don't need a government solution to do it. They could, for example, place lockups on their own and initial purchasers' crypto assets to demonstrate good faith to purchasers. Alternatively or additionally, they could embed into the crypto assets specific performance deliverables and enforcement mechanisms using smart contracts. The investment contract would intentionally travel with the crypto asset until it was extinguished by performance of the specified deliverables. Although such a market-driven solution could reduce the need for government intervention, the task force is considering how to establish clear rules of the road for crypto asset transactions. To enable crypto projects to move forward now, while we await legislation and the courts continue to opine on the question, the Commission could provide both a tailored registration regime for securities offerings involving crypto assets and an appropriately conditioned safe harbor from securities registration for transactions involving crypto assets that are or might be subject to an investment contract. A time-limited conditional safe harbor would allow crypto assets subject to an investment contract to be transacted in without being subject to securities registration requirements for a period of time, provided that the issuer satisfies certain disclosure and investor protection requirements. Such a safe harbor would afford issuers time to progressively deliver functionality for a crypto asset or decentralize a network or application while providing material information to investors about the crypto asset, the issuer, and its promised essential managerial efforts. An alternative would be to regulate offers and sales of pre-functional and pre-decentralized crypto assets by the issuer, its affiliates, underwriters, and large holders as securities transactions. but exempt from regulations subsequent sales of these crypto assets on secondary markets. Additionally, the Commission might establish an exemption framework so that certain distributions of crypto assets as part of an airdrop are not deemed to be offers or sales subject to registration. The Commission, acknowledging that some courts have found secondary sales of crypto assets to be securities transactions, could provide clarity about when that link between the investment contract and the crypto asset severs, rather than leave this question entirely up to courts' ex post assessments. Achieving crypto asset functionality as described in the issuer's public statements may be one way to break that link. Another way may be for control over the network or application to become dispersed so that the issuer is no longer providing those essential managerial efforts, and the information asymmetries that animated Congress in crafting the securities laws no longer exist. If the network or application would keep running if the issuer disappeared, it's hard to argue that the issuer is providing essential managerial efforts. Some issuers may seek to decentralize a network or application too quickly to the detriment of the long-term success of the project, but issuers that commit to a progressive decentralization roadmap designed to mitigate against the disclosed risks of exploits, bugs, and governance failures are more likely to attract investors. Pragmatically speaking, the investment contract also might terminate if the issuer publicly discloses that it's just not going to do anything else. In this case, it would not be reasonable for subsequent purchasers of the crypto asset to expect profits based on those issuers' managerial efforts, but given that not fulfilling one's promises to securities purchasers is bad conduct that securities laws address, the issuer might have to answer to the purchasers, to the initial purchasers of the investment contract. Upon conclusion or termination of the investment contract, the crypto asset would no longer be tethered to an investment contract. Regardless of how the SEC ultimately draws the lines, even if a broad swath of the crypto assets trading in secondary markets today were initially offered and sold subject to an investment contract, they clearly are no longer bought and sold in securities transactions. Many of these crypto assets are functional with respect to others. Purchasers no longer reasonably expect any business entity or promisor to perform essential managerial efforts. In other words, the crypto assets, the value of the crypto asset is intrinsically linked to something other than rights or an interest with respect to a business entity or promisor. The assets are not themselves securities, nor are they any longer part of an investment contract, even if they once were. Forthcoming rulemaking by the Commission and legislation from Congress should continue to provide clarity about which crypto assets are securities. But as highlighted in the discussion at last week's roundtable on tokenization, many crypto assets are likely to fall in tokenized form, are still securities. Among other market developments I anticipate is an interest in trading tokenized securities alongside non-security crypto assets. Nothing in the federal securities laws or regulation currently prohibits broker-dealers from offering trading in securities alongside non-securities, but further clarification from the Commission staff on this topic may be helpful to market participants. Additional authority from Congress to regulate both sides of these pairs trades could be helpful. I don't know whether blockchain will revolutionize the way our securities market operates, as some people suggest, but we stand ready to work with the public, as we have done in the past, to incorporate new technologies in our markets. 250 years after Samuel Whittemore made his stand behind the stone wall, I stand here today grateful for the freedom for which he fought. I hope that all of us can look up from the minutiae of the securities laws, which I apologize this speech was full of, and just take a moment to celebrate a quarter of a millennium fight for freedom. Even if this seemingly abstruse project of regulating the securities market, even if it seems sometimes that it is seemingly abstruse, we share this, all of us in the room, and it is one of the contributions that we make to the strength of our nation and the freedom of its people to pursue their dreams. Thank you to those of you who are on the SEC staff, who were previously on the SEC staff, who hope to join the SEC staff, who never want to join the SEC staff but want to serve from the outside. All of your voices are important in making sure that the SEC does its job well so that our capital markets of this great nation continue to thrive. Thank you so much. I'm sorry for going so long.
Thank you so much for that, Commissioner Peirce. I always gain a little bit of history from your remarks, so I appreciate that. Okay, now we will be turning things over to our senior staff of our Division of Economic and Risk Analysis. Dr. Robert Fisher will be leading the panel. He is the Acting Director of the Division of Economic and Risk Analysis. He is both an economist and an attorney. Is that me? Okay. Before joining the SEC, Dr. Fisher's legal career included stints at several prominent law firms as well as a consulting firm. He clerked for Judge Stephen F. Williams at the U.S. Court of Appeals in the D.C. Circuit. He also has extensive academic experience. Before starting this panel, I ask that you please consider the comments of this session's panelist. And Rob, I'll turn it over to you. Thank you.
Thank you. Good morning, and welcome to the Division of Economic and Risk Analysis panel. On behalf of myself and all of the DERA's panelists, I want to give our standard disclaimer. All of our remarks today are in the staff members' official capacities as members of the Division of Economic and Risk Analysis, but do not necessarily reflect the views of the Commission, the Commissioners, or other members of the staff. I'm pleased to introduce DERA's panel today. Lyndon Orton, Assistant Director in DERA's Office of Corporate Finance, will talk about counts of reporting issuers and public firms. Giulio Girardi, a Senior Economist in DERA's Office of Risk Assessment, will talk about hedge fund liquidity management. Chia Becker, DERA's Deputy Director, will talk about distributions. And Julie Marlowe, Assistant Director in DERA's Office of Structured Disclosures, will talk about structured disclosures. Before I turn it over to my colleagues, I wanted to give a very brief overview of what DERA does. Let's see if I can manage to get to the next slide. There we go. All right. DERA has four major mission areas. One, DERA provides statutorily required analyses of the Commission's proposed and final rules, costs, benefits, and effects on efficiency, competition, and capital formation. Two, DERA provides analyses that guide Commission decisions in the context of enforcement cases. Three, DERA staff analyzes capital market risks. And four, DERA provides the public with data, including statistics, data sets, and analysis. Today, I just want to talk very briefly about this fourth area, the information and data that we provide to the public via the SEC's website. All right. So DERA provides statistics and analysis of various market issues on our website. Here are a few of the topics we have just very recently addressed. I encourage you to explore the data and information available on the Commission's website. You will find that there's a lot there. As a highlight, our next speaker, Lyndon Orton, will go into more detail on one of the white papers recently published on our website, Information on Reporting Issuers and Public Firms. As I mentioned earlier, we also provide an array of data visualizations and other information on the website, most of which are interactive so that you can see the information that is of most interest to you. Again, I encourage you to check it out. These visualizations help to explain the market statistics in a different way, and we encourage you to explore them. Data sets. Lastly, DERA also provides data sets to the public for those who would like to do their own analyses. A lot of times in putting together these data sets, there's a fair bit of work in cleaning them up, and so it ends up being quite a public good for academia to go look and work with a consistent and well-defined set of data. These data sets, which are based on publicly filed information, are periodically updated. All right, so that's just a quick overview of the information available on sec.gov, but I do hope that you will go to our website to see what is available. Now I will turn it over to Lyndon Orton, who will be presenting on statistics relating to reporting issuers and public firms. Thank you.
Thanks, Rob. So these statistics are based on a DERA research paper that, as mentioned, can be found on DERA's website. This research paper had two primary purposes. The first purpose was to simply publish statistics regarding reporting issuers. And by reporting issuers, I'm referring to issuers of securities with a duty to register under the 1933 Securities Act and make regular periodic disclosure pursuant to the 1934 Exchange Act. The second purpose was to highlight some nuances around discussions of public companies. When I say public company, we all have a pretty good idea of what I'm talking about, and it's easy to assume that we're talking about the exact same group of firms. And for the most part, we are. I doubt anyone here would disagree that Walmart or Apple are public companies. There are some entities, however, that certain individuals would consider to be public companies, while others would not. The reality is that there is no legal or universally accepted definition for public company, and so it's important that we're careful and precise in what we're talking about when in our discussions of public companies. So let's start with the reporting issuers. So there are a total of 8,351 reporting issuers that issued an annual report in 2023. 7,243 of these issuers filed a Form 10-K, which is about 87%. 953 of the reporting issuers filed a Form 20-F, and 155 of the reporting issuers filed a Form 40-F. Regarding filer status, 2,461 reporting issuers were large accelerated filers. 942 issuers were accelerated filers. 4,789 were non-accelerated filers. And the remaining 159 issuers did not report their filer status in their annual report. I will note that 155 of these issuers were the ones that filed the Form 20-F, and they're not required to report filer status, and the other 4 were asset-backed securities. 3,339 of the issuers were smaller reporting companies, and 2,070 of the reporting issuers were emerging growth companies. Some additional statistics. There were 2,381 well-known seasoned issuers. There were 768 asset-backed securities, 118 business development companies, and 570 shell companies. Again, this is all for 2023. So now we move on to our discussion about public companies. As I mentioned, there's no legal definition for what is a public company, and this can lead to some confusion when we're providing counts of public companies, because you could come up with a lot of different counts based on which type of companies you decide to consider in that definition. To illustrate this, I'll use one method that is commonly used by professionals and academics and look at their population of companies and compare that to our universe of reporting issuers. To be clear, I am not opining on what should be considered a public company. I'm simply taking one of many examples that exist to show what could be considered and what could not be considered and the nuances there. All right, so this method is to just look at publicly listed companies. So this would be companies that are listed on a major US stock exchange. So what a lot of individuals do, like professionals, academics, is they'll use this data set called from the Center for Research and Security Prices, often called CRSP. And this is a data set that provides historical data on securities that are on major US exchanges. And so we take that data set and then we merge that with our population of reporting issuers to see which reporting issuers are trading on a major US exchange and which ones are not. So if you look here, you can see that 5,914 of our reporting issuers are also found on CRSP. So they have securities that are trading on a major US exchange. That is about 71% of the reporting issuers. So for the 29% of reporting issuers that did not match with CRSP, these could be issuers that are trading on the OTC markets only, or have debt securities only, or may not be trading at all. So when we look at that population of reporting issuers that also matched with the CRSP data that are trading on a major US stock exchange, we can then break it down to the different types of securities they have trading. So CRSP has the ability to do that. So you can look at what types of issuers have common shares or ADRs, closed-ended funds, stuff like that. And so when a lot of professionals and academics use this data, they only focus on, or generally only focus on, firms that have common shares trading on major U.S. exchanges. So this would be the two bottom groups. What we classify as the foreign domiciled companies and the U.S. domiciled exchange listed companies. Generally, those are the groups that get counted when we're talking about publicly listed companies, especially the bottom group. So that U.S. domiciled exchange listed companies, those are usually included when we talk about, or others talk about, U.S. public companies. So to see how this fits with our universe of reporting issuers, we've created this pie chart that has all the different groups. That big slice consists of the U.S. domiciled exchange listed companies. That's the slice that often gets used when talking about the number of U.S. companies. And you could also include those foreign domiciled exchange listed companies, the yellow slice, that would include some foreign firms. But when you're looking at a count of public companies, we see that there are a lot of different entities that are not included in that particular count that others may consider to be public companies. So what about these ADRs? What about these companies that are trading on OTC markets? They're registered with the SEC. They're providing public disclosure. Should they be considered? And a lot of this will depend on the purpose of the count and methodology, but it's important to be specific. If we want to complicate this further, we could think about other situations like, what if we don't want to consider shell companies? So if you look at just the slice of U.S. domiciled exchange-listed companies, you can see that 228 of those are shell companies. So if you don't want to include shell companies, then you're going to have a smaller number, which is 3,957. The overall takeaway of this discussion is that there's a lot of nuance when we're talking about public companies. And so it's very important to be precise about exactly what we're talking about to avoid confusion. So that ends my discussion. So I'll now turn the time to Giulio Girardi, one of our principal financial economists.
Thank you, Lyndon. So today we're going to discuss a little bit about this research paper that my co-authors and I started to work on a couple of years ago about hedge fund liquidity management. So let me give you a little bit of background and motivation for why we got interested in these topics. So the last two, financial crises, the 2008 crisis and the March 2020 market turmoil, highlighted the importance of sound liquidity risk management in order to guarantee the viability of financial institutions during crisis times. That, coupled with the fact that over the last 15 years, we've seen a big shift in credit intermediation from the banking system to asset manager pool investment vehicle, has made for us researchers studying liquidity management by pool investment vehicle, by asset manager, more important than ever in order to understand financial markets. And why we're interested in hedge fund in particular, where hedge funds have a large enough market footprint, so they're definitely relevant. They're more lightly regulated compared to mutual funds or money market funds, for instance. They have a varying level of leverage and also assets liquidity, and because of that, they could potentially be exposed to both investor redemption and margin calls. So let's take a look a little bit more closely at the structure of a hedge fund and the different liquidity components that we're going to discuss today. On the left-hand side here, we have the liability side of hedge fund balance sheet. So the hedge fund manager can raise money from the investors, right? The investors invest their money into the hedge fund, but unlike in the mutual fund case, they cannot redeem or their share on a daily basis. There are lock-up periods and notice periods that somewhat mitigate the risk of large redemption on a short-term basis. However, unlike mutual funds, the hedge fund manager can also borrow money from different sources, whether it's from banks through credit lines, prime brokers, they can trade on a margin, also in the repo markets. And depending on the financing agreement they have in place, they could face the risk of margin calls of loss of credit lines, more or less on a short-term basis. Now, with all the money the hedge fund manager either receive from the investors or borrow, he can buy different type of assets, right? Stocks, bonds, derivatives. But he can also decide, and often they do so as a fund manager, to keep some of that money aside as dry powder, right? Either in the form of cash or in the form of unused borrowing capacity. These two components, cash and unused borrowing, is what we call in our paper liquidity buffer. And the research question that we're interested in investigating in our paper are the following. Do hedge fund liquidity buffer vary cross-sectionally across funds in a way that is consistent with liquidity management theories that we learn from the finance literature? So those theories, for instance, going back hopefully to this diagram, those theories would suggest, for instance, that The lower is the hedge fund portfolio liquidity, meaning the more illiquid are the hedge fund assets, the more the hedge fund managers should want to hold higher liquidity buffer in order to find themselves not in a situation in which you would have to sell illiquid assets at a discount price. Focusing on the liability side of the balance sheet, those same theories would suggest that the higher is the investor liquidity, meaning the more investor can redeem their share on a short-term basis quickly, the more the hedge fund manager, once again, should hold higher liquidity buffer in order to be able to meet this redemption request. And on the financing side is the same concept, right? The more the financing is committed for a shorter period of time, so the more the financing is liquid, the more is committed for a shorter period of time, the more the hedge fund manager, once again, should want to hold higher liquidity buffer in order to cope with potential margin calls and so on. So these are the type of questions we're going to investigate in the first part of the paper. In the second part, we focus on abnormal low liquidity buffer, which are liquidity buffer below the level predicted by these attributes that we just discussed, by portfolio liquidity, investor liquidity, and financial liquidity. And then we ask whether low abnormal liquidity buffer reflect better investment opportunities or excessive risk-taking. And so the idea here, the hypothesis is that, is it the case that when a hedge fund hold very little liquidity, they do so because they are deploying this additional capital to buy undervalued stocks, what they perceive to be undervalued stocks, or is it the case that when they have low abnormal buffer, they're just taking excessive risk? So it's not necessarily the case that they have better investment opportunities. And then regardless of the answer to the second question, the third question of our paper that we want to investigate is, do abnormal low liquidity buffer expose hedge fund to greater liquidity risk during crisis periods, okay? And so for each of these three research questions, this is the main finding of our paper. So we find indeed evidence of all those theory that all those theory that we learn from the finance literature, they sort of check in our data. So indeed we find the case the liquidity buffer are higher across funds when funds have more illiquid assets, when funds are more exposed to the risk of margin calls and investor redemption, which makes sense, and also during period of higher market volatility, which again, for precautionary reason, that makes sense. So these are all characteristics that explain on the cross-section the level of hedge fund liquidity buffer. Now, focus on the finding of the second research question, we find the funds that have lower abnormal liquidity buffer. So given those characteristics that we just discussed above, when funds have lower liquidity than what we would predict based on those characteristics, we find that those funds, on average, in our sample period, which is 10 years worth of data from 2010 to 2023, they have better risk-adjusted portfolio performance, about 3% a year. And they also exhibit better stock selection in general, and especially around earning announcement. However, those same funds, they have lower liquidity buffer, lower abnormal liquidity buffer, and they do so because they have better investment opportunity. They are better at selecting stocks. Also, are funds that when there is an exogenous shock, like the March 2020, COVID, at the beginning of the pandemic, they realize lower returns during those market conditions, and they're forced to engage in costly fire sales of the equity holdings. So taking a look a little bit more in details about these results and appreciate a little bit better their economic significance as well. So in terms of the first question here, what determines hedge fund liquidity buffer across funds? So these are all the variables in our model that we are found to be important to determine, to explain the different level of liquidity buffer across funds. The first three in particular are the one that we discussed before, and they are the one that are more important for us: portfolio liquidity, investor, and financial liquidity. And the sign and the statistical significance of those coefficients, they all check in the direction that we want it to be. But the thing that I want to focus on today is just the economic significance, right, and the interpretation of these numbers. So if we focus on column 5, the first coefficient on the top right, minus 0.14%. So the interpretation of that coefficient will be that, across funds, when the portfolio liquidity decreases by 1 standard deviation, so the assets become more illiquid by 1 standard deviation, that is associated with an increase of liquidity buffer by 14.6%. So it's clearly a significant result from an economic standpoint as well, and so on with the other variable. Now, in the second part of our paper, what we do is, so all these variables, indeed, they tell us, they give us a prediction for what we would expect hedge fund to have in terms of liquidity buffer at a given point in time. what we do next is we focus on hedge funds that have much lower liquidity buffer than we would expect given their characteristics, and funds that have much higher liquidity buffer given what we would expect from based on these characteristics, right? Q1 are all the funds that they are in the first decile of our distribution, so they have much lower liquidity buffer compared to what we would expect given their characteristics. And Q10 are the funds that have much higher liquidity buffer compared to what we would expect given their characteristics. And Q1 minus Q10 is the difference in the performance of these two groups of funds. And the thing that I want to focus here is on the second column, which is the alpha. So this is the difference in the performance, in the risk-adjusted performance of these two groups of funds. And if you look in particular the column alpha, the last row, 0.23, so that's the monthly additional risk-adjusted performance the funds that have low abnormal buffer generates compared to funds that have high abnormal buffer. If you multiply that by 12 months of the year, you get about an extra alpha that is 3%. So that is evidence that these funds, they deploy this additional capital more than what the characteristics would suggest. They do so because they have better investment opportunity, they're better at invest than other funds, and because of that, they're able to generate systematically better risk-adjusted performance. However, those same group of funds, they also, if you look at the column to the right, they're also exposing themselves to higher credit risk. So their exposure to this credit risk factor is much higher compared to funds that have higher abnormal liquidity buffer. And so because of that, we're particularly interested in what happened to that group of funds during crisis. And so in this graph, exactly that is what we plot. So the green line is VIX over the last 10 years, which is our sample period. And we all are aware that during the onset of the pandemic in March 2020, VIX spiked to 90. And that is exactly the period of time in which this group of funds, the one with low abnormal liquidity buffer, perform very poorly, right? Minus 4% compared to funds with high abnormal buffer. The whole market was going down. Hedge funds were performing better in general. But in particular, this group of funds performed particularly worse compared to other funds that had high abnormal buffer. And so lastly, we're asking ourselves, so these funds perform better on average. However, during crisis times, perform particularly worse. Is it the case that during that point in time, they were forced perhaps to sell assets, adding therefore to the market volatility they were experiencing? And so that is the thing that we check in this table here. I don't want to make it too complicated, but essentially here the different columns represent different type of trading activity. Reduce is a variable that capture whether or not hedge fund sold their stocks. The last two capture the intensity of their selling. But regardless of which variable we're trying to measure, we see that during the crisis quarter, which is the first quarter of 2020, the hedge fund industry as a whole sold more compared to any other quarter during the 10 years worth of our sample, okay? And that is perhaps not surprising, the fact that hedge fund in the first quarter of 2020 were selling more compared to any other quarter in our sample period. The thing that is interesting for us is the second row, which basically informs us of the fact that, in particular, during that quarter of 2020, the group of hedge funds that were responsible to sell more, that they were selling the most, it was the hedge fund that entered the COVID crisis period, entered 2020 with the lowest amount of abnormal liquidity buffer. Okay? And the last table that I'm going to show you before conclude, we see the performance of the stocks that were being sold by this group of funds. And so what we see here, those columns represent the month in 2020. So it will be January, February, March, then it will be June 2020, September 2020, and December 2020. And those are the cumulative abnormal returns of the stock that were being sold by funds that entered the 2020 period with the lowest amount of abnormal liquidity buffer. And you can see that in February and March 2020, the performance of the stock that was being sold the most by hedge fund with low abnormal liquidity buffer was particularly poor, the performance of those stocks, compared to other stocks with similar characteristics at the same point in time, so in February and March 2020. However, in the second part of the year, in June, September, December 2020, eventually the performance of those stocks rebounded back towards fundamental value, which indicates the fact that there was a temporary price dislocation in those securities that were being sold by this hedge fund with low abnormal liquidity buffer. So to conclude the results of our paper, we do find the hedge fund maintain higher liquidity buffer in accordance with non-liquidity management theories that we know from the finance literature. we find the funds that have low abnormal liquidity buffer, on average, over 10 years, over our 10-year simple period, outperforms their peers and demonstrate stock picking ability. However, they also expose themselves more to market credit risk. And when this market credit risk materializes in our simple period, that will be March 2020, these funds with low abnormal buffer, they were forced to engage in equity fire sales that contributed to the temporary price dislocation during that point in time. And so when you put all these results together, that highlighted the potential trade-off between systemic risk-oriented policy that will make funds safer during crisis time and potential the impairment of regular price discovery in financial markets during normal times. And that is because the same group of funds, which is the funds with low abnormal liquidity buffer, that were responsible for selling the most stocks during crisis periods and therefore add to market volatility, is the same group of funds that in normal time are the ones that are deploying this additional capital to buy undervalued stocks and therefore make the market more efficient. So that is the punchline and the results that we have in our paper. So I'll pass it on to Chia Baker, our Deputy Director. Thank you.
Thanks, Julio. So my name is Chia Becker, and I have had the pleasure of leading the Office of Litigation Economics here in DERA for the last 17 years. So there are about 30 economists in the group. This is the group that provides economic and statistical support to specific SEC investigations and litigated cases. There are about 30 economists in the group, and they come from a variety of backgrounds. Many of them have PhDs in finance, economics, and accounting. Many of them have private sector experience doing similar work, more on the defense side than here at the SEC. But one of the things that the group does is it helps the SEC in the process of distributing money to investors. So the work that this group does is often in the background, but that doesn't mean it's not important. And we're doing, on average, 60 new distributions per year. Because of a couple of recent court cases, this work has gotten more scrutiny lately. Oops, that's the wrong direction. Okay, there we go. So I'm going to talk a little bit about what we do in the context of distributions. So after a matter has been resolved, either through settlement or judgment, and the SEC has collected its monetary remedies, then DERA helps the Office of Collections and Distributions to draft a distribution plan that will get the money back to harmed investors. The distribution plan is submitted to a judge, either in an administrative proceeding or in federal court. The investors have a chance to object and raise concerns, and the SEC has a chance to revise the plan based on that feedback. Once the plan is approved, the fund will be distributed to harmed investors according to the formulas that were developed by the economists. In some instances, the Commission works with fund administrators who assist with the claims processing to make the actual payments to investors. So within the distribution plan, what DERA is doing is writing what is called the plan of allocation. And I am, of course, somewhat biased as an economist, but I do feel that this is the heart and the most important part of the distribution plan. So the plan of allocation explains how each investor's recognized loss is calculated and how they determine how much money an investor will get. When we are writing the plan of allocation, some of our considerations are, first of all, and very importantly, can we quantify the harm to investors? This means that we're determining how investors were harmed by the misconduct and whether we can reasonably calculate a dollar value of that harm. But the second question is, can we identify the harmed investors to give the money back to? This might mean that we're going through detailed records that we've collected, and it might also mean that we're asking the investors to identify themselves in a claims-made process. And the last question goes throughout everything. The question is whether or not the plan of allocation is fair and reasonable. This is the standard that the courts hold us to. And it includes things like equal treatment for similarly situated investors, not excluding certain investors arbitrarily, not creating windfalls, and making sure that we can make a meaningful recovery for investors. In cases where we cannot identify harmed investors, or we cannot measure the harm to investors, the monetary remedies may be sent to the Treasury. Sometimes people complain that a plan does not compensate them for their investment losses, but the distributions address only the loss that is specific to the violation. One way we do this is with an event study, which controls for market and industry factors influencing the stock price on the date of a corrective disclosure. So to give you a sense of the work that we do, I am going to describe two recent examples. The first one is Valeant Pharmaceuticals. Valeant was charged with misstating revenue, and on July 31st, 2020, Valeant settled with the SEC for $45 million in penalties. In this case, DERA's economists found that the misconduct affected the prices of Valeant's stock and its bonds, many of its bonds. And we used event studies to quantify the amount of inflation in the stock price and in the bond prices. Those event study results were used to create recognized loss calculations and formulas, and a fund administrator collects and processes investor claims based on that plan. So my second example is a very different kind of situation. It's Richard Robertson and IFP Advisors. Mr. Robertson was charged with cherry picking, which means allocating a disproportionate number of profitable trades to favored accounts and unprofitable trades to unfavored accounts. On August 10th, 2022, Mr. Robertson and IFP settled with the SEC for $1.3 million in disgorgement, prejudgment interest, and penalties. While the Valeant distribution, my previous example, identified harmed investors through a claims process, this distribution did not. Because the commission had obtained the relevant trading records for all the accounts, and DERA economists identified all the harmed parties, the unfavored accounts, and the magnitude of their losses due to the violation. So as part of their analysis, DERA economists calculated each account's actual first-day return and the first-day return that would be expected if the cherry picking had not happened. The difference between those two first-day returns is the basis for the recognized loss calculation. That information was provided to the fund administrator, who contacted each investor with instructions on how to participate in the distribution and then sent payments to them. So thank you very much for this opportunity to describe our work in distributions. We recognize that this is important work, and we're careful to ensure that our contributions to the SEC's distribution plans reflect rigorous, reliable economic analysis. With that, I'm going to turn it over to Julie Marlowe.
Thank you, Chia. Good morning. The last time I had the privilege of presenting at the SEC Speaks was during the pandemic, and we're all online. It's great to see everyone in person, and thank you for the opportunity to present a few ideas today. I'm going to discuss the functions of our Office of Structured Disclosure, talk about why structured data, overview on taxonomies, and extracting data. We're going to use R&D expense as an example. Overview on FDTA, Financial Data Transparency Act, and congressional report that our office, along with others, have to produce. Some staff observations and guidance that our office works on after reviewing filings for data quality. And I'll end the presentation with an example of data set that Rob mentioned earlier. So what does OSD do? In summary, we support the SEC's efforts in making data accessible and easy to use. We design applications for conducting analysis for our staff, And once we have enough data collected under SEC rules or accounting standards, we publish data sets on our website. We also design taxonomies. In case you're unaware what a taxonomy is, it's a list of tags that filers use to structure their disclosures. You can think of it as a dictionary with list of tags. We also work with other SEC offices on including validation rules that check the quality of data when the filers submit the data to us. And as we're doing now, we conduct market engagement. We answer questions from investors about their use of data. We meet with data aggregators, filers, and accounting standard bodies on their respective financial reporting taxonomies. So for example, we meet with FASB, Financial Accounting Standards Board, on their GAAP taxonomy. So why structured data? Structured data enables automatic processing and analysis by software tools. And as we have noted in our rules, structured data may reduce the cost of capital. So let's talk about what structured data is. But let's first start with presentation languages like HTML. HTML is for human readers. It tells us how to present the content. So when something is bold, something is centered. Structured data languages like XBRL, Extensible Business Reporting Language, is for the machines. It's a language that machines use to read and process the data. It tells the computers what the content actually represents. So let's look at an example at the bottom. It starts with US GAAP, cash and cash equivalents at carrying value. So US GAAP, generally accepted accounting principles, that's for domestic filings, is from the GAAP taxonomy. Down that line, you're gonna see 2020 Q3. That means it's for quarter 3, 2020, and you see the decimals. Moving on to the second line, you're gonna see the unit reference. It's USD, it's in US dollar. And you see the amount, 11.6 billion. And it's gonna end with the tag name again. If we're looking at the GAAP taxonomy, we can kind of start from the left side. So you're gonna look at, it's as if you're looking at the financial statements. It's gonna start with statement of position, financial position, balance sheet. It's gonna go into income statement. We're gonna look at an income statement line item, but you can see that all these little items roll up to the next one. So for example, you're gonna see R&D expense rolling up to operating expenses. And then you're gonna see, if you scroll down, you're gonna see the cash flows, tags, equity tags, and tags for the footnotes. The tag we're gonna use today is research and development expense. You see the name of that tag on top, and in the middle, you're gonna see documentation. It actually tells the definition of the tag. And at the bottom, it's linked to a specific codification that requires the filers to disclose R&D expense if the amount is material. So when the filers have R&D expense, they can look at this definition and the codification and know that it's the right tag. Same thing with data users. If they want to get the R&D data, they know that this is the right tag to use by the filers and they can extract the data. So here's an example of extracting R&D expense using the GAAP tag. I used our tool called Financial Statement Core Reviewer. There are other commercial tools similar to that. And with R&D tag, it doesn't make a difference where it's located. So what do I mean by that? Some filers note their R&D expense as a line item on the income statement. Some may break it out in the footnotes. With structured data, it does not make a difference as long as it's tagged. And I was able to assemble this list within seconds because all these filers use a standard tag, R&D tag from the GAAP taxonomy. A few filers are excluded from this list because they used a custom tag. Are they allowed to do that? Yes, our rules allow that. But we have acknowledged that custom tags may reduce the comparability of intercompany data. So our rules specify the limited circumstances that they can create custom tags if they cannot find a standard tag for their unique disclosure and transactions. Let's talk about Financial Data Transparency Act. As a refresher, the act was passed in December 2022. Among other requirements, SEC and certain financial regulatory agencies are required to adopt joint data standards. In addition to that, SEC is required to submit a congressional report twice a year on our staff's use of data, but also public staff, members of the public's use of structured data. It includes discussions about enforcement cases that resulted from using the structured data, certain groups using the structured data to identify filer types, and for accounting consultation purpose. Please take a look at our latest report, December 2024. And it's on our SEC website. You can go to About and click on Reports, and you'll see this. In addition to these efforts, I mentioned our staff works on staff observations and guidance. So for example, we have data quality reminder. These focus on specific issues that we keep seeing. For example, scaling errors. We have filers giving us data that should be in millions, but that's in billions. We also see filers that adopted new accounting standards, but keep using the old tags related to the old standard. We also see filers creating custom tags for standard disclosures such as property, plant, and equipment, which includes phones, computers, printers. No reason to use a custom tag for that. And to give you some context, GAAP taxonomy has over 17,000 tags, and IFRS taxonomy has over 4,000 tags. And as you see at the bottom, we do monitor custom tags and publish trend analysis. This is for GAAP filers, and you can see we're about at 20% across filers. I'm going to end the presentation with an example data set on our website, financial statement and notes data. We have it all the way from January 2009. We update this monthly. It's a heavily downloaded item from the SEC website. And as Rob discussed earlier, we have 13 other data sets, all free for use. If you have technical questions on structured data, please contact us at structureddata@sec.gov. Thanks for your time. Back to you, Rob.
Thank you all very much for the opportunity to present to you. That's it. We're very efficient. I do want them to get their credit. We could probably share a few things.
I think we have a question.
Yes.
Liquidity, yeah. You want to go first? Yes.
Sure, thank you for the question. The first question you had, whether AI could replace structured data and what's the intersection of that. And thank you very much for the question. We get that question often. So if you look at, the way we look at it, structured data enables AI. And what do I mean by that? If the machine reading increases, the ability increases if it's reading structured disclosures with set definitions and context. So for example, XBRL, financial statements and notes, it's neatly organized with the same language across filers over periods. And there have been research studies that shows that with machine-readable data, AI is trained better. We also have a sister office called Office of Data Science, and we work with them as well. Our colleague presented last year at the SEC Speaks, and one of the things that they look at before they do any machine learning, extracting data and disclosures, they look to see if the data or disclosures are already structured. Thanks for the question.
Okay, if I could just interject a little bit there and flesh that out some, because I think it's a really important point and an important question. Some people think of AI and structured data as substitutes for one another, but they're also complements for one another. So even if data is not structured, you can use AI to get answers. But the point is that if it is structured, it's easier to train the AI is going to be more accurate, and ultimately there's a democratization to that. That is, if you have sophisticated organizations will have better trained AI, but if it's structured data, that means somebody using more common, cheaper AI, some retail investor could actually get better answers. So I think those trade-offs are really important for the Commission as we wrestle with the costs and benefits of these different tools. Yeah.
And in terms of the question that was asked to me, I'm paraphrasing sort of the question that you asked me, which makes a lot of sense. I was asked whether, the fact that these funds, they have low abnormal liquidity buffer perform better, is it almost mechanically due by the simple fact they are investing more of their capital, right? By the mere fact they have lower cash drag, they are deploying more capital. Is that why they're able to generate higher alpha? And the answer is no, because we're not looking at the raw returns. We're not comparing the raw return. That would make sense, right? The raw returns, you would expect funds over 10 years, given the stocks and bonds and the market goes up more than cash. By the mere fact that you're invested more into the markets over 10 years, you're going to expect to do better, right, in terms of raw returns. But looking at the alpha, the risk-adjusted performance, and at some point in the paper also, I didn't have time today to show you that. But we're looking at the specific stock holding in the portfolio of these funds, they have low abnormal buffer, and the stock holding in the portfolio of funds, they have higher abnormal buffer. And they're trading also ahead of earning announcement, and we just find evidence that these funds that deploy more capital, they're better at picking stocks, and that's why they generate better alpha, better risk-adjusted performance. Yep. Thank you for the question, though.
Other questions? So what time do we have to go to? We can do it. 10? 10 after? We got
more.
We have thoughts. Oh, more questions. Excellent.
I will ask this very
So currently, what we have is this research paper that has those statistics on the research paper. It does not track trends over time.
Oh, that was quick.
Sorry, I should speak much slower next time. I think that definitely merits further research going forward.
Yeah, I can interject there, but I think there's been a shift across time at the Commission in that currently, we have tremendous access to data. A lot of it we have to be very careful with what could be shared, but to the extent we can share some of this data, we think for market participants and for academics, it's really important. And again, a lot of the data involves a lot of work in cleaning it up, making sure it reflects what we want it to reflect, and that we define that for users. And so I think that'll add a uniformity to understanding of what's being measured that'll really help academic studies as well. So some of that I think we'll do retrospectively across time as well, and it's just a major effort to get the public good benefits of the fact that we have this information, we've collected this information, the public should see this information, we should be as transparent as possible. So it's all part of that effort.
Thanks, I'm sorry for all these questions. Given how you can slice and dice information, I wonder, are you going to have the ability to weigh in on some of the upcoming rule modernization activities that are going on? Let's say, for example, exec comp. It's so long and complicated, and certainly there are opportunities, I would imagine, to simplify it, but are you able to look at data and determine what disclosures in different areas might be most relevant to the market?
I'm assuming that question's for me. So this count, the number of reporting issuers that we shared, this is something that we've used internally for a while, but we rarely use the full sample. So when we're working on different rules, we will look at the reporting issuers that are influenced by those rules. So for example, we mentioned that there were asset-backed securities in that sample of reporting issuers. They're generally not impacted by a lot of rules, for example, anything related to executive compensation. And so we make sure that when we're looking at the affected companies, we are tailoring our population to the companies or entities that we think will be affected. And this actually, so since we have to kill time, during my presentation, I talked about the importance of being precise in what we talk about for public companies. But it's also important to be precise when we just look at that seemingly simple number for reporting issuers. There are a lot of decisions that go into place in coming up with that count. When we're thinking about companies that are registered with the SEC, there's a lot of fluidity. There's companies coming in, companies going out, and so you have to decide, okay, how do we want to track these companies when we're providing these counts? So what we did is we focused on annual reports. So if an entity issued an annual report in the calendar year 2023, they were included. We could have made decisions on whether to use fiscal period instead of calendar years. We could have decided to include registration statements. But there's a lot of uncertainty with whether those will stay within the sample and stuff. So even with that seemingly simple number of the total reporting issuers, the methodology you choose to use can impact that number.
Got one over here.
How do you assess who's using it, what they're using it for, and does the benefit outweigh the cost? I think you said there's 17,000 different tagging opportunities for FASB filers. So is that, who's using it, how are they using it, how do you assess that?
That's a great idea. So one of the slides that I use with other conferences on discussing different users of the data. So we have a public-facing inbox called structureddata.sec.gov, and we get a lot of questions from the investors, academics. We often get questions from financial analysts using the data as well. So I was on a panel with somebody from Morgan Stanley. They use the structured data for investment analysis. We're also aware of other financial firms that have used structured data to calculate tax effects from different acts. We also have federal agencies, FDIC, we met with Census Bureau folks, and other agencies that actually use the structured data from our financial statement, the data sets, because some of our entities that we regulate overlap. And as mentioned, SEC staff have used the data to monitor rule compliance. We have used the rules to assess if certain rules, how it will be affected. FASB, the accounting standards body, has used also structured data to assess how their new lease accounting standard may be affected. So there are various sources that we get that from. We also meet with XBRL US twice a year under the guidance from former Chair White's advice. So XBRL US is a external party made up of filers, data aggregators, both accounting standards bodies are observers, and they often tell us the use of structured data, and they give us comments on improving the data quality and taxonomy. So we have various ways to kind of track that as well.
Yeah, just to add a few comments to that, I think, I mean, setting standards does impose costs on people. At the same time, when you have a standard, you have the potential benefit of network externalities. The more people who use the standard, the more valuable it is. In this case, I think it does go to the very heart of the Commission's mission in the sense that when we do this structured data, we're allowing efficient comparability across entities, which is an extraordinarily valuable thing. So we always have to be careful and look at the costs and benefits and who's getting hit by those costs. But the potential returns can be terrific as well.
Thank you.
We've got a minute to go, guys.
Hi, thanks everyone again. Two very quick questions. First to Mr. Orton. I noticed in your kind of graph pie chart, you excluded REITs from your kind of count of domestic and foreign listed corporations. I was just curious the analysis that went into making that separation. And then to Ms. Marlowe, if you could just quickly comment on what you view as the expansion of XBRL tagging on narrative disclosure as opposed to GAAP and IFRS taxonomies. Thank you.
Yeah, so the purpose of the presentation was just to show what could or could not be included. So I'm not making an opinion on should REITs be included or not. But what has happened in a lot of academic papers and news articles is they'll take CRISP, that data set I mentioned, and they'll look for securities that have common shares, and that's it. So everything else gets cut out, and that would include REITs or ADRs. And so again, when we're talking about public companies, the definition we use might change based on the purpose. But yeah, just highlighting that can change.
So your question about how different users use the narrative disclosures, the structured data of that. So folks might remember when we first adopted the interactive data rules in 2009, we actually started with block tagging of the narrative disclosures first, because there was a lot of demand about what is in that disclosure. And now, coming with the inline XBRL and some expansion of other narrative disclosures, it saves time when that narrative disclosure is tagged, right? And it's block tagged. And then you get down to the details, the nitty-gritty of the amounts and their percentages. It enables easy processing. It saves so much time. When I joined this group, we heard from a professor who said, hey, it used to take me months to get this one little footnote across filers. With the structured data, it takes me seconds. So that's kind of the speed that we're talking about. Also, we've seen other staff within the building that have used the structured data. So our colleagues in Office of Data Science has used the tonality using the data. So what's this one filer says for a particular disclosure toward, compared to this something else. One example that we've also seen other people use is when COVID happened, what did people say about the effect of that in their footnotes, effect as a result of COVID. So there are plenty of use cases and benefits to structuring the narrative disclosures as well.
All right, I think you all should give yourselves a big round of applause for getting your PLI credits. Thank you.
Thank you, DERA, for that very informative panel and for making sure that everyone's getting their CLEs. And I am sure it is appreciated by everyone. This is, of course, quite a lineup today. And rounding out our current commissioners, I am pleased to welcome Commissioner Krenshaw. Caroline A. Krenshaw was unanimously confirmed by the U.S. Senate and sworn into office as a commissioner on August 17th, 2020. Previously, Commissioner Krenshaw served as a career SEC staff attorney in the Division of Examinations, formerly the Office of Compliance, Inspections, and Examinations, and the Division of Investment Management as counsel to Commissioners Kara Stein and Robert Jackson. In addition, Commissioner Crenshaw currently serves as a major in the United States Army Reserve, Judge Advocate General's Corp. Please welcome Commissioner Crenshaw.
Thank you, Cicely. I like to do a grand entrance right before lunch. Hold you hostage as long as possible. Good afternoon. As you know, SEC Speaks is an opportunity for the agency, and specifically the SEC staff, to speak directly to practitioners in our space. To me, and perhaps to some of you, this year's SEC Speaks feels a bit different. My hope is that over the course of this event, amid talk of rolling back rules and diminishing protections, we will all be reminded of the crucial work that the agency does, which benefits not only investors, but the markets and each of you. And I hope we are all reminded of the caliber of people who do that work. So before I begin, I'll give the standard disclaimer that the views I express today are my own and not necessarily those of the commission, the staff, or my fellow commissioners. My remarks today offer a word of caution as the agency chips away at decades of our own work, and at the same time, that we stare down alarming market volatility, emerging risks, and calls for deregulatory action in all corners of our markets. As we careen down this path full speed, it almost feels like we're playing a game of regulatory Jenga. Our proverbial Jenga board is made up of a set of discrete, bless you, but interrelated rules and laws, deeply and carefully developed over the years and implemented by a strong agency of experts, skilled in overseeing and regulating our increasingly complex markets. Of course, in Jenga, the tower remains standing when you pull out a block or two here and there. But how many blocks can you pull out before the tower gives way? When it comes to the stability of our markets, how far are we willing to take our dangerous game? Who would ultimately be the loser when the foundation gives way? I worry, as we all should, that those losing the most won't be the influential mudding interests. Rather, it will be Main Street Americans, the investors and the small business owners who can least afford the greatest loss. Consider some of the actions the agency has taken over the past weeks and months. First, we've pushed out our staff. This is the first and perhaps most devastating Jenga piece to go. The staff of the SEC is and has been comprised of dedicated public servants who are responsible for implementing and upholding a careful mosaic of laws which have matured gradually and deliberately over decades. Their knowledge base reflects a regulatory regime that is highly technical, and their expertise has been sharpened by lessons learned from crises past. The industry's success, in many ways, depends upon the agency maintaining a deep well of institutional knowledge. Our well has taken a substantial and sudden hit. In response to voluntary retirement, resignation, or simply the specter of random firings, we have lost nearly 15% of our staff. These are experts in their fields who have weathered market events of all shapes and sizes, seen the fallout from calamity, guided recovery efforts, and have instituted protections that decrease the risk that similar disasters might happen again. In other words, these are the people who you want in place when volatility or disaster strikes. This, of course, begs the question, is our capacity sufficient today to prevent a future crisis or to aid in the recovery from one? We cannot take the integrity and continuity of this institution as we know it for granted, and we should not assume that the growth and stability we've witnessed the past few years will continue. Next, we diluted and effectively rescinded the laws without due consideration of the costs, benefits, or public feedback. This is the second foundational Jenga piece. In the past 4 months, we've used guidance to walk away from rules and upend long-standing practice. Recently, there have been a wave of staff guidance on crypto mining, on meme coins, on investment advisor marketing, on the engagement with management for purposes of Schedule 13D and 13G, and on verification requirements for accredited investors. We have further changed the rules of the road for proxy proposals issued midway through the proxy season, and effectively amended recently adopted rules on conflicts of interest in securitized transactions. In particular, our statements on these crypto-related issues are the equivalent of a wink and a nod, intended to convey that we do not plan to rigorously apply our laws in certain specific situations. For example, the statements pull at the threads of our most foundational case law, while meekly suggesting, in footnotes, that we still might do the required facts and circumstances analysis in each case. We take this slipshod approach to stablecoins as well, which have shown their capability of posing systemic risk to our traditional financial system. We've done all of the above without commission vote, without the benefit of analysis from our economists, and without fulsome opportunity for public comment. I am concerned that staff guidance is not the correct vehicle for declarations of this magnitude, and we need to carefully analyze suggestions that we ought to create some alternative, presumably lesser, regime to accommodate industry and promised innovation. Separately, the Commission has also declined to defend and claims to be reconsidering recently adopted rules. The dismantling of these rules taken individually is bad enough, but what's worse is the broader intentional pattern of undoing the duly adopted work of prior commissions. The result is that every final rule feels like it isn't final at all. This is problematic for our reputation and credibility as a regulatory body and may undermine the presumption of regularity of government affairs. Of course, rules are amended and updated over the years and decades as necessary. But to reverse course on rules before they've even gone into full effect suggests that a prior commission vote is meaningless against the slightest change in the political breeze. Third, the next Jenga piece. We are ignoring courts and failing to faithfully and even-handedly enforce even laws that have been on the books for decades. Our agency was criticized for purportedly engaging in regulation by enforcement. But this is a misnomer. None of our litigations tried to create laws or regulate in a new way. These actions applied decades-old precedent to address violations of existing securities laws. This is what our mandate is and always has been. The real complaint was not that the Commission wasn't applying the facts to the law, it was that the crypto industry didn't like the law and wanted new rules. And we've now shut down our enforcement program, abandoning our duty to enforce existing law in anticipation of creating new crypto-friendly rules. This is properly criticized as regulation by non-enforcement. Given that, I'm deeply troubled by the Commission's abandonment of swaths of our enforcement program. As I've said before, these cases were thoroughly investigated by the staff and considered by a prior commission. Some even involve court orders that we now toss aside with no respect for the court's decision. This about-face is problematic for a host of reasons. It corrodes our reputation in front of courts. It undermines the credibility of the Commission and the staff when we pursue enforcement cases involving all types of misconduct, not just crypto. And it casts doubt on the state of longstanding and fundamental case law. In a supposed search for regulatory clarity, all these actions have done is create confusion and disarray. Finally, we're ignoring significant risks. Consider the crypto markets again. These products have already laid bare how their heightened risk profiles can result in harm for investors. Crypto presents certain novel risks, including those related to hacks and the prevalence of crypto as a method of payment for illicit activity. This year alone saw a 66% increase in total fraud-related crypto losses, primarily affecting individuals over the age of 60. Plus, we've also experienced what a large-scale crypto crisis can look like. As recently as 2022, following the fallout of FTX, there was a shared sense of concern and call to action for regulators. Those risks have not gone away, but the calls for serious regulatory scrutiny are a lot quieter these days. For example, unique challenges with custody, conflicts of interest, disclosure, and market integrity remain unresolved, despite the pressure for widespread crypto adoption and experimentation. Adding to the complexity are the scores of traditional products that reference crypto assets in some form, including crypto futures ETFs and crypto ETPs. Failing to appreciate and address these risks and complexities destines us to repeat hard lessons with high stakes as crypto becomes increasingly entangled with traditional finance. Next, consider the unheeded risks posed by the eroding barrier between public and private markets. There's a growing appetite to experiment with limitations on exposure to private assets in registered funds. The distinction between public and private markets exists for a reason. We know that private markets are inherently riskier, entail less disclosure, and require a higher tolerance for volatility and illiquidity. And we've seen instances of outside harm when the opacity of the private market space covers up massive fraud. These private markets are not designed for the average Main Street investor. Packaging these risks into retail products, in the form of retail funds, of private funds, for example, does not change their nature. It simply further masks those risks to investors who may not appreciate them, even if they know that they're being exposed to them at all. What's more, it's not clear that products designed for retail investors, such as registered funds, will function effectively in times of market stress if they're significantly handcuffed to private markets. It's therefore worth asking, is this proposed expansion in retail investors' interests, particularly when fees on products with private market exposure are exponentially higher than, for example, most index funds? So we're pulling pieces off the Jenga board in a perilous way. And we're doing so in a time of serious headwinds. Markets are becoming increasingly, perhaps predictably, volatile. Products are more complex. Investors are more exposed. And regulators will have less insight. It's reminiscent of other times when we've been criticized for our deregulatory posture while markets were growing increasingly complex. Consider the 2008 financial crisis. In a postmortem, the Bipartisan Financial Crisis Inquiry Commission's final report concluded that the crash was avoidable and the result of human action and inaction. According to the report, decades of deregulation and reliance on ill-advised self-regulation by financial institutions resulted in widespread failures in both financial regulation and supervision. The report also found that regulators failed adequately to manage evolving risks and heed warnings of instability. After a crisis happens, the first thing people want to know is, how could this have happened? And more specifically, where were the regulators? But before a crisis happens, everyone demands that regulators get out of their way. I don't want us to suffer the same fate. This is a dangerous game. We're pulling apart our own regulatory foundation, block by block, case by case, and rule by rule. It feels all too familiar to those of us who lived through 2008. And this approach comes in a moment when the agency has just experienced an unprecedented blow to our staff. If we continue down this path, eventually, the carefully constructed tower of regulatory blocks will tumble, leaving the door open to the same types of misconduct we have spent decades eradicating. When that happens, small businesses and retail investors are the ones who will lose out as they attempt to tread water in tumultuous markets with fewer and fewer protections. Of course, there's also the damage a potential future crisis will inflict upon the reputation of regulators who let it happen. In that future moment, when we're asking ourselves what could have prevented a new crisis, we may find ourselves coming back to the rules and case law that we contemplate abandoning at this very moment. Tomorrow's hindsight is today's foresight. We cannot play games with the institutional integrity of the SEC and the integrity of our markets and expect that we won't ultimately lose. Sooner or later, our complacency today will be the cautionary tale told to the regulators of tomorrow. Like tumbling Jenga pieces, we cannot let our guard down and pull the wrong blocks. Thank you.
So just a reminder, we're on a lunch break right now. We'll see everybody back at 1:30.
Check, check, quick check, mic check, 1, 2. Check, check, mic check, 1, 2. Check, check, 1, 2. Mic check, 1, 2. Mic check, 1, 2. This is a mic check. 1, 2, check, check, 1, 2. Hey, hey, check, check, mic check, 1, 2. Mic check. Gwen is working. Mic check. 1, 2. Sounds good. Mic check. I feel louder in the room. That's good. Mic check. 1, 2. Check, check. 1, 2. Hey, hey. And I'm speaking very low. Mic check. 1, 2.
not sure, is this mic on? Okay, perfect. Welcome back. I hope you all had a nice lunch. Our next panel will be led by Keith Cassidy, Acting Director for the Division of Examinations. As well as his acting role, Keith Cassidy also serves as the head of the Technology Controls Program. His staff also administers the SEC's Cyber Watch program. Mr. Cassidy serves as the SEC's representative to the G7 Cyber Experts Group, the Financial and Banking Information Infrastructure Committee, and the Cyber Incident Reporting Council. Before joining examinations, Mr. Cassidy was the director of the SEC's Office of Legislative and Intergovernmental Affairs. And before coming to the commission in 2010, Mr. Cassidy was chief of staff and counsel at the Department of Justice's Office of Legislative Affairs. Mr. Cassidy is also an infantry officer in the U.S. Marine Corps Reserve, where he serves as the Reserve Operations Officer for the 4th Reconnaissance Battalion and has earned numerous awards. Joining us to provide commentary for this panel is former Commissioner Dan Gallagher. Dan Gallagher is the Chief Legal, Compliance, and Corporate Affairs Officer of Robinhood Markets, Inc. Before joining Robinhood, Mr. Gallagher was partner and deputy chair of the Securities Department at WilmerHale. He served as commissioner of the SEC from 2011 to 2015 and has held several other positions on the SEC staff prior to being appointed commissioner. Mr. Gallagher's previous experience includes serving as the chief legal officer at Mylan NV, a leading global pharmaceutical company, and as president of a financial services consulting firm. He also serves on several advisory boards. So thank you for coming, Commissioner Gallagher. Before starting this panel, I ask that you please consider the comments of this session's panelists, and the disclaimer that I provided this morning does still hold. I'll turn it over to you, Keith. Thank you.
For the warm introduction, and thank you to Commissioner Gallagher for joining the panel this afternoon. And I welcome everyone in the room and online to a joint panel of the SEC's Division of Examinations, the Office of Credit Ratings, and the Office of Municipal Securities. As Cicely mentioned, I'm Keith Cassidy, the Acting Director of the Division of Examinations. We have a great set of panelists that I will introduce to you in a minute, but let me first remind everyone that while our remarks are given in our official capacity, they do not necessarily reflect the views of the Commission, the Commissioners, or any members of the staff. While much has changed since we appeared on this stage a little more than a year ago, the Division of Examinations continues to execute on our priorities and engage with industry as we're doing today, to promote compliance and in turn protect investors and ensure fair and orderly markets. As for our panelists from the Division of Examinations, I'm pleased to introduce Vanessa Horton, National Investment Advisor, Investment Company Program Director. The IAIC examination program conducts examinations of investment advisors and investment companies such as mutual funds and ETFs. Next to her, Mike Ruffino is the National Broker-Dealer and Exchange Program Director. The BDX examination program conducts examinations of broker-dealers, national security exchanges, transfer agents, municipal advisors, among others. Next to Mike is Alexis Hall, who's the Acting National Technology Controls Director. TCP conducts examinations of entities subject to regulation, systems, compliance, and integrity. This program also administers the SEC's CyberWatch program, which is the primary intake point for information filed under regulation SCI. Hein Kim, next to Alexis, is the Chief Risk and Strategy Officer for the Office of Risk and Strategy. The office is the division's strategic information hub and support center for monitoring and identification of risk in the registrant community. I'm also pleased to introduce Scott Davey, the Acting Director of the Office of Credit Ratings. The SEC's Office of Credit Ratings has oversight of credit rating agencies registered with the Commission as nationally recognized statistical rating organizations. And last but certainly not least, Adam Wendell is the Deputy Director of the SEC's Office of Municipal Securities, a team that coordinates the Commission's activities relating to the $4 trillion municipal securities market and administers the Commission's rules pertaining to municipal securities brokers and dealers, and municipal advisors, investors in municipal securities, and municipal issuers. We have an informative discussion teed up, so we'll go ahead and get started. So in 1995, former SEC Chairman Arthur Levitt announced the creation of the Office of Compliance Inspections and Examinations, which is the predecessor of the Division of Examinations. Around the time, the Office of Municipal Securities was also created to provide coordination and expertise on the varied initiatives related to the municipal operations and the Commission's oversight and regulatory functions. For Vanessa and Mike, how have your two programs changed over the last 30 years?
I'll take that one first. Thanks, Keith. Well, first, before I answer that question, I just appreciate the opportunity to speak with you here today, those who are in the room and those who may be online listening. Realize this is, probably one of the few times you voluntarily want to speak with exams and engage with us, so appreciate this opportunity for sure. So for the changes over the past 30 years, I mean, gosh, probably, a lot of folks would say it's a lot of changes that occur within the past 3 months, I should say, versus 30 years. But certainly the markets have undergone a significant amount of change and since our creation. So we, in turn, have been responding to that by adapting our examinations to address increased sophistication, breadth of complexity of the financial markets, and over the years we've improved our transparency that hopefully you've seen through our annual priorities, our risk alerts that we've published, as well as our numerous outreach events such as this. We do all this with an intent to promote compliance. More recently, we've been enhancing our examination projection methodology so that our annual planning is better aligned with our risk-based approach, examination approach. As you probably know, our priorities are published towards the beginning of our fiscal year, sometime in October, which is the exact time that we are doing our planning for the upcoming fiscal year. We've also had much better coordination throughout the regions within the IIC program and between the two largest examination programs with IIC and BDX program. This collaborative approach has really allowed us to be more efficient and add in the use of technology, and it's really a force multiplier for the exam program, and it allows us to accomplish our mission in protecting investors.
Mike, over to you.
Oh, sure. Thank you, Keith, and thanks again for inviting me to the PLI. Much appreciated. I think, as a famous saying, there's nothing permanent except change. And if we look at the BDX program over the last 30 years, there's been some significant changes to our respective program. When OC was first formed and now the Division of Examinations, the internet was at its early stages. So clearly technology was kind of coming into the foray, and it's being utilized more and more in our examinations. To start with, I will tell you that the type of registrants we're responsible for in the BDX program has changed through different laws and acts. You look at securities-based swap dealers and swap execution facilities. Excuse me, Title VII under Dodd-Frank created a whole regime with regard to securities-based swaps. Then you had funding portals, which was part of the Jobs Act. So clearly the remit for the BDX program has changed over the years. Also, the number of exchanges. I recall when I first started my career, there was only very few exchanges. Today, we have 28 national securities exchanges. So clearly, a lot of changes just on the registrant types. I will tell you that a lot of coordination and collaboration has occurred over the last 30 years. I look at colleagues, I was formerly at FINRA, where we coordinate and collaborate much with FINRA. We recognize the burden that examinations could have on our registrant population, so we do more and more today than ever before in terms of coordination and collaboration with FINRA and the MSRB. Also with the banking regulators. Some of our registrants, for example, transfer agents, they can fall under the remit of the banking agencies, the Securities and Exchange Commission, and understanding that, we coordinate with them. We have ongoing meetings and dialogue to make sure that our efforts are utilized in the right fashion. Also, as I said before, technology has changed dramatically, and our ability to utilize information to basically obtain intelligence and really act upon that intelligence today to basically root out fraud or to do background information is better now than ever before. We've hired senior specialized examiners in certain of our areas of remit to make sure that we have the right set of examination skills when conducting those examinations. We've put together specialized working groups. We've done more and more to really enhance our program like never before to make sure that we have changed with the times. As the markets have evolved, we have evolved. And today, I'm proud to say that we're positioned to do the best we can to make sure that we're protecting investors on the markets.
Thanks, Mike. Adam, how has the market for municipal securities evolved over the last 30 years?
So in many respects, the municipal securities market has evolved in the same way as all of our other securities sectors. But what may be more interesting for munis is the ways in which it hasn't evolved as much. Munis is still municipal market is still a very over-the-counter market. Many, if not most, trades are still done over the phone. So it is a little bit, I guess, has evolved less than some of the other markets, and that's largely because it is a largely retail market and sort of niche in some ways. But the changes that have occurred, a lot of them are technology related. For example, in 1994, starting in 1994, you had ongoing disclosure submissions submitted to these various array of national information repositories that were designated by the SEC. They would change over time, but they were submitted, in paper form, sometimes by fax. And then starting in 2009, that shifted to a single repository, which now the SEC is, the current designation since 2009, 2010, is the MSRB's EMMA system. So at least everything is, all of those disclosures are submitted electronically and submitted in one place. And then the other thing just is after Dodd-Frank, our office, which was originally part of trading and markets, was created in 2010 as a standalone office where our director reports directly to the chair. And together with that was the creation of this new category of registrants, municipal advisors, that are now regulated by the SEC and examined by the SEC, and we'll talk a little bit more about that later.
Thanks, Adam. Shifting a little bit from the markets to the division structure that has evolved over time. Now the Division of Examinations has 5 programs with several offices that support the 5 programs. So Alexis and Hayne, I wanted to help talk about your program and your office, which are relatively new over the last 10 or so years. So Hayne, can you talk a little bit about the creation of the Office of Risk and Strategy and what your team works on?
Yeah, so the office centralizes support for the division's monitoring and risk identification and analytics efforts. The office really serves as a critical foundation for the work that the division has undertaken over the past 15 years and more to more efficiently and surgically identify firms or areas of risk for examination by joining analytics with qualitative monitoring. So this work was relatively nascent at the time the office was created and was done in different groups and pockets of the division. And the creation really allowed for critical collaboration among the previously dispersed groups, which greatly enhanced and advanced the ability for the risk and strategy team to serve the division's needs, including helping the division effectively allocate its limited resources and meet the tech advancements that Mike and Vanessa have discussed. And so what do? We identify and assess both inherent and idiosyncratic risk and control themes through analysis of various data sources, development of research and analytics tools, and then certain data and monitoring efforts, including research, conducting in-person data-intensive exams, and then as well large firm monitoring. And this ultimately informs division strategy, planning, candidate selection, scoping, and work done during an examination for data analytics.
So, and you mentioned large firm monitoring. Can you talk a little bit about what that team does?
Yeah, so when I talk a little bit about the qualitative work that both informs and is informed by analytics of ORS, a significant part of that work is the work of the large firm monitoring team. So this group ensures that the division has an ongoing touch at select large firms, so large broker-dealers, dual registrants, often affiliated with some of the largest investment advisors and other registered entities, with our multiple registrant offerings, different products, services. The team's work is mainly conducted through regular and ad hoc meetings with personnel and the risk, compliance, cyber, tech, operations, internal audit functions of the firm. The team also drives the large firm engagement initiative for division leadership and SEC staff to meet annually with firm leaders, directors, heads of control functions, allowing for open dialogue, not cabined really by a particular asset class or service. And through this team, the division is able to keep abreast of both firm-specific, industry-wide business, risk, control issues, and themes, including understanding firm readiness for implementation of significant securities regulations.
Thanks, Hayne. Alexis, can you talk a little bit about the creation of TCP and what that team does?
Sure. With the adoption of Regulation SCI in 2014, the Automation Review Policy, known as ARP, transitioned from a voluntary program in the Division of Trading and Markets to a full examination program called the Technology Controls Program in the Division of Examinations. TCP staff are primarily technologists of varied backgrounds, but include a number of former CISOs, system admins, auditors, and a handful of attorneys, including myself. And I would say that our functions fall within three main categories. The first is that we perform technology and technology controls focused exams of entities subject to regulations SCI, SP, and SID. Second is our Cybersecurity Program Office, which we established in 2022 to coordinate initiatives across the agency and external partners on matters related to cybersecurity. And our Cybersecurity Program Office is also home to TCP's CyberWatch program, which intakes and analyzes the reports and notifications required to be filed under Regulation SCI. And lastly, the last category is via our Technical Assistance Service, which we call TAS. We offer technical expertise to other examination staff in commission division and offices. And this is full spectrum and can range from answering a question about technology to actually sending a TCP examiner to work collaboratively with another exam team out in the field.
Thanks, Alexis. We'll bring Scott into the conversation here. So the Office of Credit Ratings was created after the financial crisis. Can you talk a little bit about your work and what's changed over the last 13 years?
Yeah, sure, Keith. So in 2012, when OCR began their annual exams of credit rating agencies, the industry was fairly new to being regulated. And as such, a lot of that early exam work really focused on internal controls, policies, and procedures. And we just wanted to make sure that the basic framework for regulatory compliance was in place. And since that time, we've seen the rating agencies have really devoted a lot of resources to their compliance function, and they've made improvements to their policy procedures and those controls that we were looking at. Because of that, we're seeing their agencies actually now flagging things for us. Their compliance staff is catching things and reporting it to us as self-reported things. As we go into an exam, there's usually a bunch of things they flag for us. And the way that affects our exam is it allows our examiners to be a little more nuanced in what they want to look at. So for example, they can now look at specific rating actions to ensure that there were controls, and the controls for adherence to methodologies were followed, and there were no evidence of conflicts of interest and things like that. So a bit more nuanced now than we were previously.
Thanks, Scott. I'm going to turn back to Alexis, a topic that's near and dear to my heart. What are you all seeing as far as the significant cybersecurity threats that firms are facing these days?
I would say that ransomware remains a big one. Over time, malicious actors have adjusted their ransomware tactics to be more impactful and destructive. So we're seeing them use double extortion techniques where they exfiltrate victim data and then pressure victims to pay by threatening to release that stolen data. And we're also seeing, in some cases, they may exfiltrate data and threaten to reveal it without using ransomware at all. These incidents have a severe impact on business processes by leaving organizations unable to access necessary data to perform mission-critical services. The economic and reputational impacts of ransomware and data extortion have proven challenging and costly for organizations of all sizes.
And as far as what your team is seeing, are you really only seeing highly sophisticated techniques, such as zero-day exploits, or are you seeing kind of a myriad of attack vectors?
It's not just zero-day attacks. Threat actors' capabilities continue to evolve with the adoption of advanced techniques, such as AI-driven malware, that enable rapid customization to target specific entities. Further, the proliferation of ransomware as a service models has streamlined the distribution of attack tools, allowing even low-skilled actors to launch sophisticated attacks. And just as background, ransomware as a service is a business model where ransomware operators write software and users pay to launch attacks using the software. So users don't need to have any specific technical skills of their own, but instead just rely on the technical skills of the operator.
So maybe just to park there for a moment. So, the bad guys can go purchase something. They don't have to really know, almost like getting an app and then utilize what was purchased in order to actually exploit a registrant.
Exactly.
And so what role does TCP have in responding to cyber events, if any?
So TCP Cybersecurity Program Office is the designated lead of our agency's Cyber Incident Assessment Team. It, in consultation with other exam staff and other commission division and offices, coordinates outreach to regulated entities to review potential impacts related to significant cybersecurity events. It also coordinates external support activities in accordance with national and financial sector cyber incident response plans. For significant cybersecurity incidents, the CPO focuses on key cyber assessment areas, which include, for example, assessment of the operational impact of the event, the containment status. In other words, have the impacted systems been isolated to mitigate the risk of contagion, and the incident type, attack method, and threat actor if known.
Thanks, Alexis. And so obviously TCP is highly involved with this, but I suspect other programs have a role as well. So Vanessa, I'll turn to you. As far as IIC goes, are there specific steps that your staff are looking for firms to undertake with respect to their information security?
Most definitely, Keith. Alexis articulated so well. Cybersecurity is now has been and will be a focus for the IIC examination program for some time, and has been dating all the way back to 2014, where we've initiated national initiatives and included it in our examinations for some time. General observations for these initiatives we've included in several risk alerts that are available on our public-facing website. Some of the observations and concerns that we've been noting for our cybersecurity programs is very fact-specific. When staff reviews a firm's business and operations, we look at its compliance program with regards to cybersecurity, but we've observed that industry practices consistently consider governance and risk management, access rights and controls, data loss prevention, mobile security, incident response and resiliency, vendor management, and training and awareness, for just a few areas that we review. A governance and risk management program should generally include a risk assessment to identify, analyze, and prioritize cybersecurity risks to the organization. They should be reasonably designed, written policies and procedures that address cybersecurity to address those risks, and effective implementation and enforcement of those policies and procedures. Some of the weakest policies and procedures that we've noted are those that are more general in nature, and they simply identify examples of safeguards to consider. They also may be very narrowly scoped or too vague because they don't articulate procedures as to how employees are expected to implement the policies and procedures. Access rights and controls used to determine appropriate users for organization systems based on job responsibilities, and to deploy controls to limit access to only authorized users. Policies and procedures that we've noted were sometimes weak in addressing access rights and controls. We've identified inadequacies related to firms addressing data loss prevention, and often these issues were related to safeguards for the use of portable electronic devices, personal computers, cell phones, removable storage devices, including some firms lacking the ability to restrict end users from removing sensitive or critical information from firm networks onto such devices. The examination staff have identified weaknesses related to firms' incident response programs, including the application of such programs to branch offices and not testing policies and procedures that are in place. In some instances, we've also seen inadequacies in regard to vendor management practices. Often such issues relate to the due diligence of third-party vendors and contingency planning. Further, we've identified instances of firms not adequately addressing cybersecurity training. Such issues were often related to weak or missing policies and procedures to address the implementation of periodic security awareness training, or not requiring personnel with access to information systems to attend such trainings, including branch office personnel.
So that's a rather robust list of observations. Are there things
They
that
are
firms
available on
are there things that firms can do to improve their policies and procedures with respect to the protection of customer records and information?
Sure. I think firms should basically ask themselves if their policies and procedures are reasonably designed given their own particular business practices. Many times we've seen policies and procedures that are what we consider off-the-shelf policies and procedures that don't really address the actual firm's practices. And so we would encourage all firms to take a hard look at the practices of the firm to make sure that these policies and procedures address these threats and hazards that might be relevant to the particular business. We'd also encourage policies and procedures to address administrative, technical, and physical safeguards. And some areas to consider, again, are access rights procedures, which should include understanding the location of the data and client information and restricting access to systems to unauthorized users. And we've observed instances where former employees of firms retain their access rights after their departure and therefore could access restricted information. Firms can also consider whether they have the capability to identify what information was downloaded from their systems, when and by whom. And implementing policies and procedures that address the nature and scope of any incident and require appropriate steps to contain and control the incident to prevent further unauthorized access. For example, incident response plans should address important areas such as role assignments for implementing the plan and actions required to address cybersecurity incidents. And finally, a firm, if it has multiple office locations, they should consider whether they have implemented their safeguard procedures for all of their offices. Staff has observed many times where there were many firms implementing policies and procedures for safeguarding records, but they only do so for their main offices. And so we would encourage all firms to often make sure that their policies and procedures are relevant to all branch offices outside of the main office.
Very helpful recommendations. Let's turn to a topic that's getting a lot of press these days, artificial intelligence. Maybe we'll stick with Vanessa. How are you seeing registrants using artificial intelligence, and what issues does this raise?
Artificial intelligence is growing by leaps and bounds every day. I know it's getting scary out there when I ask my son how his day is going, and he tells me IRL went pretty well. If you don't know what that means, I didn't either, but it's in real life. So it's moving very fast. Today's AI is probably not even the same as yesterday's AI. Registrants are increasingly using artificial intelligence and their tools, including generative AI. And we recognize the promise of AI, even internal to the agency. We see such promise and efficiencies in utilizing AI, but it's our ability to, we understand that it's the ability to transform workplaces through innovation. Our job is just to understand the use cases of AI and the associated risks with utilizing AI.
So along those lines, what are some things firms should consider when utilizing AI?
Well, it's the new shining tool, but it's not actually new. Financial firms have been utilizing natural language processing and machine learning for quite some time. Artificial intelligence is dynamic, and what we've seen is that firms are experimenting and developing new uses. However, some of the foundational principles that ground the focus of how we approach artificial intelligence, I always like to say it's important to keep a human in the loop. Artificial intelligence tools can provide benefits, operational efficiencies, knowledge management, faster investment research, cybersecurity, and targeted marketing. But firms have to be careful in the disclosures that they utilize with regards to AI. One of the things also, being a disclosure regime, we want to make sure you're doing what you say and saying what you do when you utilize AI.
Sage words will let
Keith,
Vanessa
can I
off
jump
the-
in?
Oh, please.
The question. I don't want to be a total bump on the log. I got to ask a question here, right? First, by way of commentator, which I am, a comment, which is, as an old trading and markets person, I'm sitting here realizing all the pieces of trading and markets have moved over to your new division here of examinations. With the old ARP program, credit rating agencies and munis, when I was in TM, we had you guys. So that's sad. Sad for TM. I'm gonna rub their noses in it in the next panel. Two questions, though. One for Vanessa on the, I think you just hit it, though, on this AI point. To me, and I'm not the rule writers, and you guys will be informing the rule writers to the extent there are rules, it just seems like this is one of those areas where you go high-level principles, like trying to prescribe usages of AI. It's going to be really hard, just given the rapid rate of development. And so this notion which you tapped into, which is there's a human involved, right? If the rules today are written for humans and AI replaces humans, let's just make sure that humans are still involved, i.e. supervisory responsibilities and the like. I think if we go far past that, and at the same time, I think the second thing you said, let's make sure you're doing what you say you're doing, or your tech is doing what it says it's doing, right? And that, I remember those old days back with old OC, with high-frequency trading. It was all, let's get developers in, let's figure out the code, let's make sure the code does. And you realize once you go down that path, you can't keep it up as a regulator. So instead, why don't you disclose to me what your code does? I'll come in and test it, see if it actually does that, and if not, then you've got a deficiency. I think that model worked a lot better. I think it'll work better with AI. So, I mean, more of a comment than a question, but I do think just from a principles-based perspective, and we at Robinhood, as we look to integrate AI more and more, you read the rules, it's not incongruent with the rules. It's just a new way of doing the things and getting you guys and FINRA and the other SROs comfortable with it. So it'll be interesting to see, where you guys go with that. Mike, I had a question for you on your program.
Sure.
Which is nearer and dearer to me as a broker-dealer. So in your portfolio, you have the legacy broker-dealer exam program. Mm-hmm. How do you deploy? I mean, I know you have much more limited resources. I was on the commission when I had to educate the prior chairman about this. There was a moment where we said, too many advisors, not enough advisor examiners, less brokers, and there's FINRA. And so I can't remember what year it was. Mary Jo was the chair. We decided, let's shift the resources, right? Let's beef up, the SRO oversight program, and let's keep an important nub of broker-dealer oversight. But what's left, and how does it work day to day on the broker-dealer?
Sure. I mean, as I said before, Dan, we have several different registrant types that we're responsible for. What we do on a day-to-day basis is it's a risk-based program. And as Haynes said before, we have an Office of Risk and Strategy, so we really try to home in on what we're going to do, Dan, in terms of the amount of broker deals we're going to examine. We have linear models, we have predictive models, and we really try to focus in on those respective registrants that we feel are the riskiest. So therefore, I mean, what we're trying to do, Dan, is with a small amount of resources with 9 different registrant types, where do you spend your time? So we try to spend the time on the ones truly where we have our own remit with the only regulator, transfer agents, municipal advisors, for example, and swap dealers. But when it comes to broker-dealers, it's a coordination and collaboration with FINRA, and that's been better than ever before, Dan. Because we want to make sure we're covering the waterfront. When we have congressional budget justifications that we try to meet each and every year, we try to do as much coverage as we can, and having the SRO model gives us that ability to really focus in on the broker-dealers that we feel are the riskiest, and really looking to FINRA to really pick up the ones where we don't have the resources to cover.
And you still have those really technical, that team in Chicago, right, on the trading issues? I always remember there was a legacy there in Chicago.
We have a fixed income group. We have a fixed income group in Chicago that really focuses on those type of examinations, more market structure. We have specialized examiners who do market structure examinaminations. So it's really out of Chicago. You're right, Dan, great memory. It is out of Chicago.
Yeah, those guys are tough. When you're at the SEC, they're tough. I can't, you can imagine being on the other side of it. So, all right, thanks, guys.
Sure.
So maybe, Mike, we'll stick with you.
Sure.
What are you seeing from an AI perspective?
Yeah, I mean, when I look at the registrants, there's 5 risks that really come to mind when I look at what firms should be considering when utilizing AI. I think Vanessa touched on it. Governance is the first one. Basically, from a firm's perspective, who's utilizing within your respective firm's AI, who's in the development stage in terms of who's developing it, is it done in a sandbox, what's actually being shared with, within the firm, outside of the firm, making sure that, even the utilization of the data that you're utilizing, do you have the permission to utilize it? You have customer information, making sure you have the wherewithal to actually utilize information going into that model, and having the controls around it, to making sure that what you're saying you're doing is what you're doing with it. So that's kind of the governance risk. Then you have the monitoring risk. As with any time you have a new technology, you have a responsibility to supervise and to monitor that risk. So making sure that firms have the controls in place, the policies and procedures, and that basically it really fits to what the firm is doing. So the monitoring risk is something that you need to consider. The third one is the privacy risk. As I said before, you have a responsibility to safeguard customer information. The utilization of customer information requires making sure that you have the permissions to utilizing it, whether internally or through your third-party vendor. You want to make sure that you have the permissions in place, so the privacy risk is something you want to consider. And then the last 2 is bias risk. And as you've heard time and time again, the model is going to basically give output based on the input. So depending on what the inputs are into that model, you always have to consider the possibility of bias risk. Is it really giving you the information that you intended? And that's all goes back to the monitoring risk. And lastly, is the hallucination risk. You've heard time, and I'm sure you've read many articles with regard to AI and what it can produce. It sounds great on the output, but is it truly, that's kind of, you talked about the human in the middle. And Dan, I know you had mentioned it, and Vanessa, that's having that kind of other set of eyes, meaning, are you getting the output that's expected? And that hallucination sometimes is, it looks really great, but is it really truly accurate? And making sure that you're really addressing all those 5 risks are critically important. And last but not least, it's conflict of interest. As with any time you're basically giving information to customers or utilizing it, the consideration is your duty of loyalty, your duty of care. Whether it's AI or any other technology, you still have those responsibilities.
Thanks, Mike. And I think all those points, especially Commissioner Gallagher's point about, we in exams, we inform policy, we don't make policy. And so a huge part of this is ensuring that we're staying tied in with those policy divisions. So, Hayne, I know you were very heavily involved with the AI roundtable that we have. Can you talk a little bit about what we were hoping to learn from that discussion and kind of what we did and what happened?
Yeah, so the commission was particularly interested in hearing about how the financial industry is thinking about and currently using AI, but particularly the generative, the more advanced AI, including what sort of governance was in place and what's anticipated in the future, the benefits and risks of using AI in financial products and services, including some of the risks that Mike flagged, the impact and potential impacts of AI advancements on fraud and cybersecurity are near and dear to Alexis's heart, and then, given the commission's tech-neutral or agnostic approach to regulation and the disclosure-based regime, the desire to avoid impeding innovation, whether there is need for guidance or regulatory gaps. And these are sort of going to the points that Commissioner Gallagher made. And the commission also flagged the benefits with these sorts of roundtables, right? Engaging with the industry, academics, investor advocates directly on their experiences, which we often see in exams, pays a lot of dividends.
Yeah, and in case anybody's interested in watching the roundtable, I think it can be found on scdc.gov. Obviously, we talked a little bit about a few anniversaries. Mike, next week will mark the 1 year since the standard settlement cycle for most broker-dealer transactions in the U.S. was shortened to 2 business days. after the trade date to 1 business day, which we refer to as T+1. I'm sure you're going to miss being on call all Memorial Day weekend like I will this coming weekend, but from your team's perspective, how did that transition go?
Keith, I think it went really well. I mean, there were a few, maybe a few little bumps along the road, but when you look at where we are today and you look at the volatility in the markets, I think it was a great success. It went quite smoothly. As you said, I felt like the Maytag repairman waiting for the phone to ring, and it never did ring, which was great. You always want to see that when you roll out something like a change in the settlement cycle. Putting that aside, it's a testament to the coordination and collaboration with all the registrants, the clearing agencies, the other regulators, FINRA, and the banking regulators, truly making sure that it was a coordinated effort across the board. So all in all, Keith, it went very smoothly.
I think that's absolutely right. And then next month will be 5 years since Reg BI took effect. What are you seeing on your Reg BI examinations, and are you seeing improvements from firms?
Yeah, I can't believe it's 5 years, Keith. That was a monumental change in our rules from a sales practice perspective when you look at regulation best interest. Looking back 5 years, it was really, we had kind of an implementation phase whereby we went out and really made sure that firms understood the requirements. There were 4 standards that need to be adhered to. And really what we're seeing at the front end was more policies and procedures, not being compliant, kind of switching out the word suitability for best interest, which really is not really what the intent was. But then also seeing procedures not being implemented and the conflicts not being identified or remediated or mitigated. I think what you see today more, and our focus has really moved to the care obligation, making sure that for customers that recommendations are being made in the best interest of investors. That's where we're focusing in on products, business lines that may fall within the regulation best interest. But I will say, to the industry's credit, we have seen marked improvements over 5 years, Keith. Really have seen firms embracing regulation best interest, truly you hear about reasonably available alternatives. That's kind of the buzzword you hear in time and time again. And firms having systems in place, procedures in place, what they expect of their registered individuals. So truly moving in the right direction, and a credit to the registrants.
Can I just jump in on that and say, I think Reg BI has been a complete and absolute success for the agency. The process that was gone through, the rulemaking process, the roundtables, everything that led into it, the implementation, the oversight, the coordination with FINRA, and being on the receiving end of that, I can say it's very thoughtful. The rule's knowable. It's much less, don't get upset with me, Vanessa, less squishy than the fiduciary duty, and we're only newly an advisor, so I'm getting used to that one. But I'm used to having big rule sets, and it works. I mean, it might not be great. It's onerous to comply with it. If you want to make a recommendation, you better have it right and be ready for it. But anyway, I just think that is, if you look back, when I was at the commission, the debates on fiduciary duty and DOL, I mean, it was such a mess. And to go from that to where we are right now is just terrific. Hopefully, the PDA rule will die its due death here soon, and that won't complicate it, because that was essentially relitigating Reg BI under the guise of some silly technology rules. So that was the only thing that worried me there at the waning hours of that last administration. But I give you lots of credit for the implementation side of it.
So sticking with anniversary, so hard to believe, but almost 10 years. Nothing exploded in here.
Let's hope not.
Very loud. 10 years since regulation SCI was passed, and which was designed, among other things, to increase capacity and availability and resilience of our critical market infrastructure. So maybe, Alexis, if you want to talk a little bit about what TCB is doing with respect to SCI.
Sure. Well, we're certainly keeping busy in this space, and we're paying particular attention to policies and procedures regarding the operational, business continuity planning, and testing practices of SCI entities, as well as policies and procedures pertaining to the security operations management tool employed by these registrants. I'll also highlight that we're working on a series of exams that we're calling the DISCO-RICO thematic, and that sounds far more exciting than it is. It really just stands for Disconnect, Reconnect. And here we're focusing on policies and procedures pertaining to the decision to disconnect from or reconnect to another registrant or third party that's experiencing a cyber event.
I like Disco Rico. That's a good. You all love to come up with those names. So maybe we'll transition, in addition to performing compliance examinations, the exam division also helps registrants understand the impact of new rules to help them identify necessary changes to their compliance program. We talked a little bit about T+1, Mike, but can you talk a little bit of how we engage with the industry as part of the T+1 rollout?
Sure. I think what made it successful was the outreaches and really the meetings that we had internally and externally. We went out and actually did some readiness examinations of some of our registrants. And this was a great example of not going out to find violations of rules. It was really to go out to assess the readiness of registrants, find out what their pain points were. As Keith said earlier, one of the things we do is inform policy. So the more that we can take intelligence back to our Division of Trading and Markets, the more meaningful we can give guidance out there. And you look at what we did, we issued a risk alert in March of 2024 to basically share with the registrants as to some of our observations, things that they should consider. So all in all, Keith, I found it to be great planning and leads to great results. And a lot of interaction, a lot of communication with the registrants made it a success.
That's great. And Alexis, the compliance date for SP is coming up later this year. What is the team doing in order to assist registrants with compliance?
So we, in coordination with staff from the Divisions of Trading and Market and Investment Management, are hosting a series of 3 tailored outreach events to promote readiness and assist firms in their preparedness to implement these new amendments to Regulation SP. Among other topics, we'll cover basics about what to expect when interacting with an exam team during an examination where Reg SP is in scope, as well as having a broader discussion about our approach. As the 2 compliance dates set forth in the amendment's approach, we may inquire about registrant preparations to ensure compliance following the compliance date. Of course, these inquiries are not directed at citing registrants for potential noncompliance with the requirements that are not yet in effect, but are intended to inform staff of where registrants are in the process of implementation. To the extent that staff identifies trends or risk relevant across the sector or within a specific registrant population, we will communicate, or we could communicate, these anonymized observations through a risk alert or some other publication to assist registrants in coming into compliance by the respective compliance dates.
So another large undertaking, Vanessa, about 5 years ago, the commission modernized rules that govern investment advisors, advertisements, and compensation to solicitors, which was a big undertaking since neither rule had been amended significantly since their adoption more than 40 years ago. Any updates for marketing rule examinations?
Sure. Well, as you can imagine, the marketing rule was, as you say, it was a huge undertaking, and not just for, understandably, all of our registrants who are subject to the marketing rule, but it was a huge undertaking for the staff as well to gear up for the implementation dates, the compliance date of November of 2022, and to kind of assist with registrants beginning to comply with the marketing rule. We've had a series of risk alerts that we've published to assist in that matter. The first one was the examinations focused on the new investment advisor marketing rule. Sorry, we don't have such catchy names with these risk alerts. They kind of are what they are. And that one was published in September 19th of 2022. And that focused on policies and procedures, the substantiation requirement, performance advertising, and the books and records requirements with regards to the new marketing rule. I should stop calling it new since it was in 2022, although we still are releasing risk alerts. So the second one was entitled Examinations Focused on Additional Areas of the Advisor Marketing Rule. Again, very catchy title, June 2023, and that one focused on emphasizing the compliance with the marketing's rule, general prohibitions, which with marketing practices, and further identified additional areas that the staff had concerns with regards to testimonials and endorsements. The third risk alert, initial observations regarding investment advisors Act marketing rule compliance, was in April 17th in 2024. And this one highlighted compliance findings and concerns with regards to 20647, the compliance rule, 2042, the Books and Records Rule, and Marketing Rules General Prohibitions. And we understand that the marketing rule has some definitely conversations around it with many firms, and both inside and outside of the agency. And so investment management group, our investment management rulemaking group has issued several FAQs relating to the adoption and amendments of the marketing rule. And you can find those on the internet as well. You might find those helpful if you haven't already looked into those.
Maybe we'll ask Alexis and the TCP team to help with those, making those names a little bit more snazzy.
Yes,
moving
yes.
forward.
Disco, RICO sounds a lot better.
So any recent observations for marketing rule exams?
In addition to some of the observations that we listed in the 3 risk alerts, some of the focuses have been on, as you might imagine, testimonials, endorsements, third-party ratings, performance advertising, and most recently, the IM guidance on extracted performance. We've identified a variety of different findings and advertisement types, including websites, pitch books, or pitch decks, presentations, and other materials that typically provided to prospective clients.
Thanks, Vanessa. So let's turn back to Adam to talk a little bit about municipal securities. What should municipal advisor firms expect from exams that may be different from what they have experienced before, and what issues may continue to be part of exams?
Sure. So I think I talked a little bit about this last year, but it's sort of ongoing and evolving, is that in the first several years of the first dozen or so, I guess, years of the municipal advisor rule and registration system, exams were mostly focused on registration compliance, maintaining registration, written supervisory procedures, all of that kind of stuff. And now we've been working with exams to sort of include more substantive conduct examinations. So examples of that could be, municipal advisor participation in pricing, what they're recommending in terms of method of sale, fiduciary duty compliance in their interactions with municipal entities. Now, the registration and documentation issues still do remain, so you'll still see, written supervisory procedures. Are you filing your annual updates all the time, and amendments when they need to be? Off-channel communications is another newer thing that's sort of and conflicts of interest. The other thing that I just want to point out is that we do have OMS does now have a system set up where we are reminding municipal advisory firms of, filing deadlines for these forms, and possibly, if you've missed a deadline, sending a ping reminder as well. So we are sort of moving toward more seamless compliance on that front.
And what about firms registered as BDs, IAs, and other regulated entities that participate in the municipal markets?
So particularly for duly registered firms, that may be BDMA, BDIA, IAMA, et cetera, to focus on, what side of the shop your individual people are working on, if they're doing municipal advisory work, are they qualified as a municipal advisor representative? If they're doing broker-dealer work, are they qualified as a BD representative, et cetera, et cetera. So making sure that there's not too much bleed over in activities. And we talk a lot about these dual registration issues at our compliance conferences, which we do jointly with exams as well as MSRB and FINRA. We had one last November. Those videos are on our website if you want more detailed, granular compliance stuff. And we'll have another one coming this November as well.
Thanks, Adam. We'll turn now to some of the operational aspects of the exams division and talk about what firms can expect during an exam. In our workshop later today, we'll discuss the general exam experience, including effective communication and production practices, and what to expect throughout the course of the entire examination process. Vanessa, the division has said that examination process is risk-based. What are some of the factors that are considered before selecting firms for an examination?
Well, there's definitely several factors that we look at when we're selecting a firm. It's definitely risk-based, and we look to our examination staff as well, who have kind of like what we always say, the boots on the ground intelligence, as well as Haynes Group and risk strategies. So in addition to those, you might imagine that our examination may be selected, or your firms may be selected by statutory mandate, their risk profile, and typically that is determined by the filings that we receive. Tip, complaint, or referral, what we consider our TCRs, just because we like acronyms. Episodic events, such as flash crash, 2008, those types of events could lead to an examination. We have thematic reviews. In addition to that, there is a review of compliance risk areas that we have highlighted every year in our annual priorities. And so, you know, those are just a few of the things that we look to. Typically, we will not on-site tell a firm exactly why they're selected for an examination. But I always like to have open dialogue with firms, and typically you can kind of ascertain what we're looking for by the questions that were asked. So I always invite firms to you know, openly have dialogue with exam teams, and you know, to kind of understand the requests that we've made. We don't have gotcha exams, and so you know, open communication is the best way to communicate with the staff, even though we might not specifically say what type of an exam or what was the reason why examination was commenced.
So, Mike, we'll pivot to you. What are some best practices you observed by firms in handling the exam process?
Sure. Excuse me. Thank you, Keith. I mean, a few things I think in terms of a best practices, first and foremost, depending on the size of your firm, is to have a designated individual who will basically interacting with the examination team. I think it's important. It leads to continuity. It leads to making sure that all requests are being handled in the right manner, and you're getting the right individuals available. I also will implore firms to maximize your day one meeting. We will announce an examination. We will usually have a day one meeting, and having the right individuals, it's really an opportunity for the registrant to demonstrate to the examiners any changes to the firm. They know the firm best. And at that juncture, we have not really decided on how much testing we need to do. It's really a good opportunity to really inform the examination team of changes to senior management, changes to business lines. As much as we know the registrant, you know the registrant, you know, best in terms of the individuals there. Next one is just managing our request. We did issue a risk alert about a year or so ago, excuse me, with regard to what to expect on an examination, but clearly managing those requests and making sure that you kind of have a timeline set with that examination team. I think the biggest frustration is when timelines come and go and there's no dialogue or communication. So, which leads me to my last point, which is having open lines of communication with the examination team. I can't stress that enough. By all means, having, you know, whether it's status meetings, making sure that, you know, that you're getting what you need and there's no surprises. The last thing we want to do is we will never go to an exit with a surprise. We don't want to surprise you. We don't want to surprise your senior management. And the more that we can have that open lines of communication, I think is critically important throughout the examination process.
Thanks, Mike. We'll bring Scott back into the conversation. OCR is also responsible for oversight and examinations. Can you briefly discuss the exams that your office conducts?
Sure, Keith. So our office oversees credit rating agencies that are registered with the Commission as nationally recognized statistical rating organizations. We call them NRSROs for short. Currently, we oversee 10 NRSROs, and they range in size from very large and complex organizations to smaller, more niche organizations. And just give you a sense of the variety, one of our smaller registrants has about 5 analysts, and they're very focused on the insurance industry, issuing ratings there, while the bigger firms could have 1,500 or more analysts each, and they issue ratings in everything from insurance to corporates to structured finance and everything in between. So a lot of variety there in the size and scope of the firms. However, despite the size of the firm or what they're issuing ratings in, we examine each of our registrants every year. So we're required by mandate to examine annually, each registrant. And we're also required to include 8 mandatory areas in each exam. Now, those mandatory areas tend to be pretty broad, so what we do then is we risk assess to get into exactly what we want to look at. So things we think about when we're risk assessing include if there's changes at the firm, operational-wise, or if they've changed their policies, procedures, or their controls, we might want to take a look at that. If there's issuance trends that are interesting or kind of a hot market, we might want to look at that. Or even performance issues in a particular sector might be something we'd want to look at also. So then once we've scoped the exam, it's pretty similar to other types of exams where we'll request documents, we'll interview the staff from the rating agencies, and then determine if there's any findings. We'll communicate that to the firm at the end of the exam cycle. We do spend a lot of time typically looking at rating files, so specific actions that the firms have taken to determine if they've adhered to their methodologies, if they've made all the appropriate disclosures, and they've documented things they were supposed to document. So that's typical quick overview of our exam program.
Thanks, Scott. And I think I have a vague recollection from reading Dodd-Frank 15 years ago that there's a prohibition on regulating the substance of the credit ratings and the methodologies by which the ratings are determined. Can you talk a little bit about how that prohibition impacts the exams?
Yeah, so that's interesting. So not everybody always understands that, but our exams aren't designed to evaluate the content of the NRSO's methodologies or the substance of their ratings. It's not part of our program to determine whether we agree or disagree with the methodology or with a particular rating. Our regulatory regime is really based on disclosures and adherence to the NRSO's rating process. And so what that does, it allows users of credit ratings to do their due diligence and decide which rating agencies have methodologies that are sufficiently robust to meet their needs and which are issuing ratings that they feel can be relied upon. And so as you probably guessed, there's a lot of different opinions on credit, and they range depending on who's looking at it and what the methodology looks like. So it's not a one-size-fits-all. So it's really incumbent on users of ratings to decide which rating agencies best fit their needs.
Thanks, Scott. So I think we're nearing the end of the panel, so I want to briefly shift to what the future may hold. So maybe I'll just go to Vanessa and Mike, and then Adam and Scott. Anything from IIC's perspective on the future?
The future is more exams. Well, in all seriousness, we're obviously still working through our 2025 priorities, all while simultaneously and taking a lot of information to work on our 2026 priorities, which again, hopefully will be sometime at the beginning of next fiscal year to align with our planning. I mean, we have perennial items in which we look at. To quote Dan, we are firmly in the squishy fiduciary duty space. And so we will definitely look to continue looking at disclosures, conflicts of interest, fee arrangements, again, emphasizing the fact that, do what you say what you do, is our kind of tenet. And fiduciary duty encompasses, I'd say, a lot of disclosures with regards to anything that might impact the investor. I like to think at the end of the day, we're on the same side when we're looking out for clients. Our interests are aligned in that regards, and so with regards to the squishy fiduciary duty, we'll be continuing to look to protect investors and make sure that all the disclosures are appropriate.
Mike, brief thoughts?
Oh, sure. Briefly, retail investors, protection of retail investors will continue to be the focus of our examination program. As I said before, Regulation Best Interest has 4 standards. We'll continue to examine against those 4 standards. And lastly, our financial responsibility rules, really in terms of adequacy of net capital at our registrants to continue operating. And secondly, basically that customers' assets are being protected under the reserve formula, where we'll do the calculation to ensure that those assets are being properly segregated. And for the most part, as I said before, it's all about protecting investors, Keith.
Thanks, Mike. Adam, any very brief thoughts?
Sure. So one of the things we're going to continue, our office is continuing to focus on is the prevalence of unregistered municipal advisory activity. We've published bulletins and our director has given speeches on some sectors there, which are available on our website. We receive a lot of requests for guidance and relief that we continue to consider. And from a compliance perspective, just lastly, I will plug our conference that I mentioned earlier, which this year will be November 18th and 19th virtually.
Thanks, Adam. Scott, I think we probably have about 10 seconds before the Oscar music comes.
I'll make it quick. So our exams are currently underway. One of those areas that we look at is governance, so our teams are talking with the board of directors about certain responsibilities that fall under their oversight. And then once that's done, we'll start looking at the information that's been collected, and if there's any findings, we'll communicate those to the firm. So that's it.
Great, and I want to note that we're at time, and I first wanted to thank Commissioner Gallagher for the questions, comments, and insights. I'm glad you're able to join us this year, and thank the panelists for their participation. It's always interesting to hear how you frame and think about the work, and particularly Adam and Scott. And I know we have some workshops later for the exams workshop. It's going to be at 420 in Salon 14. Hope to see you there. Thank you all.
So just a reminder, we're on break until 2:55 when we'll resume with trading and markets.
Good afternoon. So we are already at our last panel of the day before we head into the workshop portion of the program. I did tell the panelists that this morning I said that the Corp Fin panel would be probably everyone's favorite. They said that they weren't going to challenge me on that, but you know, who knows what might happen. But I'm very excited to welcome this panel today. The final panel will actually be led by the Acting Director of the Division of Trading and Markets, David Saltiel. In addition to his acting role, David also leads the Office of Analytics and Research in Trading and Markets, which is responsible for leading the quantitative and qualitative research and analysis related to SEC's policies on markets and market structure. He will be joined by other senior staff from the division. And I'm also pleased to be welcoming back former Commissioners Gallagher and Roisman to provide commentary for this panel, which I'm sure will be lively. So thank you very much. Remember, before starting this panel, I ask that you consider the comments of this session's panelists. Thank you.
Thank you, Cicely. And just start by encouraging Commissioners Roisman and Gallagher not to be too lively.
I can control them.
So I just want to say about Cicely, there's a lot of challenges with being the acting anything, but one of the rewards is working with acting directors like Cicely and Sam. So that has been a real pleasure and part of what I've enjoyed in this role. Before I begin, I am contractually obligated to make the usual disclaimer, and I'll make it on behalf of all of my colleagues so that they do not have to repeat it. The SEC, as a matter of policy, disclaims the statements of staff. The statements we make today represent our individual views and not the views of anyone else on the staff or of the commissioners or of the commission, which all makes this sound rather boring, but many of you are aware that a number of TM staff have departed the agency over the last few months, including some who have been part of this panel at prior SEC Speaks events. In some cases, these departures may mean that the individual who market participants knew as an expert in a particular space is no longer at the commission. However, I want to assure you that TM has a very deep bench. Despite the departures, I'm really fortunate to work with staff with broad expertise and a dedication to the SEC's mission. And as market participants work with the division in the future, you will all have the opportunity to get to know staff that you may not have worked with much in the past. I'm confident that when you do, you'll be as impressed as I am with how skilled and hardworking staff in the division are. On that note, I want to use this event as an opportunity to issue an open invitation to all market participants. Please come talk to us. We are happy to see you in person. We're happy to see you on video. We're good at both now. We're happy to talk to you, of course, when you have a specific topic or concern, but I would also like to encourage market participants to make it a practice to come in and meet with TM staff on a regular basis, even when you don't have a specific topic or concern. Come in and talk to us about emerging trends in markets. Come in and tell us what you're hearing from your clients. This type of interaction is really crucial for us. These perspectives make us better policymakers, and they allow us to provide more informed advice to the Commission. It's something that I believe is a key part of our job. So please let us know when you're in town. Please come see us. Over the past several years, a lot of the focus of these events and the TM panels has been on rulemaking, and likely next year we'll be spending time talking about some of the rulemaking priorities of Chairman Atkins. But this focus on rulemaking may have obscured the fact that the Division of Trading and Markets has a broad set of responsibilities and roles that have nothing to do with the promulgation of new rules. I think of the division work basically broken up into three categories that you'll hear about today. And really, this is the bulk of the activity of the division. We do rulemaking on nights and weekends, and we do the rest of this work on our day job. First, the division's engaged in monitoring, oversight, and supervision of markets and market participants. Every day, we engage with broker-dealers and clearing agencies on issues related to financial risk management. We conduct research and analysis on market events and emerging trends. Second, the division reviews thousands of self-regulatory organization proposed rule changes, advance notices, applications to be a clearing agency, applications to be an exchange. Those are popular categories right now. And all of these are subject to statutory deadlines, and many of them raise novel and complex issues. Third, the division implements and oversees existing SEC rules. These include responding to interpretive requests and requests for relief. I think this is an area that I expect you'll hear a lot about today from my colleagues. All of these functions, of course, inform any rulemaking activities that the chairman may direct, but they're crucial aspects of the division's day-to-day work, and they stand on their own and they play a key role in the division's maintenance of fair, orderly, and efficient markets. I want to take this opportunity to say thank you to the whole TM team for their professionalism and commitment to public service. I think you see it every day, and I know none of them are here today, but I do want to thank them for all their work. Turning now to some more specific updates, we're going to organize today's session as follows. I'm going to kick off the program by talking about some of the activities of the division's Office of Analytics and Research, which I continue to head. I'll then speak about the work of the Office of Derivatives Policy and Trading Practices on behalf of Carol McGee, the Associate Director in charge of that office. I'll turn the program over to Andrea Orr, the division's head of the Office of Legal Review, to talk about the work of her office, and also to talk about the Office of Market Supervision on behalf of that office's Associate Director, Eric Uzenis. Jeff Mooney, the Associate Director in charge of the Office of Clearance and Settlement, will speak next, followed by John Fahey, the division's Deputy Chief Counsel, and finally Mike Macchiaroli, the Associate Director in charge of the Office of Broker-Dealer Finance, and making his 105th appearance at the SEC Speaks, will close us out. We're fortunate today to be joined by former Commissioners Elad Roisman and Dan Gallagher, both of whom I welcome to add their thoughts on any topics or ask any questions along the way, as long as they're not directed at me. For those of you who are not familiar with TM's Office of Analytics and Research, or OR, OR is made up of some of the Commission's most skilled quantitative analysts, market structure experts, and staff with deep industry expertise. OR staff conduct applied research to inform policymaking in the equities, options, corporate fixed income, treasury, security-based swap, and digital asset markets. OR is also responsible for the maintenance of the Commission's access to market data via the MIDAS platform that provides the Commission in near real time with the ability to see markets from the same perspective as market participants. Over the past year, OR staff has used this data to provide the Commission with innovative tools that provide insight into market functioning and play a key role in evaluating policy choices. OR staff also provide data and tools based on this market data to the public via the Commission's market structure website. As always, we welcome feedback on how this data could be more useful, and we encourage commenters to use this data when providing feedback on policy proposals. Empirically based comment letters are particularly helpful to the division. OR staff use this market and other regulatory data to support a number of the initiatives you'll hear about from my colleagues today, including the evaluation of SRO proposed rule changes and analysis to inform the direction of security-based swap policy. OR is also examining longer-term trends in our markets, such as 24-hour trading, the growth of low-price stocks, and how the Commission should think about the use of AI in exchange operations. As we look to the future, OR staff are also considering how to incorporate AI into our own work to continue to further the Commission's mission. As I noted earlier, OR staff always appreciate the opportunity to meet with market participants, particularly those engaged in technology and data efforts that we could learn from. I'll turn now to the Office of Derivatives Policy and Trading Practices. Carol McGee, the Associate Director over this office, couldn't be here today because she's meeting with our foreign counterparts to discuss substituted compliance of non-U.S. security-based swap dealers. For those who aren't familiar with it, substituted compliance is a novel approach to address inherently global, multi-trillion-dollar market in a way that reduces burdens on market participants while remaining true to our mission. Since I mentioned substitute compliance, I'll start with the Office of Derivatives Policy, and in particular, FAQs that they recently issued related to security-based swap reporting. My colleague Andrea Orr will discuss the Commission's recent compliance statement related to this reporting regime in a moment. I'm going to focus on some of the observations that this office has had related to data quality. We publish a biannual report on the SBS market, and we include an appendix of data quality issues in that report. But another way that we try to alert market participants to data quality issues is through FAQs. I'll mention two that we issued in May of last year. The first has to do with zero notionals, or reports where the notional value of a transaction goes down to zero and then is amended to a larger amount and then amended back to zero. An amendment to zero notional is a termination and needs to be reported as such. Subsequent transactions are new transactions. We've also seen issues with pricing and payment data for credit default swaps, where the report includes only one of the following data elements: fixed rate, spread, or other payment type upfront. That's incomplete. All pricing information must be reported in the reporting of security-based swaps. While I'm talking about FAQs, I'll also mention that the staff issued 2 sets of FAQs in May related to non-US security-based swap dealers. One related to CCO reports relying on substituted compliance, where we've received reports with important information that's redacted and thus not in line with the conditions of substituted compliance orders. We've also had issues with legal opinions provided by non-US security-based swap dealers. In short, the opinions are so caveated that they do not actually provide an opinion. The FAQ addresses that issue. Turning now to the other side of Carol's office, trading practices, I'll mention 2 rules that are set to go live before the next SEC speaks, and I'll also mention some relief related to Rule 15C to 11. First, Rule 13F2, which requires institutional investment managers that meet or exceed certain thresholds to report short position data and short activity data for equity securities, and contemplates that the Commission will aggregate that data by security and make it public. The Commission recently extended the compliance date for this rule, and as a result, the first reports are now due on February 14th, 2026. Second, Rule 10C1A requires the reporting of security loans to FINRA. This rule also requires FINRA to make certain information public. Under that rule, FINRA has filed a proposed rule change to affect this reporting regime. The Commission approved that filing on January 2nd, 2025. However, FINRA has requested an extension of those dates, and staff is currently considering that request. And finally, Rule 15C to 11. You may recall that the Commission adopted amendments to Rule 15C to 11 in 2020. Before those amendments went live, the staff issued some temporary relief for fixed income securities. And more recently, the Commission issued an exemptive order that provided an exemption for fixed income securities offered and sold pursuant to Rule 144A, followed in November of 2024 by additional no-action relief for certain fixed income securities. Staff are aware that there's an interest in additional relief related to this rule, and we're currently considering next steps. I'll turn the microphone over to Andrea Orr in a moment to discuss the Office of Legal Review and the Office of Market Supervision, but I'll mention one crypto topic that falls under the Office of Market Supervision before I hand off. As most of you are aware, there's a great deal of interest in spot crypto ETPs. To ensure that these products have a predictable path forward, staff are interested in working with SROs to consider the possibility of a generic listing standard for these products. Before I hand it off to Andrea, I'm interested if Commissioner Roisman or Commissioner Gallagher have any questions or comments.
I just want to say, hopefully I'm angling the microphone correctly. Thank you for that, and thank you for all of you for being here and answering questions. I do think your point on 15C211 is one that I think a lot of the market has been thankful for. This has been sort of a continual concern for many market participants of when that no-action relief was actually going to expire, if it was. It's obviously been a point of contention, in terms of its applicability to fixed income for several years. I guess the question I have is, you mentioned the outreach, which I can certainly attest. When I've had questions this year, I've gotten almost immediate responses from the staff. So I want to thank you for and your teams for that. What is the best way for folks to come in and talk to you about potential additional relief, or whether it's exemptive relief or reviewing for rulemaking?
Thanks, Commissioner. I think what I have found really helpful when we were considering the request related to fixed income is when market participants helped us understand what the specific challenges would be in some detail about meeting the requirements of 15C211, and any research that they had on the potential impacts to the underlying market. And so I think as we think about whether any additional relief is needed or what other steps the Commission might take, that level of detail is really important.
That's great.
I love Rule 15C211.
I know you do.
I think it's really interesting, though, too, right, that the omission, I guess, or just oversight is with respect to fixed income securities. I think it was at this conference, it must be more than 10 years ago, because I left 10 years ago, where I noted that in trading and markets, we had 1/2 of one full-time employee devoted to fixed income. Remember Tom? Tom, I forget.
Tom Eady.
Butler.
Yeah, and Tom Eady, yeah. Amazing guy, but he was still, half of him was devoted to fixed income, the other half was devoted to something else. So, I think, and I'm going to guess, Chairman Atkins is going to be interested in fixed income market structure and, sort of modernizing, if not the markets themselves. I don't think he would impose a new structure necessarily on them, but modernizing the rule sets. So it'll be interesting to see that, because I was just on the Division of Examinations panel, and they mentioned that in the muni side, what's changed and what's the same. What's the same is that a guy named Vinny is calling a guy named Joey, selling a bond and marking it up, and it's on the telephone. And I mean, these products are susceptible to electronic trading. Why are they not? Why are these inefficiencies still present in the markets? Electronic trading is not just good for accountability and transparency, but auditability and the like. I think it's good for investors. So, just not a question, just a comment. It'll be interesting to see how you guys make progress on the fixed income side too.
Yeah, certainly that's an area of interest of mine as well. And I think what would be really helpful, kind of picking up on Commissioner Roisman's question in that space, is to better understand what the hurdles are to more uptake of electronic trading in that market. And so we'd welcome people coming in and helping us understand that. I'd also say that we benefited a lot over the past several years from some experts who had industry experience in that market, working with the division, and it's something I hope we can continue.
We were going to get a jersey made for Tom Eady. In the back, it was going to say 0.5. For a number, it would say Eady 0.5.
He left.
I know. Now it's Eady 0, so we got to do something.
All right, Andrea?
So thank you, David. Good afternoon. Thank you to PLI and the members of the public that are here in the audience and listening online. Also want to echo David's remarks about the dedicated staff within the Division of Trading and Markets who are, I know all of us here on the panel have the honor and privilege of working with and learning from on a daily basis. A little bit about me, because this is my first time at SEC Speaks. I came to the commission in 2009. I think Dan interviewed me.
I hired you.
Yeah.
Yes, I did. At least interviewed you.
After working in private practice at a broker-dealer and a self-regulatory organization's general counsel's office. And while at the commission, I've worked in a variety of capacities within TM and within the SEC. A little bit about my office. I head the TM Legal Review Office, as David said. It's a relatively new office as compared to my fellow colleagues on the panel. I am fortunate to lead an exceptionally talented, hardworking, multidisciplinary team. My office has the good fortune to work with all of the offices across trading and markets, other divisions and offices, within the agency, the commissioners, and external stakeholders. My office performs legal review of significant TM work product, including all of the items that will be considered by the commission. We try to increase efficiency in our work processes in particular identifying legal issues at an early stage before a document leaves the division and identifying any common issues across TM work. With that, I will say a little bit regarding the Office of Market Supervision. Eric Huzenes, as David mentioned, could not be here today. He heads that office, but I have the pleasure of highlighting a few of the many accomplishments from that office, in particular, some of them since the last SEC Speaks. So I'm going to start with Rule 605. A bit of an overview. Rule 605 of Regulation NMS requires market centers, such as wholesalers, alternative trading systems, and exchanges, to provide monthly public disclosure of standardized order execution quality information for execution of covered orders in NMS stocks. In March of 2024, the Commission adopted rule amendments to expand the scope of reporting entities subject to Rule 605 to include larger customer-facing broker-dealers, modify the categorization and content of order information reported under that rule, and require reporting entities to produce a summary report of execution quality. The amendments to Rule 605 received widespread support and engagement from commenters, as well as unanimous support from the Commission. But the work did not stop at adoption. Staff continues to actively engage with market participants on implementation questions. As we approach the implementation deadline of December 2025, we expect that there will be additional opportunities for the public and industry to engage in the implementation process. For example, we expect the Rule 605 NMS plan participants will file an amendment to the Rule 605 NMS plan to address certain technical elements of the amended rule, which will be published for notice and comment and provide another touch point for commenter engagement. In addition, staff expects to issue a draft schema for summary 605 reports and will also request public comment. Although we aim to strike the right balance between affording reporting entities sufficient time to comply with the new rules and making the updated 605 information available to the public in a timely manner, we will continue to consider whether the current implementation timetable remains appropriate throughout the implementation process. I'm going to touch on Regulation SE. In November of 2023, the Commission adopted Regulation SE, which created a regime for the registration and regulation of security-based swap execution facilities, or SBS-CEFs. In adopting Reg SE, the Commission also addressed a host of issues. They addressed cross-border application of mandatory trade execution for security-based swaps, and issues that arise if a person having a U.S. nexus trades security-based swaps on foreign trading venues. It implemented a Dodd-Frank Act mandate requiring the Commission to address conflicts of interest at SBS-CEFs and exchanges that trade security-based swaps. It amended a rule to exempt from the statutory definition of an exchange certain registered clearing agencies and registered SBS-CEFs that provide a marketplace only for security-based swaps. It established a rule to affirm that an SBS-CEF is a broker and to exempt SBS-CEFs from broker requirements if certain conditions are met. It provided for the termination of previously existing exemptive relief for entities operating SBS-CEFs. And it also amended certain Commission rules of practice and certain delegations of authority to the Director of Trading and Markets. In August of 2024, the Commission received applications from 8 entities seeking to register SBS-CEFs. And in January of this year, the commission approve the registration of those SBSF applicants. I will also briefly touch on, as David mentioned, certain SBSR relief extension that we recently issued. In April of this year, the commission extended by 4 years until November 5th, 2029, a compliance statement that facilitates harmonized transaction reporting for swap and security-based swap transactions. The compliance statement generally provides that if a registered swap data repository and its participants follow the CFTC's swap reporting and public dissemination protocols and apply those protocols to the SEC's security-based swap reporting requirements, there will not be a basis for a commission enforcement action with respect to certain provisions of Regulation SBSR that differ from the CFTC's reporting and dissemination rules. The statement recognized the broad overlap in swap and security-based swap market participants and the time and costs that may be incurred by market participants to implement aspects of this SEC's reporting rule that have no analog in or are not wholly consistent with the CFTC's rule. The extension provides the Commission with additional time to consider whether changes would be appropriate to more fully harmonize the Commission's security-based swap reporting rules with the CFTC's swap and swap data repository rules. Lastly, just to touch upon, highlight a few proposed rule changes, since David mentioned some. Since 2024, the Commission has approved the listing and trading of various spot Bitcoin and Ether exchange-traded products, or ETPs. The Commission has also approved the listing and trading of options on Bitcoin and Ether ETPs. The Commission continues to review incoming proposals from the exchanges for the listing and trading of spot crypto ETPs and options on crypto ETPs. And with that, I will turn it over back to David, but I will note Commissioner Peirce earlier today recognized a milestone, and I think since the last time we met, TM had a milestone. We turned 90, so we are coming up on our 91st birthday. So with that.
Thanks, Andrea. Commissioners, any questions or comments?
There's a lot of data, a lot of detail there. I'm still going through it in my head, Andrea.
Fair enough.
Just kidding. No questions from me.
Okay. Jeff Mooney.
Thanks, David. Good afternoon. I'm Jeff Mooney. I'm the Associate Director for the Office of Clearance and Settlement. We administer the Commission's program under Section 17A of the Exchange Act to facilitate a national linked and coordinated clearance and settlement system. Essentially, we're the office that regulates the central counterparties, central securities depositories, transfer agents, as well as swap data repositories. And since we're talking birthdays, Section 17A's 50th birthday will be coming up in June. Today, I'm going to discuss two clearance and settlement topics. First, I'm going to provide a recap on the successful transition to a T+1 settlement cycle last year. Second, I'm going to provide an overview and an update on the status of the Commission's Treasury clearing rules. So on May 28th of last year, the U.S. securities industry successfully shortened the settlement cycle for most securities transactions to T+1. Canada, Mexico, Argentina, Jamaica, and for cross-listed issues, Peru successfully joined us in the move. The Commission and market participants first identified the potential benefits of shortening the settlement cycle to T+1 in the aftermath of the 1987 market break. But it wasn't until 1993 that the Commission first established the standard settlement cycle of T3, and then shorten the settlement cycle to T2 in September of 2017. In those previous initiatives to shorten the settlement cycle, the Commission adopted a single rule that only focused on the street side, that is the broker-dealer market side of the transaction. However, this time, the Commission adopted several additional rules directed specifically at enhancing the processing, the customer side of institutional transactions in three important ways. First, by requiring broker-dealers to have contracts or policies and procedures that help facilitate same-day affirmation. Second, by establishing record-keeping requirements for investment advisors in connection with the confirmation and affirmation process. And finally, by directing certain clearing agencies to facilitate and report on the constituents' progress in achieving straight-through processing. So straight-through processing is the automation of a trade process without any manual intervention. Throughout the months leading up to the transition to T+1, SEC staff established recurring touch points for monitoring the industry's progress on implementation. This engagement included coordination with the clearing agencies, of course, but also a full calendar of meetings and calls with impacted broker-dealers, banks, asset managers, service providers, and industry groups. In addition, we worked very closely with the staff from the Federal Reserve. We also reached out to colleagues in regulatory agencies around the world, both in bilateral discussions as well as through the staff's participation in multilateral organizations like CPMI and IASCA. During the weekend before the transition to T+1 and over the course of the conversion week, we were in close communication with the industry's T+1 command center established by SIFMA, ICI, and DTCC. We tracked key metrics from DTC, including same-day affirmation and settlement fails rates. We had regular check-ins as technology and new time schedules were being deployed by market participants. We kept an eye on the potential for liquidity constraints and operational challenges, especially related to FX, stock loans and recalls, volumes related to the double settlement date that Wednesday, and additional volumes on that Friday at the end of the month. We also had a series of calls with other jurisdictions, notably the Canadians, Mexico, Argentina, as these jurisdictions transitioned to T+1 a day before us. So we're almost to the first anniversary of the transition to T+1, and the settlement process continues to operate smoothly. There were no spikes in the fail rates during the transition to T+1. In fact, the fails rate reported on the day when there was both the settlement for the T+2 trades and the T+1 trades were actually being settled, those fail rates were below average. The affirmation rates climbed throughout the lead up to T+1 and sort of hovered around the mid-90s. And both of these metrics have remained consistent since the transition to T+1. There's also the reduction in clearing fund requirements at the DTCC. Currently, other jurisdictions, the UK, EU, are contemplating or transitions to T+1, and Commission staff is providing technical help as appropriate. Next, I'd like to provide an update on the status of the implementation of the Commission's Treasury clearing rules. To set the stage for this discussion, I'd like to provide a brief overview of how the rules operate. First, the Treasury clearing rules establish new membership requirements for covered clearing agencies providing central counterparty services for U.S. Treasuries. Specifically under the rules, these clearing agencies must have written policies and procedures to require that their direct participants submit for clearance and settlement all eligible secondary market transactions. The definition of an eligible secondary market transaction includes all Treasury repo trades in which at least one of the counterparties is a direct member of the clearing agency. The definition also includes cash transactions involving U.S. Treasury securities by direct participants who are inter-dealer brokers, as well as those cash transactions where on one hand you have a direct participant of the clearing agency, and on the other hand there's a registered broker-dealer or a government securities broker or dealer. Some entities are excluded from the definition of eligible secondary market trade, These are natural persons, central banks, international financial institutions like the IMF and World Bank, and state and local governments. When the Commission adopted the rules in December of 2023, the Commission established a phase-in period that would have required the U.S. Treasury Securities CCP to clear all eligible secondary cash transactions by December of 31st of 2025, and the compliance date or requirement for eligible repo transactions to be June 30 of 2026. Earlier this year, the Commission extended the deadlines for compliance for about a year so that direct participants of these clearing agencies for cash transactions would be pushed back until December 31 of 2026, and the eligible repo trades to June 30 of 2027. The decision to extend the phase-in period was in response to a request by a number of industry participants as well as several industry trade groups. The trade groups identified several issues that they believed needed further consideration or further discussion. These included things like the treatment of mixed CUSIP tri-party transactions, the scope of there's an inter-affiliate exemption in the rule, and as well as the rule's potential extraterritorial scope. Another issue that the industry flagged was the need for the Commission to seek comment and fully consider a clearing agency application by CME-SC and a potential application for ICE Clear Credit. CME-SC filed its application late in 2024. The Commission published it for notice in January, and actually last month, the Commission issued an order instituting proceedings in response to a number of the comments that were received. The staff is also aware that the ICE Clear Credit has stated that it also plans to submit an application to register as a Treasury Clearing CCP. Staff invites further engagement on these issues as well as any other issues related to the implementation of the Treasury Clearing Rule. Thank you, and I'll stop there.
Thank you, Jeff. Commissioners, anything you want to follow up on?
I think it's important to note, and I think you did a very good job, Jeff, of sort of the amount of effort that went into the T+1 sort of transition. And I do want to say that, industry spent a lot of time and resources, as you know, and I think everyone appreciates, how well it went. That's not to give short shrift to all the efforts that actually went into it, because I do think that it takes a lot. The fact that, there weren't the hiccups that you mentioned is something that not always gets attention. I also think it's sort of in line with a lot of the other sort of measures the Commission has done and worked with the industry on to ensure, market integrity. We had record volumes just a month ago, and people weren't talking about severe market dislocations, fail rates. We're not talking a flash crash or things like that. And, I think it's a good example of when, the Commission had concerns. They went out to the industry, they asked, what are your preparations? What are the things that you have put in place? The staff has already created limit up, limit down, circuit breakers, and all those things actually worked. So I do want to just give credit, because I do think oftentimes, we only come to you guys when there's a real problem. But I do think that was a good example of the industry and I think the regulator working well together.
Thank you. We very much describe the initiative in the office as a team sport. So you're absolutely right. It was very much a collaborative effort across the regulators and with the industry.
Yeah, great work on T1. It's funny, right? You think back to those fun days in January of 2021 and the GameStop issues, and if anything good came out of it, I think it was, the acceleration of T1. I was telling the story earlier in the back room when I was on the Commission. I think it must have been Lou Perella. I can't remember who was the division director, came up and said, let's move to, we were at T3, let's move to T2. I was like, don't bother me until you get to T1, because you're going to move to T2 and then spend 50 more years before you get to T1. But it took something like, GameStop to accelerate it. So it turns out, of all the narratives of GameStop, payment for order flow, gamification causing those events, I can tell you, having sat there on the ground floor of that, it was the settlement cycle being too long and the rule set's not working well together. 3-3, Mike, having all your cash locked up and then a long settlement cycle.
There's nothing wrong with
It's a
that.
bad construct. Bad construct.
I agreed with what happened.
I told many congressmen to talk to you, Mike. They said it doesn't make any sense. The money's in this account and you owe the
It's
DTC,
different
it should go
pools
like
of money.
this. Yeah, exactly.
And there's debits.
Yep. Yeah, that's what I told. I
This
told
is-
them you would say that too.
This is a conflict of interest.
Anyway, so Jeff, just real fast on looking forward. I mean, I'm getting excited thinking about competition and clearing, something we just haven't had really. And the DTC does a great job, and no one's going to dispute that. But they don't really have day-to-day competition that makes you a better entity, right? And I know you've got a couple 17A applications in. You've got tokenization and other things happening on the crypto side that could be brought over into traditional securities. How are you thinking about competition coming into the space?
Sure. Well, I mean, even now, and we're familiar, there is competition broadly in the clearance and settlement space. We've got several clearing agencies serving the securities-based swaps market currently. There's at least 2. There have been times when there's been 3, possibly 4. You go way back to 17A. Each of the exchanges had their own sort of clearing facility, so to help, where there was potential competition amongst help facilitate competition among the exchanges. As I was saying, we're directed to help facilitate a linked and coordinated clearance and settlement system, comparable regulation among clearing agencies. As we were doing the Treasury clearing rule, a number of the commenters expressed an interest in or a desire to have greater competition in the Treasury market amongst central clearers. There actually in some of the comments on the CMESC application made similar comments. We're going to take all that in as we review the comments, consider the application, consider all of the, how we move forward with Treasury clearing, and include that as we make recommendations, any recommendations to the Commission going forward.
That's great. It's going to be fun to watch this space,
Yes.
Because I do think, as heard Chairman Atkins talk about crypto regulation and getting rules of the road as crypto normalizes, and as he said, I think if you have a broker trading securities next to non-securities, Mike, I'm sure you're going to weigh in on that. We're going to just push the bounds on infrastructure too. It's not just the broker model; it's clearance, settlement, custody, all these, the transfer agent rules, everything are going to come into play. And I think the DTC is trying to adapt, but I think that pace might need to pick up a bit when we see the normalizing of this new blockchain infrastructure.
I mean, even you read the preamble of 17A, one of the things that, one of the congressional findings is that new technologies, new procedures are vitally important to improve the national clearance and settlement system. So we are, again, taking that all on board.
John Fahey.
Okay, thank you. Thanks, David. Good to be here. Thank you. Good to see so many former colleagues. TM's Office of Chief Counsel continues to consider a number of recent issues related to broker-dealer status and regulation. Recent efforts include working with the Crypto Task Force to evaluate the application of broker-dealer registration and regulatory obligations to activities involving crypto, and evaluating other areas where we could provide greater clarity on the application of broker-dealer registration requirements. Echoing what others said, we have truly benefited from and welcome engagement with the industry on these issues. Since the last SEC speaks in the rulemaking area, the Commission adopted amendments to Regulation SP, which is the rule governing the treatment by certain financial institutions of non-public personal information about their customers. SP was originally adopted in 2000 and requires broker-dealers, investment companies, and investment advisors to adopt policies to safeguard customer records, requires proper disposal of consumer report information, and implements privacy policy notice and opt-out provisions. The amendments to SP apply to broker-dealers, including funding portals, investment companies, and registered investment advisors, and extend the safeguards and disposal rules to transfer agents registered with the Commission or another regulatory agency. A few highlights from the amendments. First, they require that firms adopt an incident response program reasonably designed to detect, respond to, and recover from unauthorized access to or use of customer information. The program must also include procedures to assess the nature and scope of any incident, require appropriate steps to contain and control incidents, and prevent further unauthorized access or use. The amendments require notification of affected individuals whose sensitive customer information was or is reasonably likely to have been accessed or used without authorization, and that notification must occur as soon as practicable, but no later than 30 days after the institution becomes aware that unauthorized access has occurred or is reasonably likely to have occurred. They also impose new requirements related to third-party service providers. The amendments expand the safeguard and disposal rules to cover non-public personal information a financial institution receives from another financial institution about customers of that second financial institution. In the coming months, staff in the Division of Examinations, in coordination with staff from Division of Investment Management and Trading and Markets, will host a series of 3 outreach events to help promote readiness and assist firms in their preparedness to implement these new amendments. The compliance dates for the SP amendments are December 3rd, 2025 for larger entities and June 3rd, 2026 for everyone else. And on that point, a group including SIFMA, the ICI, and the American Bankers Association has requested on April 25th that the Commission extend the compliance deadline for the amendments by 12 months, and also requested that the Commission consider targeted modifications to that rule. We also do a lot of work with FINRA and have frequent interactions with them. We put out many of their filings for comment related to sales practices issues, communications with the public, arbitration, and anti-money laundering. We expect filings may pick up a bit as FINRA considers potential rule changes related to their FINRA Forward initiative. And they have several reg notices out in that area. 2504 announces broadly the initiative. 2506 is specific to rules facilitating capital formation. 2507 on supporting modern member workplaces. And the comment periods on all of those expire between June and July. They extended the comment date on several of those. The comment period also recently closed on a FINRA proposal regarding associated persons outside activities, which would combine the existing rules governing outside business activities and private securities transactions. And we expect that Chief Counsel will be publishing some of the proposed rule changes FINRA may make stemming from these initiatives, and we look forward to receiving your comments on those. Finally, on anti-money laundering, as you may know, the Financial Action Task Force is the global standard-setting body for anti-money laundering and countering terrorist financing. The FATF sets standards for member countries and assesses the countries against the standards for compliance. They also regularly publish what are known as the black and the gray lists, which identify jurisdictions with weak measures to combat money laundering and terrorist financing. The mutual evaluation of the U.S. has begun, and that's expected to finish in 2026. Just by way of background, mutual evaluations have 2 basic components: technical compliance, which is whether you have laws on the books, and effectiveness, and that's whether the country implements the laws on the books effectively. And while the overall U.S. effort is led by the Treasury Department, we and Chief Counsel and other members of the staff expect to participate in the FATF discussions involving the U.S. securities industry. Finally, on the AML, a reminder, there's a staff bulletin we put out a while ago on the risks associated with omnibus accounts transacting in low-price securities. That bulletin highlights the particular risks associated with transactions effected through these accounts maintained for foreign financial institutions. And those include fraud, money laundering, and unregistered securities offerings. The bulletin reminds firms of their AML obligations, and while it's not new, the guidance is still good, and the activity is something that's worth keeping an eye on. It's available on the Trading Markets website section of the SEC website. And that's all from me. David, thank you.
Thanks, John. Commissioners?
You got off easy, John.
Mr. Macchiaroli.
Thank you, sir. So a brief description of Rule 15C33 so you understand the amendments. Rule 15C33 requires that a broker-dealer put in a reserve account the difference between customer-related credits and customer-related debits if the credits are greater than the debits. It does this through a weekly calculation. So credits on one side, debits on the other side. The debits are reduced by 3% in the calculation, so this requires a bigger lockup because you're reducing a netting number. Now, the Commission on 12/20/24 adopted amendments to the Customer Protection Rule to require certain broker-dealers to perform the reserve calculations daily rather than weekly as now required. In addition, however, because of there will be more calculations in effect, the Commission allowed the 3% number of reduction of debits to be reduced to 2%. Now that, in some cases, the firms have $100 billion in debits or so, so that would mean a net reduction of about $1 billion for certain people, and in other cases, somewhere between $200 to $500 million. So it is substantial. So that's money they do not have to deposit as they do now under the present rule. Now, SIFMA is always asking for more. So SIFMA asked that the period for compliance be extended 6 months after the original compliance date. They now want it to June 30th, 2026. In addition, this is a little bit complicated, has asked that deposit requirements arising from free credits that will be the next day deposited into a sweep account be allowed to be netted against the deposit required by the calculation. So you make a calculation on Monday night, and it requires $20 million into the reserve account. But in that calculation is money that's going to be swept the next day, Tuesday, into a sweep account, regulated, normally a bank sweep account. So they want that money that's deposited on Tuesday not to have to be redeposited on Wednesday into the 3-3 account. So it's logical. I'm not sure what the Commission's going to do. This is pending. These are pending issues. SIFMA also asks that certain days other than federal holidays be deemed to be non-computing days, because right now there's about 50 calculations a year. Under the new rule, there'll be around more than 200 a year, and there'll also be more periods when there's stress on the employees and whatnot. So days before Memorial Day, for example, or after Memorial Day, maybe is what they're, the kind of things they're seeking. Everything is pending. Nothing has been yet decided. I'm not sure how this will be presented to the Commission. Secondly, the Commission on 12/13/24 approved a rule amendment, was clearance of settlement, but the only thing that would in effect require all eligible secondary, all direct participants of a clearing system in effect to bring to the clearing corporation for clearance all secondary mortgage market transactions in U.S. Treasuries to which it is a counterparty. I'm not going to talk about that. I'm only going to talk about the margin requirements. That's all I care about. Now, if customer collateral, there's going to be margin requirements, a lot more than what are today, if they have all of these transactions going through the system. I'm not sure how many transactions it will be, but it includes repos as well as market transactions. There may be a lot. It could probably be a lot. So they're going to have to post collateral. Normally, they want to post customer collateral. So they'll collect it from the customer and post it. Now, if they post that collateral, that will become a 3-3 credit. So they want a debit, in effect, to offset that, so they don't have to lock it up twice, because they no longer have the money. They just gave it to the clearing corporation, so they don't want to lock it up in a 3-3 account. So the debit, we agreed, the Commission agreed that the debit could be allowed if it's segregated from the firm's accounts, in effect. So it'll be in a separate account, which if anything happens, it'll be turned back to the customers. Now, there are instances where the customer hasn't posted collateral. We give them a 1-day leeway. The firms, under the rule, can post treasuries to meet that obligation of the customer, which hasn't been done yet. Now, the firms asked for that, and the commission agreed, but they forgot to ask for cash in addition to treasuries. Now they want the cash. So they want the cash also to be considered as something where they could post the cash pending the customer settlement. Now, when they post customer securities as collateral, there's a potential 3-3 problem because you can only generally use a customer security if the customer owes you money. Now, there's no money owed here, in effect. These are transactions which are margin transactions, but there's no debit. That is, the customer owes no money to the firm. But generally, where margin is concerned, we've treated this as if it were a debit related to the amount of the margin. If the whole thing is postponed, the question is whether or not that's a possession or control problem. And again, that's an issue for the commission. The final issue is that right now, the collateral posted has to be customer by customer. So John gives me collateral, I post it, I get a debit if it's properly segregated. The firms now, there's netting going on in this system. The firms want to be able to post, rather than customer by customer, an omnibus amount. So rather than John's credit, my credit, and Dan's credit, they would just post a general credit, which is a netted number. In other words, it'll be less than the total of the three of us. The rule only allows, however, customer by customer debits. So that's, again, an issue that the commission will have to decide whether or not to allow an omnibus debit. The margin would still have to be collected from the customer, but the firm would treat that as a 3-3 credit. The other stuff would be, in effect, segregated would be actually delivered to the clearing corporation. But they want an omnibus debit, so in effect, they don't have to lock the money up twice. Finally, the commission last week issued an FAQ prepared by the Division of Trading and Markets, which answers frequently asked questions relating to crypto asset activities and distributed ledger technology. Real mouthful. And so we drafted these after much discussion and debate. They're an opening into the cryptocurrency world. They're not the last word. I'm sure the commission will do other things. But at the present time, these are indications of the direction in which the commission may be going into the future. So it's a relaxation, certainly, of some of the positions that were taken in the previous months. The commission also withdrew a 2019 statement relating to custody of crypto securities, in effect. So that has been withdrawn, and this has been issued in lieu. Okay, now one more thing. So the SEC, the commission, in effect, will require electronic filing of broker-dealer audited statements by June 30th, 2025. Now, the problem is not so much that, but the commission action will also require electronic filing on the EGDR system, which is fine. But in effect, they also wanted structured data where appropriate. Now, that was not in the 630, the structured data will not be required, will be required in the future. And so there's some folks who believe that perhaps the cost is not worth the benefit, in effect, and that commission should revisit that position. So that's all I have.
Thanks, Mike. Any questions, commissioners?
Can't resist, Mike.
And I should have mentioned that the Rule 333 forbids you to take any money out of the account unless you show that it's not needed any longer.
Is that right?
For another computation.
There are enough computations, Mike. You added one, huh? So on the 3.3, the SIFMA comments, you said the commission's going to have to take a look at those. Are you thinking technical amendments? Are you thinking about staff FAQ? What mechanism would?
You know, some of these are not, it could be done through an FAQ. They're not the kind of things that might require rule change, but that's something we have to discuss.
Okay.
Because they're not really go to the heart of the rule or anything of that sort. So it is, the extension, of course, is the
to 2026.
Yeah, to 2026. Yeah, the federal holidays, and I don't really, I mean, the workers, you can't, this enslaves people, in effect, this thing.
Daily comp, yeah.
The daily comp, and it means, in effect, that the poor bastards who do this have to do it 200 times instead of 50.
At Robin Hood, we have them locked up in a room, and it's like 200 degrees. And I feel so bad for them. They fight every day.
I don't feel bad for them.
They're not going to think that's relief, I can tell you that much.
Well, they'll be able to take off on Memorial Day.
So, Mike, on the crypto FAQs, what's the interplay between those FAQs and that special purpose broker no action letter that happened under Chairman Clayton?
That is something that has not been withdrawn. That's still extant. But whether or not the commission will do something further on custody is the question. In other words, it may make that irrelevant if something further is done.
Okay. But it's still
It's still
in play.
extant.
Okay.
Although to some degree this does modify the circumstances. In other words, it allows crypto, in effect, under certain circumstances, to be put in a broker-dealer.
I would think of the FAQs as opening up other paths, alternatives.
Mm-hmm. And I mean, I guess it's still so early for you guys, but is the thinking longer term to modernize that letter, or the letter could be just optionality for folks?
I think the commission is considering all options on that.
Pretty much in real time, yeah. Okay.
Look, I mean, there's 2 points. One is, I think, in the crypto space, there's obviously a lot of hunger for greater, clarity. It's clearly a priority for this commission. I thought, Commissioner Peirce's speech today was very thoughtful and laid a lot of things, frankly, in TM's lap for future consideration of how it could possibly work under a new system. So good luck with that. I do think there's also just to point that Dan and Mike were going back and forth about, what is sort of the law of the land today and considerations. We talked a little bit about it earlier in the Corp Fin panel, but just I think it's helpful for everyone to at least level set. Obviously there have been certain rule challenges. Some have been, the commission has withdrawn. Some are still in litigation. I'm going to throw one out. You don't have to be specific, or you have to respond to it. But obviously there's the dealer rule was something that was controversial for some, and the commission withdrew. How does the sort of staff think about rules that have been finalized but either have been sort of vacated or not vacated, stayed, or the commission withdrew? Do you sort of go back to what it was under the previous sort of iteration and understanding? I guess that's my question.
So as a non-lawyer, I'll make a lawyerly answer and say it depends on the rule and what has happened in court. But in that case, I think we go back to where we were.
Thanks. I think that's what most people think about. I just wanted, I think that that's beneficial for folks to hear, just especially when there was a lot of things sort of left hanging under the last sort of proposals. So it seems fair that people should come to you and ask these sort of questions just for clarification.
Thank you. I think we got within 1 minute of our deadline. So. That was the job. Well, thank you, commissioners, for joining us, and thank you all for staying on to the last panel of the day. I understand there's another session before the happy hour, but if you make it through that, I think you can pay for wine in the lobby. So, thank you all, and please come and talk to us.
So we will be on a break until 4:20, and then Corp Fin will have their workshop in here. If you are attending the exams workshop, it's directly across the hall in Salon 14.
Hello, everyone. Oh, that's a little loud. So I heard that the general disclaimer was provided this morning, but I was having some audio issues watching this from home, so I'm not. So just to be safe, we'll provide the disclaimers again. The views we express today are provided in our official capacities, but do not necessarily reflect the views of the commission, the commissioners, or members of the staff. So welcome to the CF workshop. And as a thank you for deciding to spend the last session of the day with us, some of our CF leaders will discuss recent developments that we think may be helpful to you. I am Duck Dang. I'm an associate director in Corp Fin's disclosure operations. And next to me is
Jessica Kane. I'm also an associate director in disclosure operations. Good afternoon, everyone, and welcome.
And so with that out of the way, Sarah Lowe, a deputy chief accountant in Corp Fin's office of the chief accountant, will kick us off. Sarah?
Thanks, Duck. So last year's review cycle was the first chance we had to observe implementation of the required disclosures for compliance with the clawback rule. And we also continued to receive questions on this topic throughout the year in our interactions with legal and accounting advisors and registrants alike. Last month, we published 6 new compliance and disclosure interpretations on this subject, which are focused on the requirements to the checkboxes and 402W disclosures. And these can be found in the Exchange Act forms, section 104 for 10K filings, from question 104.20 to 25. And today I'd like to share a summary of what we have memorialized in those C&DIs. Before I do so, though, I want to highlight a difference that I think helps understanding the separate disclosure requirements discussed in the new C&DIs. Although the requirements for marking the checkboxes and the requirements for the recovery analysis disclosure prescribed by item 402W of Regulation SK are related, and they're often aligned, each disclosure is triggered by specific events or circumstances as detailed in the underlying rules. The determination of whether to mark the checkboxes is based on when restatements are reflected in the financial statements in the issuer's annual report, whereas the need for disclosure in the issuer's annual reports or proxy statements about the recovery analysis is based on when issuers determined that they were required to prepare an accounting restatement. So with that in mind, Let's start with the requirements for the first checkbox. We clarified at this forum last year that the first box needs to be checked for all corrections of errors to previously issued financial statements. That includes big R's, little r's, and voluntary restatements, but not out-of-period adjustments. And this is now noted in C&DI 10420. As a reminder, the staff looks to the definition of an error in GAAP when identifying whether a change to previously issued financial statements is the correction of an error, and registrants, their advisors, and auditors should do the same. U.S. GAAP defines an error as an error in recognition, measurement, presentation, or disclosure in financial statements resulting from mathematical mistakes, mistakes in the application of GAAP, or oversight or misuse of facts that existed at the time the financial statements were prepared. If there are questions on whether something is an error correction, say, for example, a change in the prior year footnote disclosure, I recommend that companies involve their accountants in that discussion. Specific to this first checkbox, we have fielded questions regarding checkboxes in a Form 10-K subsequent to a restatement having been made. So for example, if an issuer's 2024 10-K is amended in 2025 through the filing of a 10-KA, and the issuer properly marks the boxes on the cover of that 10-KA, the issuer would not check the boxes on the cover of the subsequent 2025 10-K for the same restatement that was reported in the 2024 10-KA, and that's because they already checked the boxes. I should clarify, this assumes that there is not a new restatement that needs to be considered. However, if a restatement was reported in a filing that did not have the checkbox requirements on the cover, for example, a Form 8K or a registration statement, then we believe the cover of the subsequent 2025 Form 10-K filing should mark the checkboxes. Essentially, checking the box is the signal to investors about the restatement, and this is covered in C&DI 10424. C&DI 10425 addresses whether you would check the box, in this case we're talking about both boxes, in the annual filing subsequent to a restatement of one of the current year's quarterly periods. Here, we would not object if the checkboxes were not marked on the cover of that filing because the restatements did not impact the annual periods in the filing. I will point out this is true even if the issuer includes disclosures about the interim restatements in a footnote to the annual period financial statements. However, the disclosures required by item 402W of Regulation SK should still be provided in this scenario. Now, last year, we observed some inconsistencies on when the second checkbox was checked to indicate whether the error correction signaled with the first checkbox required a recovery analysis. A recovery analysis is always required whenever there is a required restatement, so the second box would always be checked when you have a big R or little r restatement, and it wouldn't be checked for a voluntary restatement. So you are checking the box regardless of the outcome of a recovery analysis. So this is even in situations when there is no incentive-based compensation received by an executive officer at all during the relevant time frame, or the incentive-based compensation received by the executive officers during was not based on a financial reporting measure impacted by the restatement. In both cases, the issuer is still marking the second checkbox as the determination they made about the incentive-based compensation, albeit a simple recovery analysis. It is in effect the recovery analysis for purposes of the checkbox disclosure. When you are in the scenario where the outcome of the recovery analysis results in no actual recovery, I will share two reminders. First, disclosure is still required. The rules stipulate that a brief explanation of why you reached a no recovery conclusion by applying the recovery policy must be disclosed. So the required recovery analysis disclosure needs to include more than just a statement that no recovery is required. Second, in cases where the restatement has been filed in an amended filing, the 402W2 required disclosure must appear in the next annual report or the proxy or information statement that requires disclosure pursuant to item 402. Even in the amended annual report properly included a brief explanation of why application of the recovery policy did not require recovery. Now, at the beginning of my remarks, I mentioned the determination of whether to mark the checkboxes is based on when restatements are reflected in the financial statements in the issuer's annual report, whereas the need for disclosure in the issuer's annual reports or proxy statements about their recovery analysis is based on when the issuer determined that they were required to prepare an accounting restatement. I think this is a point that is worth repeating. In CNDI 104-22 and 23, they apply these concepts to some specific timing scenarios, which I will not elaborate on here in order to make sure my wonderful colleagues do not have to cut their own remarks short. But give those a look when you have the chance. So one final thought here, I would be remiss if I did not mention that on Friday, and as discussed this morning, the Chair Atkins announced the SEC will host a roundtable on June 26 to discuss executive compensation requirements, which will include consideration of the 402 disclosures I have just mentioned. Instructions for members of the public who would like to provide their views can be found in the press release on the sec.gov website.
Great, thank you, Sarah. Next up is Justin Doby, the Office Chief for the Office of Crypto Assets. Take it away, Justin.
Thank you, Jessica. Glad to be here this afternoon. So, as I'm sure you've heard if you've been listening today, a crypto task force was formed earlier this year to help the Commission develop a comprehensive and clear regulatory framework for crypto assets. So while the task force considers that framework, Corp Fin has issued a number of staff statements on the application of the federal securities laws to crypto assets. Those statements have addressed meme coins, proof of work mining activities, stable coins, and offerings and registrations of securities in the crypto asset markets. So I'm going to spend a few minutes talking about the last one, offerings and registrations. So stepping back a little bit in time, the review program in Corp Fin started seeing filings involving crypto assets in late 2017. In the years that followed, those filings included 33 Act registration statements on S1 and F1, Regulation A offering statements on Form 1A, and Exchange Act registration statements on Form 10. In some cases, the filings involved equity or debt securities of issuers whose operations related to crypto assets or their associated network or application. In others, they related to crypto assets that were offered as part of or subject to an investment contract. So as a result of our experience reviewing these filings over the years, Corp Fin published a statement about a month ago reflecting our observations on disclosures in these type of filings under the existing disclosure requirements. So with that background, let's get into some of the specific observations that are covered in the statement. I'll start with the description of business, which is an area where the statement covers a number of crypto asset specific observations. So at a general level, the statement notes that we have observed effective business disclosure when the information is tailored to the issuer's business and to the greatest extent possible uses clear and concise language rather than overly technical terminology or industry jargon. The statement includes quite a few specific examples of business disclosures we have observed. I've picked just 2 of them to give you a sense of what we've seen. One example is disclosure about the current state and timeline for the development of the network or application to show how and when the initial development team intends to achieve network maturity or deploy their application. A second example is disclosure about the objectives of the network and how the technology of the network or application functions and accomplishes its objectives, including its architecture, software, cryptographic key management, and functionality. So in my view, these are 2 good examples of how crypto asset issuers can tailor their disclosure in the business section to provide information material to understanding the development of their product, network, or application. Okay, a second disclosure area covered by the statement is the description of securities section. It also includes quite a few disclosure examples about the terms, rights, and characteristics of the security being offered or registered. I'll mention 3 examples of specific disclosures we have observed in the description of securities section. So first, the characteristics of the security. This would include how the security or the subject crypto asset can be accessed, held, and transferred, how it can be redeemed, retired, or burned, and whether the security will be certificated or uncertificated and eligible for deposit at a securities depository. Second example are the technical requirements for holding, accessing, and transferring the security or subject crypto asset, including wallet requirements, whether senders and receivers must be on an approved list of participants, and disclosure about the network transaction fees, including who is responsible for those fees in a transfer. Third area are the tokenomics of the project. So disclosure about the rules governing the total supply of the security or subject crypto asset, whether there's a process for redeeming, retiring, freezing, or burning the security or subject crypto asset, whether any of the supply is reserved for the network's treasury or particular uses or participants, and whether any portion of the supply is subject to vesting or lockups. So those are just 3 out of many examples in this section. And because we've seen the rights, obligations, technical specifications, and tokenomics can vary from offering to offering, we hope the statement provides a range of examples of disclosures in this section. All right, beyond those 2 specific areas, there are other disclosure topics that the statement addresses. Those include risk factors, directors, executive officers, and significant employees, financial statements, and exhibits. I'm not going to go into the specifics of any of those, but I would encourage you to take a look to see our observations. The statement also includes a couple of other useful reminders. One of those reminders is that disclosure is not required where a particular disclosure requirement is not applicable, or the issuer does not have responsive information. This is a question that we get from time to time. The statement also reminds issuers to consider their own facts and circumstances when preparing their disclosure. We hope that all of the examples provided are useful, but not all of them are going to be relevant depending on your particular situation. Okay, I will finish up the same way that the statement does, which is to say that we welcome any questions you have about the application of the disclosure requirements in this space. I'd point you to the Contact Us section on the Corp Fin page on our website. It's a good resource to help connect you with the appropriate office or offices in our division. And if you're not quite sure where to go with your question, you can always reach out to me or a member of the Crypto Assets Disclosure Review team, and we'll either try to answer your question or we'll get the right people involved.
Thanks, Justin. Next up, we have Larry Spergel. He is the Office Chief for the Office of Technology. Take it away, Larry.
Thanks, Doc. So we've had accounting, and now we've had crypto, so now we're really going to get real, and we're going to talk about draft registration statements and executive compensation in Form S3. So I have the gripping portion of this presentation today. Draft registration submissions in the past were generally limited to IPOs and offerings in the first 12 months following an IPO. But on March 3rd of this year, the division began accepting DRS submissions for any type of offering, including all 34 Act registration statements. So in addition to IPOs, which would also include direct listings, we accept DRS submissions for shelf registration statements, resale registration statements, mergers, including all types of de-SPAC transactions, regardless of which entities are the issuers in the transaction, Form 1012Bs, and also Form 1012Gs, regardless of whether it's a voluntary filing or a required filing. We also accept DRS submissions for foreign filers. We have been doing so since 2012, so there's two ways you can submit that. There's an accommodation that came out in 2012, or you can use our statement on draft submissions for foreign filers. Both of them have slightly different conditions, so I just caution you, depending upon which way you go, to be mindful of the requirements for each pathway. And also our Reg A filers can also submit their Reg A offerings on DOS draft offering statements. So with this, there are some conditions that it's important to be mindful of. Some are new, but some are also conditions prior to March 3rd, but are worth noting here. For IPOs and Initial Exchange Act registration statements, multiple amendments can be made confidentially. But for non-IPOs, only the initial submission can be done confidentially. For IPOs, the initial public filing must be done at least 15 calendar days prior to any roadshow, or if there's no roadshow, 15 calendar days prior to effectiveness. That's a requirement that's actually dates back to the Jobs Act when draft registration statement submissions were first introduced. For all other registration statements, the initial public filing must be done at least 2 business days prior to effectiveness. So these are important conditions to keep in mind. But the next things that I'm going to talk about are the things that you really need to be mindful of, and are the things that, if you're not mindful of, you may have to have those difficult conversations with either the staff, but more to the point, with your client. So when you publicly file your registration statement, it's really important to remember to, quote, flip the Edgar switch for the DRS, or instruct your printer to do so that the public release of the original DRS and all DRS amendments occurs. The SEC does not publicly release DRS submissions. Issuers have that responsibility. And it's just worth noting that because there's been many instances, even dating before our expanded policy on March 3rd, where, especially in the firm commitment IPO space, companies have filed publicly and not realize that their printer has not flipped the switch and publicly filed the DRS. And then fast forward to the point where they want to go effective, they'll come in with an acceleration request to go effective in the next 48 hours. We notice on the staff that the DRS is not publicly available, and the company has to wait 15 days to go effective. Because this is a statutory requirement that dates back to the Jobs Act, we don't feel like this is something that we can waive, and even for non-EGCs, it's something, because it's derivative of a statutory requirement, it's really hard and fast time frame. So please, if you are on a firm commitment IPO and you have come in on DRS, make sure in plenty of time, 15 calendar days, that your DRS submissions have been made public. Second point is, if you are filing a repeat offering as a DRS, don't assume that if you get a no review from the staff that you can request effectiveness for a date that's less than 2 business days from when you publicly flip. Now, our statement does indicate that we will entertain reasonable requests to shorten this time frame, But when this was adopted, it was not the intended, or this policy was adopted, it was not the intention to bring all S3 filers into the realm of WIXIs, where they could do automatic shelf registrations, where they could submit confidentially, get a no review, flip publicly, and then go effective almost immediately. That wasn't the intention. And so if there is a request to shorten that date, again, we're looking for a reasonable request, and it's got to be not that they just need to get to market, because there is a certain amount of time that has to be built in for market acceptance or market knowledge of the offering. Another condition of using the expanded policy that's been around since the beginning is that the DRS submission must be substantially complete, or the staff will defer its processing of the submission, including whether we'll even review the filing or not. So if a submission comes in and it's incomplete, there's a good chance you'll receive a phone call from the staff saying you need to include this entire section before we can make a decision as to whether or not we're going to review this. Some examples of what substantially complete is not is if you're missing financial statements. Now, I say that with a caveat because there is something that comes back from the FAST Act which allows certain DRS submissions to come in with financial statements that, omitting financial statements that might be due in that submission, but when the company anticipates that it will file publicly would not be required in there. And the statutory requirement allows those financial statements to be omitted. So that's not the situation I'm talking about. But if the financial statements would be in that public filing, we will defer review until those financials are included. Now, recently, we did change our policy on this other element. Again, another example of where we would defer review is if like an entire section was left out. If there was no executive compensation information in the submission and it was required at that time, that's something where you can expect a phone call asking that the information be put in before we start our review. But something that we have changed recently to back off on and allow the initial processing of a DRS is where in a firm commitment transaction, the underwriters are not identified in that initial submission. Historically, we have deferred the review, but we have decided that at least initially when the submission is made, if the underwriters are not identified, we will begin processing and screening the registration statement. But the expectation is if it's reviewed and comments are issued and you come back in with an amended filing, or you just amend the filing on your own, even if it was a no review, that the identification of the underwriter would be made in that next amendment. The last thing I wanted to just point out on this was that if a company submits a DRS, it does not preclude the company from publicly acknowledging the submission of a DRS. Sometimes there's confusion when a company plans an IPO, submits a DRS, and then publicly discusses it. That is permitted. There's just two things that I would just caution companies on doing that is in the original release on securities reform, it makes clear that in order to take advantage of some of the communication rules that are in existence, you have to have a filing. A DRS is not considered as filing because it's submitted confidentially. So be careful about what you say and limit those communications to what is permitted. And the second thing is that if you, and there is a CDI on this, is if you do publicly discuss a confidential submission, that could hamper any effort to block a FOIA request that comes in later on. If there are any questions that relate to the DRS policy, we do have an email address that's set up, cfdraftpolicy@sec.gov, and we do monitor that, so feel free to submit any questions. And also, all of what I've just talked about and some more detail is contained on our statement that's on the Corp Fin page on the SEC website. And you can find that if you just search on the sec.gov in the search bar, enhanced accommodations for issuers submitting draft registration statements. The second thing I wanted to talk about was just a change that we've had in when executive compensation disclosure needs to be included in a Form S-3. Historically, and still to this day, after on the first day of a registrant's new fiscal year, the executive compensation disclosure needs to be updated under our rules. So for an S1, if you're a 1231 company, on January 1st, the executive compensation disclosure needs to be updated. Historically, for S3s, we have taken the position, and this was in C&DI 123.01, that the executive compensation disclosure wasn't required in the S3 for effectiveness until the filing of the 10K. And at that filing of the 10K, normally the executive compensation disclosure is not in there. So it would either have to be included in the 10K or included in the S3 rather than waiting for the annual meeting proxy statement to be filed with that executive compensation disclosure. We've changed our policy. So 123.01 has been rescinded, and now we have expanded C&DIs 114.05 and 198.05 to not only include automatic shelf registration statements on S3, but all S3 registration statements. So what that means is that come the time of the filing of the 10K, a company could go effective on an S3 even though their executive compensation disclosure is not in that S3. But the CD&Is do make clear, though, that if that it's on the registrant to ensure that they have a valid 10A prospectus under the Securities Act and Schedule A. That's not, the SEC won't be involved in that. That is really on the issuer to make sure that at the time of use, they have a valid 10A prospectus. That's it.
Thanks so much, Larry. Next up, we're going to hear from Jeb Byrne, the Office Chief for the Office of Small Business Policy.
Thanks, Jessica. I'm excited to be here to speak to you all today. So today I'm going to talk about some recent guidance that the Division of Corporation Finance put out on Rule 506C of Regulation D, specifically the reasonable steps to verify requirement in that rule. So in mid-March, the division published a no action letter in response to a letter from Latham & Watkins. The letter addressed the use of high minimum investment amounts in the context of verifying accredited investor statuses under Rule 506C. Specifically, Latham's letter sketched out a fact pattern where they believed an issuer will have taken reasonable steps to verify the accredited investor status of purchasers. The specific facts presented in the letter are, first, a natural person purchaser agrees to make a $200,000 minimum investment, or an entity purchaser agrees to make a $1 million minimum investment. Second, the issuer obtains written representations from purchasers that the purchaser is an accredited investor under one of the prongs of the definition for individuals or entities that is based on income, net worth, total assets, investments, or assets under management. Third, the issuer obtains written representations from purchasers that the purchaser's minimum investment amount is not financed in whole or in part by any third party for the specific purpose of making the particular investment in the issuer. And fourth, the issuer must have no actual knowledge of any facts that indicate that any purchaser is not an accredited investor or that the minimum investment amount of any purchaser is financed in whole or in part by any third party for the specific purpose of making the particular investment in the issuer. There's also a fact pattern laid out in the letter for entities who qualify under Rule 501A8 as accredited investors because all of their equity owners are accredited investors. That portion involves a multi-layered analysis of both the purchaser at question and its equity owners, so it's a bit difficult to go through in a situation like this. But if you're in that situation, I'd recommend taking a look at the letter itself to understand the specific requirements. In response to the letter, the division agreed that a high minimum investment amount is a relevant factor in verifying accredited investor status. Specifically, the division's response letter quotes the Commission in the 2013 506C release that, quote, if the terms of the offering require a high minimum investment amount and a purchaser is able to meet those terms, then the likelihood of that purchaser satisfying the definition of accredited investor may be sufficiently high that, absent any facts that indicate that the purchaser is not an accredited investor, it may be reasonable for the issuer to take fewer steps to verify or, in certain cases, no additional steps to verify accredited investor status other than to confirm that the purchaser's cash investment is not being financed by a third party. The no action letter from the division then notes the specific facts laid out in the Latham letter and states that whether an issuer has taken reasonable steps to verify that a purchaser is an accredited investor is an objective determination by the issuer in the context of the particular facts and circumstances of each purchaser and transaction. There are a few points in Latham's fact pattern in our no action letter that I'd like to highlight. First, this no action letter does not create a new method of verification under Rule 506C. It is an interpretation of the principles-based method of verification, which has been the core of Rule 506C since the Commission adopted the rule in 2013. As both the Latham letter and the no action letter quote, at a high level, this fact pattern was already sketched out by the Commission in 2013. The purpose of this letter and the C&DIs, which I'll talk about in a moment, are not to invite the bar or others to send in a myriad of new suggested ways to verify investors under Rule 506C. While we always welcome people reaching out for guidance, and you should feel free to reach out to my office if you'd like to speak, this letter and the C&DIs are meant to serve as a reminder to the bar that whether and how an issuer has taken reasonable steps to verify is a facts and circumstances legal determination that can and should be made by issuers and their counsel. I'd also like, as a reminder, to note there is and never was a requirement, there is not and there never was a requirement to rely on the specific non-exclusive, non-mandatory methods laid out in Rule 506C. And then finally, the reasonableness determination is a similar analysis to what has been done for almost 45 years under Rule 506B's reasonable basis standard. And in some cases, as the Commission has stated, the two analyses may not be substantially different. Second point I want to emphasize in the letter is the no knowledge portion of the letter. The Latham letter does not say that the issuer must have no actual knowledge that the investor is not an accredited investor or financed the investment, but rather that the issuer must have no actual knowledge of any facts that indicate that the investor is not an accredited investor or financed the investment. Some of the commentary I've seen on the letter glosses over or is just plain wrong about this point, so I want to make sure it's clear. As with any reasonableness determination, the issuer can't just plug its ears and ignore facts that indicate there may be issues. Finally, on the requirement that the investor did not finance the investment in whole or in part by any third party, I'd like to flag some of the language in a footnote in the Latham letter. That footnote, footnote 4, states that for purposes of making the representation about the investment being financed, the purchaser would not be precluded from providing the necessary representation that its minimum investment amount is not financed in whole or in part by any third party for the specific purpose of making the particular investment in the issuer if the purchaser obtains capital through one or more, 1, financing programs, including a secured credit facility that has other purposes than solely making the particular investment in the issuer, 2, binding commitments or financing to the purchaser that predate the commencement of the offering under Rule 506C, and or 3, financing transactions conducted by the purchaser in which the purchaser as an issuer has satisfied the conditions applicable to an issuer under the Latham letter. The first point just recognizes that money is fungible, and often people and companies have financing arrangements that could be seen as indirectly financing the investment. However, this language does not allow someone to take out a loan to finance their minimum investment amount, as they cannot have the financing program that has the purpose of solely making the particular investment in the issuer. The second point recognizes situations where an investor has already secured commitments and financings before the Rule 506C offering at issue has commenced. The easiest fact pattern to envision here is when a fund already has investors with capital commitments, and then that fund is itself an investor in a new Rule 506C offering. The third point, again, deals with entities under Rule 501A8 who are accredited because all of their equity owners are accredited investors. As I noted earlier, if you're in that situation or wondering about that fact pattern, I'd recommend looking at the letter itself because, again, that's a multi-level analysis. It's important to keep in the background that all of these facts need to be considered in the context of the reasonableness determination. Notwithstanding the language in the footnote or elsewhere in the letters, an issuer should think hard about asking more questions or getting more information from an investor if they learn of any financing or any other facts that indicate the purchaser is not an accredited investor or financed their investment. That includes considering the requirements of the specific prong of the accredited investor definition that the investor represents as applicable to them. I'd also like to briefly touch on 2 CNDIs that the division put out at the same time as the no action letter. The first is new Securities Act Rule CNDI 256.35. This CNDI underscores the principle-based nature of the reasonable steps to verify requirement. It includes quotations from the 2013 and 2020 releases that adopted and amended Rule 506C, and specifically flags factors that the Commission stated issuers should consider when making the facts and circumstances analysis. These factors include the nature of the purchaser and the type of accredited investor that the purchaser claims to be, the amount and type of information that the issuer has about the purchaser, and the nature of the offering, such as the manner in which the purchaser was solicited to participate in the offering, and the terms of the offering, such as a minimum investment amount. The second CNDI is new Securities Act Rule CNDI 256.36. It includes a more general question about high minimum investment amounts and the interplay of them with Rule 506C's verification requirement. That CNDI points to both the 2013 quote that I read earlier regarding high minimum investment amounts and also the no action letter. Finally, I'd just like to briefly flag that we also updated a number of other small business and exempt offering related CNDIs on March 12th when we published those 2 new CNDIs in the no action letter. These updates are all meant to reflect changes to the small business regulations that have occurred in the last 10 years or so. And there shouldn't be anything surprising or new there to you. They're all technical changes, but I just wanted to flag that those changes happened in case you wanted to take a look and update any guidance or references you had to the old or now removed CNDIs. Thank you.
Thanks, Jeb. I think earlier Larry used the term gripping. So as someone who used to work in-house and had to deal with Edgar codes and passkeys, the next topic is one that I actually find very gripping. So next up is Robert Ehret, the Office Chief for the Office of the Office Chief for the Disclosure Management Office.
Good afternoon, everybody. Before I continue on into my talking points, I'm just going to give a quick introduction to the Disclosure Management Office, because for some of you, this may be the first time you've actually heard about the office. And so we actually have 3 responsibilities for the Disclosure Review Program and the division. The first is we help oversee certain operational and strategic initiatives and functions, particularly for the DRP. So for instance, when a final rule is adopted, we'll be the office that helps coordinate all the actions that are necessary internally to make sure that the Disclosure Review Program is ready to go around the compliance state. Second, we're responsible for curating internal Disclosure Review Program guidance and procedures. And third, we serve as the EDGAR liaison for rulemakings and filings. In that role, we'll be the ones that address filing process issues and corrections in partnership with the EDGAR Business Office. And then we'll also be the ones that help define functional requirements for changes to EDGAR that might be necessary, again, because of a rulemaking change or a business process change. So with that in mind, here to talk about 2 points. One is just a little bit on EDGAR next, and the second one will be about structured filing fees. So as many of you probably know, the Commission adopted a rule in September 2024 for rule and form amendments to enhance the security of EDGAR and improve filers' access and account management capabilities. So a few of those changes involved requiring individual account credentials and the completion of multi-factor authentication in order to access EDGAR, and that's a change from the current process where the registrant itself has those account credentials, and if you have access to those account credentials, you can make filings on their behalf. Now, multi-factor authentication is a very common security practice in use today. And the benefit of individual account credentials is the fact that the SEC and filers are going to be able to identify the individuals that have made a submission or filing on a filer's behalf. Now with that, filers are going to need to authorize specific individuals to manage their accounts, and they'll also be able to delegate the ability to file to filing agents. And finally, of note, I think, is the optional application programming interfaces, or APIs, that are now available. And these are designed to make it easier for filers to submit filings and submissions, retrieve information, and manage their accounts. The benefit of those the application programming interfaces is that they're a secure machine-to-machine connection with EDGAR. So let me talk for a second just about the enrollment and where we're at in the transition phase. So March 2025, the enrollment period opened and a new Edgar Filer Management website was launched. The new website includes a dashboard, and this is where prospective filers can now submit the new Form ID application, existing filers can enroll, and enrolled filers can manage their Edgar accounts. And so in order to access the dashboard, this is where you need those individual account credentials that will be created through login.gov, and then complete that multi-factor authentication process. Now, enrollment is a streamlined process available to existing filers. That means that they do not need to provide a Form ID application or present notarized documents or a power of attorney to SEC staff. It is important to note that all existing filers do need to enroll or should enroll in Edgar Next, regardless of whether they're using a filing agent or third-party service provider. And once enrolled, they're going to have access to those optional APIs I mentioned just a moment ago, where they'll be able to make filings and retrieve information and manage their accounts. Even after enrollment, the Edgar legacy filing websites will remain available through September 12th of 2025. And for those that had their Form ID granted on or after March 24th of 2025, they're already enrolled in Edgar Next, and they do not need to take any additional actions to enroll. So let's talk about the compliance date. That's September 15th of this year. That at that point, all the legacy Edgar filing websites will no longer be available, and that's when filers will need to use the new individual account credentials and multi-factor authentication process to access Edgar. Now, filers who have not enrolled by September 15th will not be able to file until they do enroll. So to avoid an interruption in the ability to file on Edgar, filers really should enroll prior to the compliance date of September 15th. Now, even after September 15th, all the way to December 19th, the streamlined enrollment process will remain available, where filers that need to enroll can do so through that streamlined process. Just a few final points on Edgar Next. Just again, I'll say it probably for the third time because of the importance of it, is just to avoid filing interruptions, please, filers should enroll as early as possible. With respect to the new Form ID process, do recommend that anyone that needs to submit a Form ID application, be it a prospective filer or perhaps a filer that's lost their Edgar account credentials, to submit the Form ID as soon as possible, because right now it's taking 6+ business days in order to process those applications. And finally, individual account credentials are just that, just a reminder that those should remain individual account credentials and not be shared with others. There is lots more information available on the Edgar Next page on sec.gov. There's information sheets, videos, webinars, FAQs. There's also an Edgar Filer Management beta site so that filers can become more familiar with the dashboard. And finally, the Edgar Business Office is available to help with the transition. I do recommend you contact them by email at edgarnextbeta@sec.gov. Again, that's edgarnextbeta, all one word, at sec.gov. And of course, to the extent necessary, they'll reach out to our office for assistance with any Corp Fin specific issues. In just the few minutes I have left, I'm just going to cover just a few points on structured filing fees. Structured filing fees was a requirement or a rule adopted by the Commission in October of 2021. And that really was, the focus of that was to modernize filing fee disclosures and payment methods. And with that, most fee-bearing form schedule statements and related rules were revised to require each fee or filing fee table and accompanying disclosure to include all required information for fee calculation in a structured format, and that structured format is in inline XBRL. Now, last July, large accelerated filers had to comply with that new structured filing fee requirement, and staff have been monitoring compliance with that, with those requirements and those the structured filing fee requirements. Now, since last July, there have been approximately 30,000 filings with the structured filing fee data included. And so far, we've identified approximately 600 filings that did not include their structured filing fee data. And the final point that I want to make here, and a reason I raise this, is the compliance date for accelerated filers and all other filers is coming soon. That's July 31st of 2025. And of course, staff will continue to monitor compliance with the filing fee requirements. Thank you.
Thanks very much, Robert. And last but never least, Tiffany Posel, our closer from the Office of Mergers and Acquisitions. Tiffany is the office chief. Take it away.
Thanks, Jessica. So similar to each of the offices you've already heard from on this panel, the Office of Mergers and Acquisitions has been very busy this year. In addition to conducting our normal filing review program and also handling requests for no action and exemptive relief, we have, since just the beginning of this year, published new and revised interpretive guidance, primarily in 4 areas, including with respect to notices of exempt solicitation, Schedule 13 DG obligations in the context of shareholder engagement, the use of lockup agreements and written consents in Rule 145A transactions, and material changes in the context of tender offers. Much of this new guidance is the result of our continuing efforts to engage with various stakeholders, and it's also a great example of how that engagement really is critical to our understanding of the issues that companies and investors are facing, and also how we can help clarify the application of our rules for all stakeholders. The new interpretive guidance on notices of exempt solicitation and Schedule 13 DG obligations was addressed on an earlier panel and also in commissioner remarks. So for this panel, I'll just focus on the new guidance related to material changes in the context of tender offers and the revised guidance on the use of lockup agreements and consents. So in March, we published 5 new compliance and disclosure interpretations, or CDIs, which reflect the staff's current views on material changes to tender offers related to financing and funding conditions. By way of background, the tender offer rules require that when there is a material change in the information that is published, sent, or given to security holders, that material change must be promptly disclosed and disseminated in a manner reasonably designed to inform shareholders of that change. And embedded in this requirement is that disclosure of the material change must be disseminated with sufficient time for shareholders to consider that information and factor it into the decision whether to tender their shares, withdraw their shares that they already tendered, sell into the market, or otherwise hold their shares. While the tender offer rules prescribe the number of days that must remain in the offer following a change in price or amount of securities, the rules do not prescribe the number of days that must remain in the offer following other material changes, except in the case of registered exchange offers. And there, the rules require 10 business days for changes in price or amount of security sought or similarly significant changes, and 5 business days for material changes other than price or share levels. So as a result, for cash tender offers, practitioners generally look to statements and commission releases in the time required in registered exchange offers for guidance on how many days must remain in the offer period following material changes that don't involve price or share levels. So the first of the 5 new CDIs we published in March focuses on one of these commission statements, and it confirms that an all-cash tender offer does not always have to remain open for at least 5 business days after disclosure of a material change that doesn't involve price or percentage of securities sought. While the Commission stated in a 1987 release that the offer should remain open for a minimum of 5 business days as a general rule, the new guidance acknowledges that a shorter time period may be adequate if disclosure and dissemination of the material change allows shareholders sufficient time to consider such information and factor it into their investment or tender decision. What is sufficient time will depend, not surprisingly, on the facts and circumstances, as well as the relative materiality of that change. The next 3 CDIs in that series of 5 I mentioned are really building blocks for the 5th new CDI. So the second new CDI confirms that the staff views the change from an unfinanced tender offer or partly financed tender offer to a fully financed tender offer as a material change. And by unfinanced tender offer, I mean where the offeror commences the offer without sufficient funds or committed financing to purchase all securities sought in the offer. We confirmed in the third new CDI that a tender offer is considered fully financed if the offeror has obtained a binding commitment letter from a lender to provide the funds necessary to purchase all the securities sought in the offer. So if an offeror commences an unfinanced tender offer and then subsequently secures committed financing needed to purchase all securities sought in the offer, that is a material change, which, as I just discussed, requires the offeror to promptly disclose and disseminate the material change to shareholders in a manner that reasonably informs them of that change. Accordingly, if that change from unfinanced to fully financed occurs near or at the end of the tender offer period, the offeror must ensure that sufficient time remains in the offer period to allow for adequate dissemination, which may require extending the offer. The fourth new CDI in that series of 5 confirms that the substitution of a funding source or available cash in a fully financed tender offer is not considered a material change, so long as the offer materials disclose the possibility that the offeror would use an alternative source of funds. So if an offeror commences a tender offer, and at the time of commencement, they disclose in their offer to purchase that it has obtained a binding commitment letter from a lender to provide sufficient funds necessary to purchase all securities, and then it also discloses the possibility that it may use an alternative source of funding to purchase the securities. If prior to expiration, the offeror decides to purchase the security sought in the offer by using that alternative source of funds, such as available cash or through committed financing from a different lender, the alternative source is sufficient to purchase all securities, then that change is not considered a material change. And then we arrive at the fifth and final new CDI in that series of 5. And this is probably the most significant of the 5, if you will. It updates the staff's prior informal guidance on this topic, and it confirms that the receipt of funds in a fully financed tender offer, subject to a funding condition, would not constitute a material change in the information given to shareholders. So if an offeror commences an all-cash tender offer and discloses in its offer to purchase that it has obtained a binding commitment letter from a lender to provide the funds necessary to purchase all securities, and then notwithstanding that binding commitment letter, it conditions its purchase of tendered securities on the actual receipt of funds from the lender by the offer's expiration, which is also referred to as a funding condition. This new CDI sets forth the staff's current view that when the offeror has that binding commitment letter from a lender and receives the expected funds, then no material change in the information given to shareholders has occurred, because there the lender has simply satisfied the funding condition by fulfilling its contractual obligation. These new CDIs are intended to provide market participants with greater clarity about the staff's views, and based on engagement with various stakeholders, we expect they will reduce unnecessary cost in certain tender offers. So now I'll move on to the revised interpretive guidance we issued in March on the use of lockup agreements and written consents in Rule 145A transactions. As many of you are aware, acquiring companies commonly seek voting commitments or lockup agreements in support of public M&A transactions from the target company insiders before the transaction is announced or a proxy statement is filed for that transaction. And in the context of stock-for-stock mergers, acquirers must consider whether these voting commitments or consents constitute investment decisions under the Securities Act. And that impacts the ability of the acquirer to register the offer and sale of the securities to be issued as part of that transaction. The staff's prior guidance indicated that if target company insiders entering into lockups also delivered consents approving the transaction before the registration statement was filed, the staff would object to the subsequent registration of the issuance of the acquiring company's securities for any of the target shareholders. And this objection was based on the rationale that offers and sales had already been made and completed privately, and once begun privately, the transaction must end privately. Effectively, the view is that the approval of the consents of the transaction by consent involved a private offering, which then precluded the acquirer from later registering the offering of securities on the S-4. In response to a number of questions regarding the application of the staff's prior guidance to specific situations involving written consent, we updated the staff's views on the use of lockup agreements and written consents in Rule 145A transactions in a revised CDI. Specifically, the staff will not object to the subsequent registration of the acquiring company's securities where target management and principal shareholders that enter into lockups also deliver written consents approving the transaction, so long as those insiders only receive securities of the acquiring company pursuant to a valid exemption, private placement exemption. That is, they can't receive securities of the acquiring company that are registered on a Form S-4. And second, the acquiring company's securities registered on Form S-4 will be offered and sold only to target shareholders who did not deliver a written consent approving the transaction. This updated guidance effectively allows stock-for-stock mergers and similar transactions to proceed with a combination of exempt offerings for the insiders who provide consents and registered offerings for other shareholders. And with that, I'll turn it back over to Duck and Jessica. Thank you.
Great, thank you, Tiffany. I'm looking at Grace. I see that we are at time. So I'm just going to give you a few thank yous to wrap up for today. First, thank you to all the panelists for these very informative presentations. We really appreciate it. I also want to recognize and thank the incredible staff of the Division of Corporation Finance for their dedication, their professionalism, and the incredible work that they do every day to meet mission. And thank you all for attending. See you at happy hour.
Just right quick, a little housekeeping. First of all, for anybody on the webcast who missed the chairman's remarks or had trouble accessing that, or the Corp Fin panel, both have been posted on the live stream page, which you can access from the website. Just click through and you can watch both of those if you want to catch up. For those in the room, be sure to check out so that you get all your credits for today. Big thank you to everybody who participated today and our last panel for closing us out. And we'll see everybody tomorrow at 8:45. Thanks so much.